Good evening, and welcome to the monthly meeting of the Arlington Board of Zoning Appeals, also known as the BZA. I'm Judy Freshman, Chairman of the Board. The Board's made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Charles Smith, Inta Malis, Paul Melnick, and Peter Owen. Also present is the professional staff, including Liliana Rios, Acting Board of Zoning Appeals Secretary, Arlova Vaughn, Zoning Administrator, Cliff Hogan, Assistant to the Zoning Administrator, Simon Keynes, Administrative Technician, and Min Shao Kaur, Assistant County Attorney. We thank you for being here and extend you a warm welcome. To avoid disruptions, we ask that you please turn your cell phones or pagers off or put them in silent mode. On the front table, you'll find copies of the staff report for each case before us this evening. I recommend that if you've not yet seen that report for your case, that you get a copy and review it before your case is called. The Board's powers are prescribed in the Code of Virginia and are set out in further detail in the county's zoning ordinance adopted by the County Board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the ordinance. That authority rests with the County Board. This board does have the authority to do 3 things. We can approve use permits that allow modifications of placement requirements for structures on 1 and 2 family lots where there's no option in the zoning ordinance to allow such modifications. We can grant variances from the special requirements of the zoning ordinance, and we can decide appeals of decisions of the zoning administrator. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary in the public interest, including limiting the duration of the use permit. In order to approve a use permit, the law requires that the Board find that the proposal meets conditions and that the use permit will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purpose of the master plans and land use and zoning related policies of the county. To do this, the BZA shall consider whether the modification will promote compatibility of development with the surrounding neighborhood, because the structure's overall footprint size and placement are similar to the structures on the property surrounding the lot in question, and whether the modification will help preserve natural landform, historic features, and/or significant trees and foliage. When granting variances, the Board must determine that the strict application of the ordinance would unreasonably restrict the utilization of the property, or that the granting of the variance would alleviate a hardship due to a physical condition relating to the property or improvements thereon, that the hardship is not generally shared by other properties in the same zoning district, and that the authorization of the variance will not be of substantial detriment to adjacent property, and the character of the district will not be changed by the granting of the variance. A Virginia Supreme Court ruling requires that a variance cannot be granted unless the effect of the zoning ordinance, as applied to the piece of property under consideration, would, in the absence of a variance, interfere with all reasonable beneficial uses of the property, taken as a whole. When deciding appeals of the zoning administrator, the Board must determine if the administrator acted correctly. This evening, cases will be called, and a brief staff report and recommendation will be given. Following that, Board members will ask any questions of the staff they may have. Next, applicants or their representative will be given an opportunity to make comments to support the application or appeal. If they choose to make a comment, they must come forward to the podium so their comments can be recorded for the record. Next, all speakers for the item will be called. Speakers must fill out a speaker slip, which is available on the table in the front of the room. After we hear from speakers for and against the proposal, the Board may permit the applicant a brief opportunity to clarify any points. The Board may ask questions of any speakers, but does not permit and will not condone any cross-examination or direct questioning by others. We have deemed the following time limits for speakers to be sufficient: 20 minutes for applicants of appeals, 5 minutes for applicants for use permits and variances. For use permits, variances, and appeals, we've deemed 3 minutes for representatives of organizations and 2 minutes for individuals as sufficient. After the board has gathered all the information they need and discussed the case, it will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you're welcome to stay for the balance of the session or leave at your convenience. Again, thank you for being here this evening. Please call the first case.
For case V-11260-17-APP-1 is an appeal by Cellco Partnership doing business as Verizon Wireless of the zoning administrator's determination regarding height restrictions for cellular radio towers at the premises known as 308 North Kensington Street in the R6 zoning district. I just have a short statement.
Please.
The original request filed in April 2016 was for a use permit to establish a 115-foot tall monopole, and that proposal was in excess of the maximum permitted district height in the R6 zoning district. Planning staff who received the application communicated this to the applicant, explaining the issues with the proposed height, given the district height allowances and those for certain exceptions to height, and that the county board cannot modify height as part of the use permit request. To this date, the request has not been heard by the board, updated, or formally withdrawn. In November of 2016, the applicant requested a determination of Arlington County Zoning Ordinance Section 3161B with regard to its application to a monopole request 115 feet in height in an R6 zoning district. The determination request included several examples of existing monopoles with varying heights that would appear to exceed maximum district heights. In responding to the determination request, staff researched the examples provided. However, given the age of these facilities, we were unable to find comprehensive records providing an analysis of the proposed height, a rationale for their approval, or any mention of an exemption from district height for these structures. Therefore, staff cannot determine with certainty if the approvals were based on the assumption that district heights did not apply to these structures, if the approvals were if they were in response to some other previous county policy, or if they were simply approved in error. Nonetheless, staff has found that in the requests made in the past several years, since 2008, the approach to structures of this height is consistent with that expressed in the determination currently subject to appeal. This approach applies the maximum district height for the subject zoning district plus an additional 23 feet per the provisions of Section 316B1 for those structures specifically enumerated and those found to be similar to them. The staff report provides examples of how this interpretation has been applied to telecommunications facilities as well as other structures over the past several years, and is explained in the associated county board staff reports. Therefore, I ask that you find I acted correctly and uphold my decision to apply the height exceptions found in Arlington County Zoning Ordinance Section 316B1 to a proposed monopole.
Thank you. Questions for staff? We hear from Mr. Stearns for the applicant.
Madam Chair.
Mr. Owen.
I sent an email to the acting secretary last night, and I wanted to know if that email made it out to the parties. Does either party have, is it the zoning administrator or the applicant get an email forwarded from me?
No, Mr. Owen.
And what about the zoning
I got it.
You got it? Probably be best to share that with the other party.
Okay.
Possible tonight. Thanks.
Mr. Stern.
Good evening, Madam Chairman, members of the board. My name is Frank Stearns. I'm an attorney representing Verizon Wireless. What we're here today is to ask for the overturning of the determination that kept us from filing the special use permit. And I've been doing this a number of years, and I filed a number of special use permits in Arlington, and I would never have one refuse to be accepted. And the reason it was refused to be accepted was because they said we did not comply with the height limit. But for the years that I've been doing it, the height limit was always interpreted to not apply to cellular telephone towers. That height control is through the special use permit. We are not allowed in any zone in Arlington County without approval of a special use permit. At that time, we have to show the need and that the height we're choosing is the minimum height necessary to satisfy that need and also to provide co-location. That's set forth in the telecommunications guidelines. So the height can't really be determined on the site on the general basis. It has to be determined on the site-by-site basis. That's why it's done through the special use process. I think the zoning administrator, when she reads the section 3.1.6, she adds words that aren't there, and she misconstrues the purpose of the way the statute or the ordinance is laid out. Quite clearly, the 23 feet concerns mechanical penthouses on rooftop buildings. They can't be more than 23 feet high. The words height limit aren't in that particular sentence. Mechanical penthouses and mechanical roof structures are both in the sentences before and after that particular one sentence, and that's because that's what the 23 feet relates to. And that just makes common sense. And that's the way other zoning administrators have approached it. Because, as you know, we put some cellular sites on rooftops, and they have equipment buildings. And when we talk to the zoning administrator, the question is the height of the equipment building, not the height of the antenna. The height of the equipment building cannot be more than 23 feet above the roof, not the height limit for the district above the roof. For instance, if you're in an industrial zone where the allowable height is 75 feet, and you have a 40-foot building, under the zoning administrator's interpretation, you're allowed 23 additional feet above 75 feet for your mechanical penthouse. That would be a 58-foot high mechanical penthouse. The board didn't want that. The board says no more than 23 feet above the roof line. And that's why that 23 feet applies only to mechanical penthouses. And that follows through because you can see then the other items identified in paragraph 1, non-commercial radio towers, no more than 25 feet, not 23, 25. Number 3 is chimneys and smokestacks. They're only allowed 27 feet above the height limit. The county government schools and public communication facilities, you know, the sports lighting, et cetera, no more than 50 feet. But none of those are 23 feet, but yet they're all in the preceding sentence where our towers are located, and the zoning administrator says that 23 feet applies to it. Well, if that's the case, then why do they have all these other sections with different height limits? And the zoning administrator explains that as saying, well, that's just surpluses, that's just additional. Well, that's not the way statutes are to be interpreted. Each word is to be given its meaning, and it's to be read in conjunction one with another so that it makes sense. And I submit that the 23 feet makes sense when it's applied to mechanical penthouses, but not to any of the other structures listed in paragraph 1. You have to give meaning and purpose to each of those words. I think that the zoning administrator has mischaracterized our appeal when she says that we are really asking for an excuse to be excused from the height limit. We're not asking to be excused from the height limit. We recognize we're going to have a height limit on it, but that's going to be set at the special use permit review time, and it's not set in the general bulk regulations like it is with most other such structures of buildings, et cetera. Most jurisdictions recognize this. I mean, most jurisdictions you'll see, for instance, in Alexandria, the city administrator is charged with approving the height, and he's given certain guidelines to approve the height, but there's no set number because, as I said, you can't have a set number that's generally applicable to the whole county because it depends on topography, it depends on the other network situation, it depends on a whole host of things, the area you're to cover, how high that's to be, and all that has to be established through the special use permit. In support of the position, the zoning administrator has cited several cases in your packet. All but 2 of those cases didn't involve a height exemption. All but 2 of those cases, the height was applied for and it was within the height limit that the zoning administrator felt was appropriate. so there was no reason to contest it. They had the height that they wanted. But two of those, that wasn't the case. One of them involved Wakefield High School, where Sprint tried to locate on an existing telecommunications facility that was above 23 feet above the height limit, and was approved back in early 2000. And it was approved under a correct reading of the ordinance. And yet Sprint decided not to pursue that particular site when they went in there to replace that pole with a slightly taller one. Now, that was in 2014. Curiously now, a federal law would say they couldn't deny that. They would have to grant that. But that wasn't the case in 2014. But the point was that it proves my argument that before it was interpreted that 23 feet did not apply to towers. It applied to mechanical penthouses. And because Sprint didn't choose to pursue it, doesn't mean that that was established. That just means it just wasn't pursued. They should have, but they didn't. Then the second reason, or the second citing that she gives, where it did involve the height exemption, was on the steeple, a church steeple, with telecommunications facilities in it. And it was very interesting. Melinda Artman, who I've dealt with on many occasions, wrote an opinion letter, determination, and it's very interesting that, excuse me, I need glasses here, that what she says in there that is that, let me find that. In her letter, she specifically says this cannot be relied upon for future determinations. I found it now. This is the letter of November 16th, 2010, and I'm not sure why she said this, but obviously she didn't have much faith in this opinion, because she says this determination applies solely to the reference property, the church steeple, and is not binding upon the county, the zoning administrator, or any other official with respect to any other property. And clearly we're dealing with another property here. No person may rely upon this determination with respect to any property other than the reference property. Those are Mrs. Artman's words. And she submits this to say, rely on this to say that my interpretation is correct. So she's violating the very terms of this determination. So in short, or in summary, we are not asking for an approval of this site. We're just asking for the right to be able to come forward and ask for approval of the site, the process that was a process for many, many years in this county. And as far as I know, it's worked very well. I've cited some non-pole sites there. Old Glebe Road Military, that's 110 feet. The one at Army-Navy Country Club is 60 feet, which is 2 feet higher than would be the allowable height. But the height issue was raised in that particular case and was found to be exempt. And then there's church steeples. A number of those are well above the height limit, but those two were singled out by the board in that particular section. And just in final, I mean, the preponderance of the evidence is that the interpretation was the correct one previous to this. The only evidence that this particular interpretation is valid is based upon one case where it was withdrawn and another case where the person who made the determination says, don't rely on this for any other site. So there's really no support for that determination. And I really wonder, what was the cause for switching the determination? What was the reason? There was no board action or anything to that effect that would say this needs to be amended. So, and the interesting thing is that language is now found in a different section of the code than it was before 2008. And it goes back to 1987. This language has been in the code for, well over 30 years. And just up until the last couple years has it been interpreted any differently. So I would say the interpretation is plainly wrong. I'm sure it was made in good faith. I don't mean to cast any dispersions, but it was plainly wrong, and there's not a preponderance, and there is a preponderance of evidence to say that the previous one was the correct one, the one the board wanted made, because it heard a number of special use permits with that height limit well above the 23 feet, and that, in all candor, that we should be allowed to file this application and take it through the process as we have many times before.
Thank you. Questions? Or Mr. Stern? Yeah. Ms. Malice?
Is it your position that the Arlington County zoning ordinance has no maximum height limits for cell phone towers?
In terms of a specific number, it does in the sense that in going through a special use permit,
No, but that the ordinance itself establishes no maximum.
it does not set out a specific number, no.
Yeah, thank you.
Mr. Malnick?
So when I read the statute, and I understand what you're saying. I've heard your arguments, but the way it appears to me is that there's in paragraph 1, there's more of a general rule. It has a list, and then it has not exceed 23 feet. Then it has a sentence about the penthouses, but then it seems that it's getting more specific. So each other paragraph, they're picking out different circumstances and different things that are mentioned previously and increasing it from 23 feet. So it's going from a general rule to more specific rules on specific circumstances and increasing the feet for each thing as applicable. So how can we not read it like that? Like this is a general rule and there's not a carve out for the towers that you're talking about.
Well, because there's not a carve-out, the carve-out is for the mechanical penthouses. That's what the carve-out is for. And then the other 4 or 5 enumerated items. As I say, if you read it without the height limit, if the county wanted to do what you're suggesting, they would have said that mechanical penthouses, fire parapet walls, skylights, radio towers, steeples, flagpoles, chimneys, smokestacks, or similar structures may be erected up to 23 feet above the height limit. That's what they would have said. Mm-hmm. Why would they go and carve out mechanical penthouses on both sides of that 23 feet sentence for specific treatment if it wasn't meant to apply only to them?
Well, they did say such. And such usually reflects back. I would reflect it back to everything mentioned in the previous sentence. But, you'd think they would have been, if they intended it, they'd be more specific. Instead of using such, they would have named the structures.
Well, I think they just meant the 2 structures mentioned before it, mechanical penthouses and rooftop structures. Mm-hmm. That's what it meant to modify.
Okay, thank you.
Like I say, if you read it the other way, then you get this anomaly where you could have a 58-foot high mechanical penthouse.
Other comments? Mr. Smith?
I hear you, Mr. Melnick, but I see that second sentence only referring to those 2 specific structures. When it says such structures, they're talking about those specific 2, mechanical penthouse or roof structure or any space above the height limit shall be allowed for the purpose of providing such structures, just those 2, the mechanical penthouse or a roof structure. And the mechanical shall be concealed, that's really what I think it's talking about. I have a question for the applicant with respect to the preemption, the federal regulation. Help me. I think it deals with, part of what it deals with is the need for cell service to be utilized with a 911 service. And is that partly correct?
They're trying to expedite deployment of the service.
So there's capture area, there's coverage when police and fire need to respond, and for people with cell phones to be able to call for emergency services.
Well, very much so. And a lot of people now have medical devices that are wirelessly operated that connect to hospitals and doctors. I mean, they want all that to work. And I mean, this is all we would be putting forward in our special exception application if we would just be given the opportunity to file it. That's all we're asking for.
And one last, I think maybe Mr. Owen will ask this question because it was one that he circulated earlier amongst us and staff, and that has to do with if you weren't granted, I was flummoxed by the idea that you weren't allowed to make the application for the special use permit and have them say, oh no, this is the wrong process. But what would be your remedy if if you aren't allowed to even apply to make the argument for height. And if this board said, yes, the zoning administrator is right.
We wouldn't be able to file. I've learned over the years that if they cannot build what works, they're not going to build something that doesn't work. And it's a lot of money. They're not going to put a lot of money into something that is 50%, 30% of quality. So they just won't build it.
Mr. Owen?
So I have a number of questions, and now you have a written copy of them. I regret that you don't even have a moment or two before you begin to speak to see that document. So if there's a later point in our meeting where you have a minute or two to read it over and something occurs to you to say, I'd be happy to call on you very briefly. But let me address some of them now. Following up on Mr. Smith's question, you indicate, let me find this here. You reference Title 47 USC 332C7B12, the National Wireless Telecommunications Siting Policy. And I thought I had brought a copy, but when I read that section earlier this week, it seemed to suggest that localities may not prohibit cell service. It didn't say that they can't have any regulation of cell service. That's literally on its terms.
That's correct.
Can you explain what you think that means in practice? Do you think that that means that there can be no preset height limit of any amount, that a locality can't say no more than 500 feet tall, but will consider a use permit under that? Does it always have to be use permit in order to comply with Title 47? Is that your view?
No. There are a lot of statutes, ordinances throughout the country that allow, that set forth the standards you have to meet, and if you meet those standards, then you can go in there. Mm-hmm. And those standards are all set in consultation with the providers, the wireless providers, so they tell them what specifics they need, the size of the antenna, the height, range. It has to be somewhere within, this range. And you can limit it within those ranges. What you cannot do is put on a condition that's impossible to meet. That becomes a barrier to entry.
So you think federal law requires Arlington to allow a cell phone tower of workable height on every parcel of land?
No, they're allowed to make sure that they are located in as least impactful area as possible, to put it in generic terms. So the zoning code can still apply, but it can't be used to bar entry. So you can put in there that you have to have certain setbacks. You can put in there, you can keep it, most jurisdictions say below 199 feet. You can't build above that. All of this has been workable, since I've been involved in there. It's when they prohibit it in any zone. You can't go in any zone. That's when you run into a barrier.
So if Arlington had a rule that said very explicitly cell phone monopoles may not be higher than 58 feet in an R zone, that would not necessarily violate Title 47.
Right? Good.
It could.
Yeah, I think it would. I don't have the radio engineers here with me today, but they are looking now at providing the service in some limited instances through what they call small cells, which are below 30 feet. But the macro cells, the one on Army Navy Country Clubs at 60 feet, that's the shortest one I know of, but that was because they could provide the service through 60 feet. I doubt they could provide the coverage in Arlington at 58 feet throughout all of Arlington.
Another question I have is related to the text of the code. In the first sentence of B1, there's the phrase, or any space above the height limit. Do you agree that the such structure shall not exceed 23 feet applies to the phrase, or any space above the height limit?
Well, I think with that, the space above the height limit is within the 23 feet. That's where it has to be.
Right, so you're saying, so do you agree that any space above the height limit must not exceed 23 feet?
There are other parts of the ordinance, where that's changed, but for this particular provision, you cannot have a mechanical penthouse that is more than 23 feet above the roof. Not the height limit above the
let me
roof.
read the longer phrase. It says, but no mechanical penthouse or roof structure or any space above the height limit shall be allowed for the purpose of providing additional floor space. So I think you would agree that any space above the height limit must mean something different than mechanical penthouse. Otherwise, they wouldn't need to repeat it, right? It says mechanical penthouse, one thing, or roof structure, which has got to be some different thing, or any space above the height limit, which has got to be a third thing. And my question is, do you have a notion of what the ordinance means by any space above the height limit that's beyond or different than mechanical penthouse?
Yeah, if I understand your question. I mean, if it's any one of those three things, and granted the third one is very vague, but it can't be.
My question is, why isn't a cellular monopole included in any space above the height limit?
Doesn't have any floor space.
And how do you draw that conclusion? You think you're asserting that the word space must mean floor space?
FAR.
Okay.
Floor area.
So do you think that steeples can be of unlimited height in Arlington by right?
Apparently so.
Okay. And do you think that's been the consistent practice of the zoning in Arlington?
Well, I know that there's a number of church steeples in existence that have been there for quite some time that are well above the height limit. I presume they allow that because they feel the architecture will control it, keeping it from getting too high. I've got the exact height of those. Let's see. They are the church steeple at Old Glebe, the Walker Chapel United Methodist Church, is 98 feet, and that's in a 35-foot zone. The Memorial Baptist Church at North Glebe and Ditmore is 95 feet, and the Westover Baptist Church at Patrick Henry Drive is 126 feet.
And those are all approved after the ordinance?
Oh, yeah. This ordinance has been in effect since, I think since the 70s, not before.
So, and that leads me to one of my other questions, which is you and the zoning administrator have both argued in your materials about what is the enforcement precedent. And I'm a little new around here, and so I feel kind of bad because I feel like I should know what the legal import of enforcement precedent is. Some places I think I remember reading that a zoning administrator can't be bound to a wrong interpretation, but I'm wondering if you have a citation or if there's, how have the Virginia courts or the Virginia legislature established that enforcement precedent matters to an interpretation of a code?
Well, I mean, prior enforcement is an interpretation by the administrator of what the ordinance should say, so it's probative of that. But it's the question is, it has to be shown to be erroneous. You can't say, well, I think that's erroneous, therefore I'm not going to follow it. There has to be some proof as to why it's erroneous.
I guess my question is, why is enforcement precedent at all probative of what a statute means? Why can't we just read the statute?
Just because prior interpretations are evidence of how it should be read in the future.
Okay. But there's been mixed precedents, right?
Not
Been 100% all one way or the other.
the only two that were cited by the zoning administrator. One, the party did not continue to proceed, but the facility was there under the interpretation we were promoting. And then the second one, the zoning administrator said, you can't rely on this. I don't know why, but she said, do not rely on this opinion, please.
That's actually standard. All the zoning administrators' opinions say that.
You can't rely on it.
That's the standard language in all of the zoning administrators' opinions.
Ones I've seen, but all right.
All right, I have maybe one or two more questions, but I'll take a break in case my colleagues want to jump in.
Ms. Malice?
I just have a question for staff if we want to
Go ahead.
move around. Are there instances in our zoning ordinance where there are no established height limits and all the heights are decided by county, any height is decided by county board action?
Other than the exceptions listed here, each district establishes the height. And then there are cases like for site plan, for example, where the board in some districts has the authority to modify height without setting a cap. In some cases there is a cap. In some cases it's going to depend on the project and its merits and what cases may.
In the cases where there's no cap, are there other limiting factors that effectively create a cap, or is it just that the board could approve any height that they wished?
Generally by site plan, unless there's in some districts there's a language that says under no circumstances may a certain limit be exceeded. So if that language isn't there, conceivably by site plan, that's the only place I'm aware of it. The board has greater flexibility to approve height.
And I guess it's the applicant's argument that given this height restriction, there are zoning districts where cell phone towers would not be feasible.
Correct.
Thank you.
Cell phone towers of 115 feet, yes.
Mr. Melnick?
Okay, I have a question for staff. And so you've heard the appellant's argument about the National Wireless Telecommunications siting policy and preventing entry into an area. So what is the staff's response to that? If there's this general limitation, and how it relates to what is required for entry. If there's a certain tower and it happens to be above that, then is there a possibility that this policy is going to be violated?
Our position is interpretation of federal telecommunications law is outside the jurisdiction of the BZA. If there's a challenge to the zoning ordinance as a whole, and how this interpretation could prevent barrier to entry, which I dispute, but I don't want to go into here, I think the proper venue for that is the Eastern District of Virginia, because it is a federal law.
Okay, thank you.
Anyone else? Mr. Smith?
Question, kind of following up on Ms. Malice's question with respect to height limits. Counsel from Stearns said that he believes that church steeples aren't covered by any limitation. Do you disagree with that?
I would, and the examples, I believe all three of the examples that Mr. Stearns provided are of structures that either predated the zoning ordinance or were subject to different regulations.
Those being?
So, United Methodist on Old Glebe Road, the church was built in 1871, clearly prior to our zoning regulations. The one at Memorial Baptist Church was built in 1948, and the ordinance in effect at that time did not limit the height of steeples. And for Westover Baptist Church, it's unclear. We believe it was built prior to 1958, so it's the same rule. At that time, the steeple wouldn't have been subject to the requirements that exist today.
I'm not sure. If you go to each one of those churches, those steeples are a lot newer. They've been remodeled since those dates, the churches.
Well, I guess I would follow up and ask staff, you knew that he was going to make the argument that those specific steeples were not covered by a limitation. Was there any research done with respect to whether there had been any permitting for modifications or replacement or repairs?
No, I'm not aware of any.
Would those churches have any by right options to repair or remodel those steeples?
Repair, certainly.
Mr. Owen?
Oh, I'm sorry.
Keep going.
So, in addition, the appellant criticizes part of your analysis on the location of cellular monopoles that are located on VDOT property, asserting that VDOT property is not, I think you had implied in your statement that, your written statement, that VDOT property is differently regulated than other land in the county, and the applicant cites Fairfax County versus Washington, D.C. SMSA as saying that that's an incorrect supposition. Do you have any response to that?
I think while the county has the right to, it's been our policy not to regulate structures in their right-of-way.
I'm confused about what you just said. Are you saying that there are...
We may be able to, but we haven't historically.
I see. So is it in your power as the zoning administrator to decide not to enforce the zoning ordinance on VDOT property?
It's been a policy decision of the county.
Who's the county in this case? The board or the zoning administrator or someone else?
Board.
And how did the board express that policy choice?
I believe this is just the way we've been operating for some time.
Okay.
Can I also add something to that?
Yeah.
The case cited was a 1999 case. So prior to that case, I mean, the reason the case was brought was because prior to that case, BDOT held the position that they were not required to go to localities for permits. And Mr. Stearns provided a number of monopoles or structures on VDOT property, which some of them we don't have records for, and we don't know if that's because of our policy or because, they were just constructed prior to that case being litigated. 1993 is not that long ago from a zoning perspective, I guess. So that's just some additional context.
Does the zoning administrator agree that enforcement practice is probative as to the meaning of an ordinance provision?
If the plain text can be read unambiguously, it is what it is. But I think that previous enforcement action can give some guidance when there is ambiguity, where differing people can have differing opinions. I think the zoning administrator does have leeway to take on an interpretation. And obviously, she shouldn't go one way or one day and then another way the next. And so that's why a consistent series of interpretation is relevant. But at the same time, I've cited a case saying that the zoning administrator is not, and the county is not, held to past errors or one interpretation forever. In this case, I think the text is clear as to what the district height limitation is. But since the appellant had brought up the fact that there were previous instances of monopoles being of a certain height, we felt it was necessary to go back, do some history, and provide some context on the history way back then and then the more recent history in the last 10 years.
Madam Chair, could I just
Ms. Malice.
clarify? I appreciate Mr. Owen's line of thinking, but I just want to make sure I understood something the Attorney Counsel said earlier, and that is our role is strictly on the reading of the zoning ordinance and whether the zoning administrator made an error. It is not whether her zoning interpretation is in conflict with any other federal law or any other laws.
Correct.
So if in fact it was in conflict, there would be other steps that the applicant could take to straighten that out.
Yes.
Thank you.
Mr. Owen?
One of the other questions that was raised earlier was, what are the legislative remedies available to the appellant if this doesn't go their way, if the Virginia Supreme Court or whatever appellate body they stop at agrees with you? Would they, it seems that your view is that they could never get a hearing for a use permit, but could they petition the board to change the ordinance to allow by right construction? Could they petition the board to allow a use permit to exceed the height limit in this district for this purpose? Could they, is this parcel eligible for a rezoning, and what is the GLUP designation for the parcel?
Certainly a text amendment could be pursued to allow a number of things in a number of ways. So we could be asked to look at creating regulations strictly for monopoles, just to clear it up and have that be one of the specifically enumerated ones like we already have. Or to explicitly allow via use permit such structures to exceed the height. There's different ways you could go, but a text amendment would be necessary. For the GLUP designation, it appears to be, it's kind of, the larger property is split in half, so part of it appears to be low residential, and I believe this property is semi-public. So the two districts would be S3A and SD. By right, the maximum height in the SD is 45 feet. If, again, with a site plan in that district, I don't think the property is large enough, but for properties of 2 or 3 acres or more, the heights are allowed to increase. So if the site is at least 2 acres, the height could be 60 feet, and if it's at least 3 acres, it's 95 feet.
That's more options than I thought they would have.
That's via site, so it's a rezoning and a site plan, but yeah.
But they would, but even absent a textual change to the code,
Right.
they have some permitting that they could pursue potentially. Now we don't know what. I'm sorry. What was the height that you're requesting?
115 feet.
So none of those would get up to 115 feet. It sounds like, though.
If the property were 3 acres, and we applied the same principles here, so 95 feet plus 23. That's the highest that you could get.
Did you evaluate pursuing that option?
Well, we would have to amend this ordinance.
No, the zoning administrator said
I know,
that's
but
not
that we
necessary.
can't apply for, a rezoning wouldn't help us. There's no zone that doesn't require a special use permit in Arlington County. So whatever zone we're in, we're going to need a special use permit.
But you were already willing to do that.
We're willing to, well, that's all we're asking for the right to do is file a
So
special
why not
use
ask
permit.
for a rezoning at the same time, and then you're potentially done?
Well, we don't need it. What do we need a rezoning for? What does that, how does that advance the cause?
It raises the height limit.
Well, but if the ordinance is read as it has been, we're exempt from that height limit. The height limit will be set by the board in the special use permit review. That's where the height limit will be established. So rezoning it to one where we can add 23 feet to it and get to where we want really is probably more than really should be necessary.
Okay, I think I have just one last question for the zoning administrator. The phrase that we've been debating says such structures shall not exceed 23 feet. I'm wondering, what does it mean to exceed 23 feet in that section? And the reason and the context is, which I put in the email I provided to the parties, the rest of this section has 3 different measurements for what you're exceeding. One of them says above, a couple of them say above the height limit. One of them says above the building, the height of any building on the site or on the property. And a third one says above ground level. So, sections 2 and 3 say no more than the height limit. Section 4 says no more than the height of existing structures or the height limit. And then Section 5 says above the ground level. So my question is, when the zoning administrator says such structures shall not exceed 23 feet, 23 feet above what? Or 23, not even above. I don't want to put the above word in. What does 23 feet exceed 23 feet? What can't you exceed 23 feet by? What is the thing that is exceeded?
So this is in subsection number 1, which has the language at the beginning naming all the different types. And it talks about how these types of structures may be erected above the height limits herein prescribed. So to my mind, that's what this is referring to. The 23 feet is above the height limits therein prescribed.
So you believe the implication is that it's like number 2 and number 3, where it's meant to be interpreted above the height limit?
Yes.
And not necessarily above the building? Because if the building was
I see
low,
what you're saying.
if the building was 10 feet tall, could you have a pole on top of that goes all the way up to 23 above the height limit? Or is it limited to 23 feet above the building? That's my question.
I believe it's meant to be 23 feet above the height limit, but I know that I'm pretty sure that it's been applied.
Sounds like you're giving a snap answer and not one that's based on a carefully researched view.
I hesitate to say height limit because I'm thinking of site plan examples for buildings that are approved above the height limit.
Right.
So that's
All right.
I'm having a hard time.
I'll let the cat out of the bag, which is that I think the entire structure of number 1, and I'll share this and if you want to respond to this as well, I think the entire structure of number 1 was written as building height being the basis. I think that the entire meaning of Section 1 was, I don't think the drafters of Section 1 intended, or maybe whatever they intended, I don't think that they expected as they drafted it, that it would be applied to structures that start from the ground and go all the way up to the total maximum possible height limit. I think that the entire context of number 1 is these are all structures that could be placed on top of a building. And so it says you can put these things on top of a building, but they shouldn't be more than 23 feet above the building. And so and what's created the conundrum, what makes it seem like this is an ambiguous statute, is the global practice of the zoning administrator to allow things like monopoles or antennas to go all the way from the ground with no building in sight, with no space, any other space above the height, the space, all of that suggests on top of buildings. And so when you try to apply this to be generous to antennas and monopoles and flagpoles that are starting from the ground and going up with no building underneath them, what the zoning administrator has done is to say, well, we'll treat the first 35 feet of the monopole as if it were a building, and then we'll treat the last 23 feet as if it were a radio tower. And so that's how you get a monopole up to the total height limit. But I'm not sure that that entire interpretation is on good foundation. So do you have any reaction to that?
No.
Do you have any reaction to that?
Well, I think you see the dilemma. I mean, a cellular telephone service provider comes into a jurisdiction and tries to locate where they're supposed to locate. And they read this ordinance and they think, well, we have to meet certain setback requirements, there's certain zones, you have to get a special use permit. Well, what about the height limits? And you read that, well, you're a tower, you're exempt from a height limit, and therefore they move on to the other standards they have to meet, knowing the height's going to be determined in the special use process. And if to do as you say, the zoning administrator would have to write language in to the ordinance to interpret it that way.
Mr. Melnick.
In reference to what Mr. Owen was saying here, I did notice that on our handout it has section 3.1.6, but then it also has 18.2 general terms for structures defined as anything constructed or erected that requires location on the ground or attached to something having a location on the ground. So that does include on the ground or attached to a building. And it's true, one would think one way or the other that a section that uses the word structure would be keyed in to the definition of structure. But I think that, for me, that addresses, whether are we talking about something on a building or on the ground?
Other questions? Comments?
Madam Chair?
Ms. Malice?
I'm trying to stay with the narrow task that's before us, and that is to determine whether the zoning administrator applied the existing ordinance correctly. And I guess that includes whether the zoning administrator in the past or present has the ability to change interpretations, which I think they do. And so in the narrow sense of what the zoning ordinance says rather than what it should say or what it should be more clear or less clear, I think that she has interpreted the zoning ordinance as it is written, as it exists today. That's my view at this point.
Motion?
Pardon? I'd be happy to make a motion.
Please.
Whereas the Board of Zoning Appeals has held a duly advertised public hearing on May 17th, 2017 on case number V-11260-17-APP-1, an appeal of the zoning administrator determination regarding the height restriction for cellular radio towers, and whereas the BZA finds that the zoning administrator's determination was valid and correct. Now, therefore, be it resolved that the BZA hereby affirms and upholds the zoning administrator's determination to Cellco Partnership doing business as Verizon Wireless regarding the permitted height for a cellular radio tower at 308 Kensington Street.
Is there a second?
I'll second.
Moved by Ms. Malice, seconded by Mr. Melnick. Discussion? Hearing none. All those in favor?
Aye.
Aye. Opposed?
Nay.
Thank you.
Thank you, Madam Chair.
Next case, please. 4-1.
B-11238-17-VA-1. It's a variant request to permit a main building footprint of 35.7 and a total lot coverage of 47.9 for a new two-story addition with an attached garage in the R8 zoning district in the premises known as 6100 31st Street North. And the staff recommendation is to accept the applicant's request to defer the case to the June 21st hearing.
Chair,
Mr. Melnick,
I'd like to make a motion.
please.
Okay, so in case V-1123817-VA1, I make a motion to defer this case to the June 21st, 2017 hearing.
Second.
Moved by Mr. Melnick, seconded by Mr. Smith to defer to the June BZA hearing. All those in favor?
Aye.
Aye. Thank you.
B-11238-17-UP-1 is a use permit request to permit a setback of 23.2 feet to the wall from the North Ohio Street right-of-way instead of 25 feet as required, and to modify a previous variance approval that permitted a setback of 16 feet to the North 31st Street right-of-way and a 10.8 feet to the North Ohio Street right-of-way for a front porch for a new two-story addition with the attached garage and an enclosed front porch in the R8 zoning districts, premises known as 6100 31st Street North. And the staff recommendation is to accept the applicant's request to defer the case to the June 21st hearing.
Madam Chair?
Ms. Malice.
I move that the Board of Zoning Appeals defer this matter to the June 21st, 2017 meeting.
Second.
Moved by Ms. Malice, seconded by Mr. Smith to defer the case to the June 21st BZA meeting. All those in favor?
Aye.
Thank you. Next case, please.
B-11248-17-VA-1. It's a variance to permit an addition exceeding 50% of the existing floor area on a non-conforming lot for a new addition in the R27 zoning district on the premises known as 844 South Irving Street. And the staff recommendation is to adopt the resolution approving the variance request with conditions.
Thank you. Questions for staff? We'll hear from the applicant, please.
Chair.
Oh, sorry.
Sorry.
Mr. Owen.
Thank you, Madam Chair. In the staff report, the analysis of the criteria for granting a variance, number 3 says the condition or situation of the property is not so general or recurring as to make reasonably practical to formulate a regulation which can be adopted as an amendment to the ordinance. The staff response is the condition of having to comply with section 16.2.5 is general and recurring and is a condition shared by other lots in the Westmont subdivision. Why isn't that a bar in staff's mind to approving the variance? Why did staff say that was true, but nonetheless recommend that the variance be granted?
This was a difficult one because of, in doing further research, we found evidence of the requirement not being applied properly. In addition, we did some work with our colleagues in planning going on a year and a half ago, citing areas where we thought changes to the zoning ordinance were appropriate. Those were presented to the county board and the planning commission this March as part of the work plan to talk about what amendments are coming. It didn't make the cut for this fiscal year, but it certainly was identified as something that we need to fix. So in light of that, the situation that we discovered happening in this very neighborhood, we felt that we could recommend it at this time, and the changes that were made since the time we were here a couple months ago.
I mean, it's not a problem for me because I voted for the variance last time on other grounds. But I think for those of you who disagreed with me, you're in a pickle with this. But
Ms. Malice.
So how did staff misinterpret this ordinance in the past?
I think applicants came in for rear additions, and this particular regulation is located, it's kind of embedded in the non-conforming section. It's not where where kind of the other regulations are that deal with kind of run-of-the-mill residential additions, and I think it was has been missed, sadly.
Okay, so the fact that it's going forward for review does not necessarily predetermine the outcome, does it?
No.
So why do we rely on a possibility? Why do you rely on a possibility being strong enough to go against the ordinance?
We just felt comfortable with it given the research that we did and the reception that we've gotten in discussing it so far.
The reception from?
Certainly the board was interested, not necessarily in this provision in particular, but certainly in addressing non-conforming structures and the challenges that homeowners have in trying to make improvements and additions. It came to light again recently as a result of the Arlington magazine article. So it's certainly on their radar. But it's actually not scheduled, just to be clear, it's not scheduled for this year. It didn't there were too many other items, but it was raised as if it was raised in the context of if there's a way we can squeeze it in this year's work plan, try to. If not, then we'll have to wait till next year.
Mr. Melnick.
So I too am troubled about this particular condition, and this is actually a part of the statute, and we heard in the last case that just because something, an interpretation has been wrong or there have been errors in the past, that that's not justification for the error to continue, and I understand a lot of work's gone into this, a lot of drawings, probably a lot of money and effort and so forth, but it seems like, with the staff right out saying that this condition is not met, that we're getting almost into like equity, that it's that in, if things have been wrong enough, and if I guess enough has been done, then we should just ignore the ordinance, and so I have a real problem with it, just because of that. And it just seems to me that maybe the county ought to put it on a fast track so that these people, can get some relief. But that's, to go right up against an actual condition, just because it's been done erroneously in the past, I have real hesitancy with that.
Thank you.
Madam Chair.
Mr. Owen.
Just very briefly to make sure to spoil any surprise, I'm going to likely support this variance as I did last time for the same reason, which is that I think that this is basically a historic structure that's in both this and the other house that's next to it. I think both of these are very old structures that are sited on the land in a very different position than all the other houses on the block. And so I don't agree with the staff analysis as to number 3, and so that saves me. So that's my view.
Madam Chair.
Mr. Smith.
I associate myself with Mr. Owen's indication that you can clearly see that the back line of this lot is at an angle, and in general, what you find are these lots are rectangular. So I too will support the variance.
Can we hear from the applicant, please? Just to stay on point.
Should they not undo the gilded lily?
We're back.
Hi there.
Hello. A few updates from when we were here last, and I think you received our written statement, so I'll just go through a couple of highlights. Number 1, we have modified our plans based on the discussion that we had when we were here last time. We are now proposing an addition that is reduced to 524 square feet, which is 61% of the existing floor area from 1950. So we scaled that considerably. We've also modified the facade of the house so that it is in keeping with our neighbors. So as you know, we're doing this as a joint project with our neighbors. So we modified that in the plans to make sure that we're continuing that consistency. As you see in our neighborhood, the houses tend to match. And then also with the completed addition, we still will be well under the lot coverage limits. So we are not expanding the use in that way at all. Point number 2 is we did our research, and this has come up in the discussion. Within our zone, there are 10 two-family houses that are on non-conforming lots that have additions that exceed the 50% rule. Some of those received variances. Some of those, there's no record of what happened. There's kind of a mishmash of what happened with those. But this is roughly in a 2-square block radius of our house. So there is a lot of precedent, and these are, again, going by the taxable square footage of the houses. Number 3, we have extensive neighbor support. You have in your packets 15 or so signatures, and we did, since the last time, secure the signature and a letter from our immediate adjacent neighbor, not our connected neighbor, but on our side. And then my 4th point is just a little bit of perspective. So what we're asking for is that extra 11% for the variance. That's going to be 100 square feet spread across 2 floors. So if we take a look at probably the area from the podium up to there, about this wide, that's about what we're asking for across 2 floors. So I'm pretty confident that our whole house would fit into this room. So when we're talking about the size and the scope of this, that's, again, just a little bit of perspective. Just to read a couple of notes from the staff report, so I know that you've seen that, but one particular point, whether inadvertently overlooked or misinterpreted, the misapplication of this provision during previous permit reviews has created a hardship for this property owner, as they are now being held to the strict application of the zoning ordinance where others have not. So this is the hardship argument. In this case, a variance to alleviate this hardship would be necessary in order to achieve parity with the dwellings within the neighborhood. A second point, the granting of the variance should not be of substantial detriment to adjacent or nearby properties. Again, we received a letter from our next door neighbor who would be most directly impacted in theory by this. And as we heard, the county planning staff recommends that a future zoning ordinance amendment revise this provision so that it no longer applies to two-family dwellings, and we had that discussion. And eventually the actual conclusion, though, is the use of this property is unreasonably restricted by the zoning ordinance. Thank you.
Questions of the applicant? Thank you.
Madam Chair?
Ms. Malice.
I also, I agree with Mr. Owen that condition number 3 is the reverse of what I would argue if I was going to try to get this approved. I mean, we are in a position of approving exceptions, not something that applies to an entire zoning district throughout Arlington. And so I think we have to reject the staff analysis in this case. And if we're going to approve it, it's going to be approved on the basis that this particular dwelling is different than most of the other dwellings in this district. And that's the basis of our approval.
Thank you. Other comments?
Madam Chair,
Mr. Owen.
I move that the Board of Zoning Appeals adopt the attached resolution. Actually, the proposed motion says something different from what I wanted. I move that the Board of Zoning Appeals adopt the attached resolution approving the variance V-11248-17-VA-1.
Second.
Moved by Mr. Owen, seconded by Mr. Smith. All those in favor? Aye. Opposed?
Nay.
Thank you. 4-1. Next case.
B-11248-17 UP-1. It's a use permit request to permit a setback of 8.2 feet from the wall instead of 10 feet as required, and 4.5 feet to the basement areaway and a window well instead of 5 feet as required from the left side property line, and to permit a setback of 21 feet to the wall instead of 25 feet as required from the rear property line. For a new addition, an existing rear addition, a new screen porch, a basement areaway and window well in the R27 zoning district, the premises known as 844 South Irving Street. And the staff recommendation is to adopt the attached resolution, granting the use permit with conditions.
Thank you. Questions? Applicants?
I don't think we have anything else in particular to say, but we're happy to answer questions on this aspect of the project.
Okay, we do have a speaker slip from Wanda, your designer. Sorry? You pass?
I think unless if you have questions, specific questions to the design, that
Okay.
she can answer.
Thank
that we
you.
can.
I did this time.
Questions? Comments?
Madam Chair,
Mr. Smith?
I move that the Board of Zoning Appeals adopt the attached resolution approving the use permit in V-11248-17-UP1, subject to the conditions that are listed in the resolution.
Second.
Moved by Mr. Smith, seconded by Mr. Owen. All those in favor?
Aye.
Aye. Opposed?
Nay.
4-1. Thank you.
Thank you.
Next case.
B-11249-17-VA-1. Severance request to permit an addition exceeding 50% of the existing floor area on a non-conforming lot for a new addition in the R27 zoning district in the premises known as 842 South Irving Street. The staff recommendation is to adopt the attached resolution approving the variance request with conditions.
Thank you. Questions? Applicant, please.
Hello, excuse me. I'm Jennifer McDougall, one of the property owners of 842 South Irving Street, the adjoining property of the Helms family you just saw. Just to reiterate, it is our plan to build the additions in question together. We're going to utilize same contractors, same external materials, and same construction timeline. I'm not sure what I can say that hasn't already been spoken. We've worked diligently together on this project, so I'm happy to answer any other questions.
Thank you. Questions for Ms. McDougall? We have a speaker, Thomas Helms. Oh, hello.
I'm just here to express my unequivocal support for the project, as it is a joint project, and going forward without the McDougalls is not really an option for us.
Okay, thank you.
Madam Chair,
Mr. Owen.
just want to make a comment while the applicants are here. So often the Board of Zoning Appeals is in the unhappy position of addressing disputes between neighbors who are fighting viciously with each other. And it's so refreshing to finally have some neighbors who are working so hard together in the same direction. So thanks for bringing this to us.
Thank you. Agreed.
Madam Chair,
Ms. Malice.
I just would like to make the same disclaimer that we made on the previous case in terms of the rationale for my approval, at least, and that is that this dwelling is different than the other zoning dwellings in the zoning district. Not that it's similar, but that my interest in approving the variance is because we can interpret this as having a hardship that other dwellings in that district do not have.
Madam Chair,
Mr. Smith.
and I agree with Ms. Malice that this structure and this plot is it's oddly shaped, and those are factors that require, I think, some relief from a strict application of the zoning ordinance. And I too am happy to see neighbors working very, very closely together because they're so close. One other point, usually Ms. Malice adds a comment about material that's submitted that's really not relevant. The housing data is very informative and very instructive, but it really doesn't go to the characteristics of the land that would allow for granting some relief. But it was very informative, and it's helpful to know.
Thank you.
Thank you. Mr. Melnick.
Just to clarify, so I'm not going to be able to support this, although it looks like I'm going, upstream on this thing. But I do, I do accept the staff's comments on paragraph 3. So that's the reason for my vote.
Madam Chair,
Mr. Owen.
I move that the Board of Zoning Appeals adopt the attached resolution approving the variance V-11249-17-VA-1.
Second.
Moved by Mr. Owen, seconded by Ms. Malice. All those in favor? Aye. Opposed?
Nay.
4-1. Thank you. Next case. Might as well just stay there.
Thanks.
Dash 11249 17-UP-1. It's a use permit request for a setback of 8 feet to the wall and base of porch from the right side property line instead of 10 feet as required for a new addition and front porch in the R27 district and the premises known as 842 South Irving Street. The staff recommendation is to adopt the attached resolution granting the use permit with conditions.
Thank you. Questions, comments? Okay.
Madam Chair,
Mr. Smith.
let me make a brief statement. The public is seeing us go through these 2 cases for each of these structures, and they're probably wondering, well, I only have one. Well, these are unique because they're variance applications that have a higher threshold to meet. And historically, that was the only avenue that an applicant could go down. But in the not too distant past, the General Assembly changed the law and added the ability for counties like Arlington to apply a special use permit application for different different issues with respect to land. So these cases are unique in that they are variance applications then coupled with the special use request, which is kind of an underlying and a condition that's easier to meet.
And also, they were heard once before and sent back for collaboration. So part of what isn't being discussed has already been heard.
Madam Chair,
Mr. Owen.
I move that the Board of Zoning Appeals adopt the attached resolution approving the use permit V-11249-17-UP1, subject to the conditions listed in the resolution.
Moved by Mr. Owen, seconded by Mr. Smith. All those in favor?
Aye.
Opposed?
Nay.
4-1. Thank you. Next case, please.
B-11258-17-UP-1 is a use permit request to permit a setback of 2.1 feet from the wall of a shed and 1.5 feet from the eave to the rear property line instead of 10 feet as required, and 20.5 feet from the wall instead of 25 feet as required, and 19.9 feet from the eave instead of 21 feet as required, to the North Edison Street right-of-way for a shed. And the staff recommendation is to adopt the staff resolution granting the subject use permit with a setback of 6 feet to the rear property line instead of 2.1 feet as requested. And I wanted to make this clarification that the applicant suggested or sent more information to us requesting or moving the subject 6 feet over, actually instead of the 2.1. So there's a little bit of incorrect information on the subject request.
Okay, Madam Chairman.
Ms. Miles.
So the plans that we have show the shed 1.5 feet from property line.
What you see on the plot that you have, it's number 2. Originally, she had requested 2.1 feet of setback, and a few weeks later, we received a new request that she was decreasing the setback, moving it in to ask for a setback at 6 feet instead of the 2.1 feet.
Do we need new drawings to do that?
We have it. It's the second one.
Second, I see, okay. The second one shows the change.
Correct, yes.
Okay, and it's just the text that needs to be.
Correct, that is just the text.
And on the page 2 of the staff report, at the top where it says proposed changes, that sentence should read, the applicant is proposing an 8x8 square foot shed.
Correct.
Right, that word shed. And is it an existing?
It's existing.
It's an existing shed, isn't it?
I believe it is, and why she's requesting the use permit is because it's less than 150 feet, less than 150 feet, which is when you're adding such structure, you do not need a building permit for it. Therefore, she added it and constructed it without a permit because it is not a requirement when it's less than 150 feet.
So,
Feet, I'm sorry.
so is it now in the correct setback, or does it have to be moved?
It's going to have to be moved.
Okay. Other questions? What was the answer? It has to be moved. Applicant, please.
Madam Chair,
Mr. Owen.
is there a speaker's slip on this item?
Yes.
Okay. So is it the rear neighbor?
Tough to say.
Okay. Thanks.
Applicant?
Yes, Peter.
Good evening. I'm Kim Harris. My mother, Margaret Harris, and I are the property owners at 5010 14th Street North. We are requesting a use permit for a shed located on this corner lot. The shed has a footprint of 64 square feet. Last fall, the shed was built in the area of our lot within the 10-foot setback from the rear lot line and the 20-foot setback from the street right-of-way. Although I did review the zoning ordinance prior to citing the shed, I incorrectly interpreted that since the shed did not meet the size requirement for an accessory building and did not need a building permit, it was not subject to the setbacks. When I was informed that the shed was not compliant, I started pursuing the use permit to become compliant. We selected the current location of the shed for several reasons. It backs to my neighbor's shed, a 263 square foot building, which is also within the setbacks for the rear lot line and the street right-of-way. This promotes symmetry between the two properties. And if you take a look at the photo number 1 in the information that I gave you, you will see my neighbor's shed on the left side of the fence and my shed on the right side of the fence. That's looking from my lot toward the rear lot line. Second, we placed the shed among a couple large trees and azalea bushes in an area where nothing else was growing. This location helps conceal the shed in the yard and preserves other areas of the yard for other uses. And you can refer to number 2 to see my lovely picture of my shed from my west side of my lot, which shows the trees that it's beneath and the azaleas that it's among. We specifically did not put it in the southeast corner of the lot because we have a nice lawn in that area, and we want to preserve that lawn for its use as a recreation area, and that you can see in photo 3, which is the southeast corner of the lot. The setbacks for structures on corner lots only allows us to place the shed in the middle area of our rear and side yards. Locating the shed in these areas is not practical since a shed doesn't fit in with the use of these areas and or would impede walking around the property. There are also limitations for placing the shed even within the setbacks in other areas of the side and rear yards. Along the side lot line, there is uneven and sloping terrain, trees, shrubs, and a patio areas that restrict the placement of the shed. And along the rear lot line are trees and the lawn area we would like to preserve. As a part of our neighborhood outreach, we talked to all 8 neighbors with property peripheral to ours and those who routinely walk within the neighborhood. Of the people we spoke with, only those property owners closest to the shed had even noticed it. When we pointed it out, most felt it was compatible with the house, yard, and neighborhood. There was one exception. The neighbor along the west rear lot line has raised objections to the shed location, especially that it is too close to the fence line and too close to where he parks his car. And you can see, there's another picture of it, I think, on the monitors, but there's also shown in photo 4 where you see his parking area from the Edison, and you can see our shed to the left along our fence line. To accommodate this neighbor's concerns, we revised our proposal to have a 6-foot setback to the rear lot line to be equitable to our neighbor's permitted setback from their shed. So in summary, based on the criteria required for the approval of our use permit, our proposal appears to meet all conditions necessary for approval. The proposal promotes compatibility of development within the surrounding neighborhood. The 3 adjoining properties all have sheds with a footprint greater than 64 square feet. Our shed is placed opposite to the neighbor's shed across the rear lot line. Outreach to neighbors suggests that the general opinion is the shed is compatible with the surrounding neighborhood development. The proposed location does not require changes to the landform, historical features, or significant trees or foliage. Number 2, the proposal would not adversely affect the health or safety of persons residing in the neighborhood. Number 3, the proposal would not be detrimental to the public welfare or injurious to property or improvements in the neighborhood. And 4, the proposal is not in conflict with the purposes of the master plans and land use and zoning related policies as a county. We would really appreciate the board's approval of our use permit for the shed at the proposed location. Thank you.
Madam Chair.
Thank you. Yes, Mr. Melnick.
I have a question. So
Sure.
I understand instead of 2.1, you're going to agree to 6 feet?
Correct.
And is that then to the wall, and then there'll be the 0.6 feet to, allowance for the eave?
Correct.
Okay.
Other questions? Thank you. We have one speaker, Douglas Staver.
Thanks.
Good evening, and thank you to the board and staff for your time. I am Doug Staver, and my wife and I live in the house directly behind Ms. Harris's property. I want to note that aside from this shed issue, Ms. Harris has been a great neighbor. Excellent. The reason we're here is that a few months ago, she installed the new shed approximately a foot from the fence that separates our two properties. While you can purchase sheds 8x8 at Home Depot that are 6 or 8 feet tall, this is a 12-foot tall shed, a little bit over double my height, including the foundation. I understand why our neighbor placed the shed where she did. Its current placement has it tucked between two trees, just about as far back in the corner of her lot as possible, and out of sight from her large side yard with its open space and patio. Unfortunately, though, optimal placement from my neighbor's standpoint is not optimal for us on our side of the fence. The current location places a 12-foot tall white wall directly in our line of sight from our driveway, where previously we had a 60-foot unobstructed view of trees and bushes across two properties. So now every single time we pull into or leave our driveway, we're now looking right into the side and back of this white shed. I noticed that my neighbor's application neglected to include photos which show how close the shed is to the fence line, up close, or the view from our driveway, up close where, it's pretty close right there, where I drive into the driveway. I've included those photos in my packet. I understand there are numerous grandfathered sheds and outbuildings in our neighborhood which are close to their fence lines, but this is precisely why Arlington changed the zoning rules to require a 10-foot setback, because more and more of these buildings, as more of these buildings go up, Arlington's suburban aesthetic is negatively impacted. Zoning rules were enacted after much deliberation. We have a wonderful suburban aesthetic, and the new zoning rules prevent the more crowded feeling you get in an urban environment where new structures go up haphazardly.
Just sum up, please.
Sure. My neighbor has included signatures and some letters from neighbors across the street and down the block. My wife and I own one of the 3 properties adjacent to Ms. Harris's corner lot. I've included in my packet letters from the 2 other adjacent property owners, both of whom support our position regarding the shed. They are included in your packet. These letters request that either she place the shed, as is her right, in a location that complies with Arlington's zoning regulations, or she work with all 3 adjacent property owners to obtain a variance on a compromised location that is acceptable to all parties.
Thank you. Questions for the speaker? Thank you, sir.
At a later time. I think I want to
Sure.
hear the speaker.
Are we done with the speakers? Has the last speaker been called?
I did have one more thing to add, but I don't know if I'm allowed to add one more.
Thank you.
Do you have anything else to add?
If it's okay. The applicant noted that I have a shed on my side of the fence, and she's entirely correct. But if you look at the photo, that shed, the height of my shed in the other side of the fence, 6 feet from the fence, is only 5 feet tall. That's actually a garage. And in order to put that garage where it's located right now, that garage had to be buried 3 feet underground. That was a requirement by the zoning approval process, was that it be placed 3 feet underground, and the roof line of a shed on our side of the fence had to slope toward the fence. So 10 feet from the fence, the roof is only 7 feet tall. 6 feet from the fence where she's proposing to put her shed, my shed is 5 feet tall. So it was placed, and per the zoning rules, it had to be placed there, buried 3 feet underground with a sloped roof to minimize the impact on the neighbor in her house, the previous owner. So while there is some comparison between the two properties, a 12-foot tall structure and offsetting a much shorter structure, I don't think is necessarily compatible or comparable.
So my question to you is, have you considered the possible? Have you considered? I didn't hear in your comments that you precisely addressed the possibility that the shed would be moved several feet farther away from your property line.
Right. Well, that was what I was trying to get at by saying that mine is 6 feet away from the fence and hers is also. Her proposed solution is 6 feet also. Unfortunately, it's still going to be right there visible as we come and go from our property. We have proposed and suggested that it be moved more toward the inner corner of the lot. We're willing to work with her on the 10-foot variance, and the neighbors have indicated in their letters that they're willing to work with her too, to come up with a location that is compatible for all parties. But we are not satisfied with the move 6 feet from the fence line.
Thank you.
Other questions?
Question for staff.
Thank you, sir.
Sure.
Go ahead. Ms. Malice.
This shed did not require a building permit because of its footprint size. Do these sheds have any height limits?
Yes. We've had this come up a couple of times where because they don't require a permit, they don't get zoning review, but they're still subject to the placement requirements and the height requirements. I'm looking for what they are for accessory structures. Is in the district, is it?
I have a question for the applicant if we want to do that while we're waiting.
Mr. Owen.
I see in the materials that your neighbor has passed out tonight that it looks like several of your neighbors are inviting further discussion on alternate placements or alternate configurations of the shed. And I'm wondering if you have a reaction to those various offers for further discussion.
Well, I hadn't heard of these offers because I had visited with my neighbors back in January when we put the original use permit in, and they had no objection. And I talked to both of them, both the other ones who were enjoying lots, and they, again, said they had no objections to where it was placed. In terms of open for discussion, I know that one of the requirements is that it's placed in, or the structure should be placed in an area where another shed is placed, or where another structure is, or similar to where other structures are placed on surrounding properties. And this is the place that's most consistent with another structure placement on a property because it backs to that property. Anywhere else on my property except on my side yard where my other neighbor has a shed, is the only place there's another shed. And so, with all due respect, that I see my neighbor's shed from my entire house, from my entire yard, and even though it doesn't have a wall, I see as a roof because the roof slants up, so it looks just like a wall. So my visibility to his shed is throughout my property, where his visibility is only in his parking area on the other side of his shed. He can't see it from his yard. So
I guess what I'm getting at is that if we rule tonight, there's likely to be at least one person, maybe you, maybe a neighbor, who feels like they lost. Whereas if there's any possibility that over the next couple of weeks you and your neighbors could get together and reach an agreement, which all of you support, then there's a very high likelihood that the Board of Zoning Appeals would, my colleagues and I would rubber stamp whatever that agreement was. And that agreement could include different kinds of encroachments and placements other than the ones that are before us in this application. And so I just wanted to check and see if you feel like you want to take advantage of that opportunity, or if you want to roll the dice and ask us to rule up or down tonight. And you don't have to give an answer in the next 5 seconds if you want to think about it. So I just throw that out there.
So could I just follow up? You know, in listening to the testimony of Mr. Staver, he mentioned a number of different things that were of concern to him. So it seems like there's a number of different points that could be addressed. For instance, he mentioned the color white as being particularly intrusive. When you look at some of the other sheds, they're a more muted color and therefore don't stand out as much. So it seemed to me that Mr. Staver did give some indication of places where you might be able to work out some kind of a compromise.
I did actually address the color with him already, and he didn't say the color wasn't, he didn't mention that the color change would make a difference. I don't know how he might feel now. I also talked about putting a tree between the fence line and my shed.
So
to help obscure the shed as well.
Our difficulty is that we can't redesign the location of the shed as we sit here,
right,
and come up with a solution. Our question to you is, are you willing to take a deferral on this item and sit down and see if you can come up with a solution with your neighbors?
If you did that, you wouldn't lose your right to come back and make this same proposal later.
Yes, I guess I would prefer to defer then.
All right, so that's good. There would be an expectation that Mr. Staver and the other neighbors would meet with you to discuss alternatives. You are under no obligation to accept any other proposals, but understanding that we will be the ones that finally decide which way that we go. So that would be the expectation, that you would have a cordial and productive meeting with your neighbors to see if you can't work this out.
And your neighbors would conduct that discussion with the knowledge that staff already supports this proposal. So that would be an incentive for them to participate in the discussions with you in good faith.
Are we still looking for the height?
Yes, are you still looking for the height of this building?
Well, the height of the building's like
Can I ask the applicant a question?
Mr. Smith?
Very briefly. A delay wouldn't cost you anything, would it? It wouldn't cost you any money. You don't have any. There wouldn't be any carriage costs or carrying costs or anything. It's already built, and you don't have a contract set.
No,
right?
it wouldn't cost me any money. Just causes me a lot of stress.
Yeah, that
because it's already an expensive proposition.
Cost,
so it is very, very stressful.
That's not going to be avoided, though.
We get that a lot.
You have to understand that the zoning rules protect everybody. Not, they protect you from your neighbors, and they protect your neighbors from you. And so there has to be. We have to take those into consideration when we make these decisions.
I understand. I was just looking for equity from my neighbor has a shed, and I was looking for equity from his position of his shed.
You may come back and argue that point subsequently.
And you're perfectly free to come back whenever the deferral period ends and propose the same project if you don't feel like there's a good alternative out there. But maybe there is, and if your neighbors work in good faith with you, maybe that will be arrived at.
Okay, thank you.
So the next question is the amount of time of the deferral. Typically, we suggest 2 months because by the time you have a chance to talk, and if there should be any changes to drawings or any location, you need time to be able to document those before you come.
I'm trying to avoid July for previously advertised reasons, but can you tell me
The height of the shed?
the height of the shed?
The limitations are 1.5 stories or 25 feet.
So even a small footprint.
Yes.
Can have a 24-foot silo as long as it's below the building permit limit.
So that tells your neighbors that
the height issue is-
it could be worse.
No moment. Be careful what you wish for.
Okay. What's your pleasure?
Madam Chair, just to add, just for the benefit of the stavers, my personal view is no matter where a shed is placed in that yard, when you drive in, it's going to be visible to you. So 6 feet, 6 feet.
In terms of a deferral, how much time for advertising for June? Or is it too late for that? It just seems to me that a lot of the elements are in place and we already need to discuss it.
We're not too late for June.
It's not late.
It's close, but we're not too late. And for July, we have so far very few cases. So,
Well, I'm just submitting that we're not starting from scratch here. We've got,
right.
in terms of getting together, having a discussion, and trying to come to a meeting of the minds if that's possible, and yet not delaying you any further for having a final decision.
But, Madam Chair, just for advertisement purposes, any proposal is going to be further away. It's going to have less of a encroachment than what's already been advertised, right?
Yes.
'Cause, I mean, they've already accepted. Yeah, we do know that because she's already accepted 6 feet.
If they move the location to a corner, there might be
Yeah.
a compromise on how far from the fence it is.
Yes, that's the point.
Yeah.
But they have rights to put it in a corner, though.
There's no place I can put this shed without a setback request. The side yard is 8 feet because it's a structure, not a accessory building, which would only be 1 foot because it's too small.
They don't meet the garage requirements, that's right, to be closed.
Yeah. So it would have to be.
At least 6 feet, so, and it's been advertised for 2, so.
Well, worst case scenario is if they come up with something that requires a re-advertisement, then they'd be in July, right?
Right.
Okay.
So we'll make the deferral to the June hearing, and if you don't make it, then you...
Isn't that the next meeting? There's no way I can make the June meeting because you have to advertise it within like 2
I
weeks.
think we just discussed that we could make it work.
Would you
I don't
would you
think it's gonna
prefer
work.
not to do June? Would you prefer to do July?
To do July
Okay.
because I don't think we can make it work in June.
Okay.
All right.
Can I have a motion, please?
I'm in the matter V-11258-17-UP1. I move that the Board of Zoning Appeals defer this matter to the July hearing.
Second.
Moved by Ms. Malice, seconded by Mr. Owen. All those in favor of deferring to the July meeting?
Aye.
Aye. Thank you.
Thank you.
Next case, please.
B-11125-17-UP-1. It's a use permit request to permit a setback of 3.4 feet from the left side property line instead of 9.8 feet as required. In an aggregate side yard of 14.6 feet instead of 21 feet as required for a new left side carport in the R8 zoning district in the premises known as 2548 North Upland Street. The staff recommendation is to adopt the attached resolution denying a setback of 3.4 feet. And an alternative resolution has been provided as advertised.
So this was a construction error? I believe. Staff?
Yes. During construction, I believe they built it closer than what the previous request was.
Thank you. Questions for the staff? Applicant? Please go ahead.
Yes, my name's Catherine Biersack, and this
Are
property...
you speaking to the microphone, please?
Sorry. Hi. My name's Catherine Biersack, and this home has been in our family since 1964. I became the legal owner of it in 1999 upon the death of my father. And I moved into the house just about 10 years ago and started to do the renovation of it, of which everything has been permitted. It's the original 1952 house, Roy Hill Rambler with a walkout basement. In the late 80s, early 90s, I'm not sure exactly the date because I was stationed overseas, my father took down the old carport because it was in disrepair. And at some point, they covered the driveway, the concrete driveway, with asphalt. It looks like once we tore it up, there were multiple coats. Since I've moved in, the retaining wall was starting to crumble and fall apart. And so at some point, I knew I was going to need to replace it and do something and put a carport. And so early on, even 5-6 years before we started this project, I went ahead and talked to my neighbor on the left-hand side as you face my house. So last year, the board kindly did give us a user permit with requirements. We could never build above it. We needed a second plat. We couldn't be closer than 4.1 feet to the property line. And what I believe happened, and my contractor is going to be able to explain it better than I can, but when we got the plat, and they didn't know where the end of where the retaining wall started from the front. They knew where it ended in the back because it was underground and under the asphalt. So at this point, if my speaker can then explain what happened during the construction.
Are you
all
Mr.
right.
Everett? Yes. Mikey?
So the retaining wall she's speaking of.
Would you state your name for the record, please?
Everett.
Thank you.
So the retaining wall she's speaking of was the boundary that supported the dirt underneath of the existing carport slab. And that had deteriorated to the point where a slab could no longer be supported by the wall. The footer below had to go as well. So this originally started out with me to build a canopy over the existing carport slab. But once it was determined all that had to be removed, a new retaining wall, a new footer, and a new concrete slab above to support the new canopy. And when I laid it out, I tried to stay on the same footprint as the original retaining wall that supported the original carport slab by staking it out, but I apparently overshot the mark for a variety of reasons and ended up, instead of 4'1" off the property line, I ended up at 3'4", 3.4.
String them up.
No ropes.
It's going to be a long night.
Yeah. So as you can see, we've I went and talked to all the neighbors, and all the neighbors are supportive of this. In particular, my neighbor who's most impacted, which is the Flanagan home to the left, which is 2544 over there. There, the corner, when they didn't build it, a builder bought it and, did the tear down, partial tear down, build up, and then got a variance or a user permit. I didn't know the difference of those until recently, to be able to enclose the carport and screened-in porch to be a garage. So the corner of their garage is 5 foot to the property line. Their overhang, however, isn't, because it's another 1.5 feet. So they're, actually, if you look at height-wise, they're close to the property line as well. But they have no problem with it, and this was a mistake. I mean, that's all I can. I mean, I was sick about it. He was sick about it, because as a 27-year active, retiree from the military, I am like about rules. I really am. I mean, I think my parents knew at the beginning by sending me to Catholic school and then to being in the military. I get this. I understand rules.
Okay, thank you. Any questions for the applicant or the speaker? Thank you.
Questions based on the photos we've given you. We wanted you to see, there was a comment about carports. There's a picture of an original carport, which is at 2539, which is across the street. It doesn't show in that one schematic where they have the homes. Where's that schematic? This one. It doesn't show that that carport is actually on the property line. And we have a narrow lot. It's, you know, I'm at the curve as you're making the curve. I have a big backyard. It's tiered, and it runs into the creek. So you don't want to affect the water runoff. And then I took a picture of the 25 to 30-foot cypress, and its trunk is 6.5 feet to the property line, or something like that.
Okay, thank you.
Hoping to just make the point that if you look at the first picture in the stack, that you can see that the two properties diverge from each other, the two structures, her carport and the garage on the left. And the only really offending part is that leading left-hand corner of the carport. It amounts to a triangle of about 2.5 feet by 8 inches.
Thank you.
Madam Chair,
Mr. Melnick,
I'd like to make a motion.
please.
Okay. So I'd like to, in case V1112517UP1, I'd like to move that the Board of Zoning Appeals adopt the resolution as advertised in this case, with the conditions as stated.
The alternative?
Yes, exactly, the alternative resolution.
Second.
Moved by Mr. Melnick and seconded by Mr. Smith to approve the alternative resolution, which is approval as advertised. Mr. Owen.
I'm going to support the motion. I think that a good faith construction error, just in my own evaluation, is a necessary but not sufficient reason to do something like this. The bulk of my evaluation is that the reconstructed version is also not offensive to the neighbors. But I wouldn't want anyone to get the idea that just because there's a contractor error doesn't mean that the BZA isn't going to make you rip up all the concrete, because I'm sure as heck ready to do that sometimes.
We have.
But in this case, it seems to me that if this had been the original proposal, I might well have approved it as well.
And I
Mr.
feel the
Melnick.
same way. You know, like, that's the danger of this kind of thing. But, you've given, for me, an adequate explanation. You seem very sincere. And, but I totally agree with Mr. Owen that we have to be very careful in this kind of case. But just due to those reasons, that's why I made my motion.
Thank you. All those in favor?
Aye.
Opposed? Thank you.
Thank you.
Thank you very much.
Next case, please.
Sorry. B-11261-17-UP-1. It's a use permit request to permit a setback of 9 feet from the deck to the rear property line instead of 21 feet as required, and a 4.7 feet to the side property line instead of 6 feet as required, for a new rear deck in the R6 zoning district in the premises known as 3207 19th Street North. And the staff recommendation is to adopt the attached resolution granting the subject use permit with conditions.
Thank you. Questions for staff?
Madam Chair?
Mr. Owen.
Is this for application for something that's already been built or something that's proposed to be built?
It's
there.
It's there, but it's being replaced by a wood deck.
Oh, I see. So it's a proposal that's in contemplation of replacing an existing structure that itself would need a permit but doesn't have one. Is that right?
They got a variance and they had a building permit for the previous one, for the previous permit. I'm sorry, for the previous deck.
I don't see that.
The previous deck vested or not?
See that?
I think that's the right one.
Am I confusing? I'm
Right,
sorry.
perhaps the applicant can clarify. I believe the deck is in place already.
The one that we're being asked to approve has already been built.
It has a wooden deck on the back.
The previous one was metal. In the same location, this one is slightly larger.
So there was an approved metal deck.
With a variance.
Right.
Just a moment.
My question's for staff. So is it staff's understanding that there was an approved metal deck and that it's been replaced by a wooden deck,
That's my understanding.
and that the replacement should have received a use permit?
Yes.
And that's what we're dealing with now. Moreover, my next question is it staff's understanding that the wooden deck is, in terms of its size and placement, identical to or not identical to the previous deck?
I believe it's a foot wider. I believe the first deck was 10 feet from the rear, and this one is 9.
Was the deck part of the original approval that we did a couple years ago?
Madam Chair, I don't see any mention of the deck in the previous actions.
I don't think so either.
So I'm looking at the first page, previous BZA actions, November 14th, 2013. I just see mention of setback of 10.6 feet to the eave. I don't see the deck.
Right. Well, that was my question. Well, I'll ask the applicant. Okay, applicant.
I'm sorry. Madam Chair.
Mr. Owen?
Thank you. In the staff report, the previous BGA application says that it was a request in 2013 by the same individual who's now applying. Is that correct?
No,
No.
that's incorrect. The previous request was done by Paul Brown
Okay.
in 2013.
Thank you, Madam Chair.
Applicant?
Hi there, my name is Cynthia Blendu. It's Blendu versus the spelling up there. So a couple pieces of background. The house was built in 1940 and renovated in 2014-ish. From my understanding, when they did the renovation, they did get an approved variance for the deck that was added on as part of the renovation. I was not aware, and you think it would have come up when they did the plat. I'm not aware that it wasn't, and I'm pretty sure that when I was looking at the history that I did see that original or the 2014 deck that the variance had gotten approved. Between my mom and I, we probably came to the county probably 5 or 6 times throughout this process. The second piece of information is if I don't have some form of a deck where the current deck is, I have a 7-foot drop. So no matter what, I need some sort of landing to take me from that door down to the grass or the ground. So that's the two pieces that's one piece of background that I wanted to share. In terms of the deck itself, it is a little bit bigger. It did replace what I would consider a dangerous deck. Anytime it rained or snowed, it was slippery. So what I did is I replaced the deck that looks very like my neighbor's deck that you all approved for variances, and I actually think they're encroaching much more than the 10 feet line than I am. So they're much closer to the line, and when the gentleman came out to take the pictures from the county, I specifically said, hey, please take a picture of my neighbors who did get approved variances from this board, because they're encroaching much more than I am. I did not realize I needed a permit. I'm from the Northwest. I'm from Idaho. You do not need to have this. When I did put a fireplace in, or 2-gas fireplace, I did, of course, permit that. As soon as I found out that I did need a permit to do a replacement, again, this was not a build, I actually turned myself in. I think that should be on record that I actually turned myself in. I received a violation, and I've been trying since the January-February time frame to make this right. I've already had you all out come to check the structural integrity of the deck. So I've already started that process, and Damien was out for a second time already. And so far, we're working to do all that. So again, I apologize. I do have in the materials My neighbor complimenting on the design and the look of the deck versus what the old deck was. So their support. The materials that you have actually show that I only received signatures from a couple of my neighbors. I actually sent about a week or so ago to get the two neighbors behind me, 3208 and 3202 19th Road North, and I have the copy of the signature here if you'd like that for your reference. I did send that a few days ago to both Amanda and then Liliana, who the gentleman who came out to take the pictures actually said Amanda was not necessarily the right person, so I actually resent it a couple days ago in advance of this hearing. So again, it would be a huge hardship to have a 7-foot drop off from one of my doors. Again, really apologize for not seeking the permit in advance. I really genuinely did not know. And again, I did try to match the aesthetics to my neighbors. And lastly, they have decks that are much closer to the line than I have, and I'm sure you could ask staff how close they are to the line. The closest point, based on a new plat I had just for this session, is 10 feet. When I had done done it myself without an updated plat, I came up with the 9 feet. It's actually per the closest point is 10 feet to the line. And no matter what, with the placement of my house, given it was built in the 1940s, I'm never going to make that 21-foot setback. You'd actually have to carve off some of my house to meet that setback.
Questions? The house is for sale?
Yes, if I look like this, there's a reason. I have a newborn, 1 month old, and I'm moving to Dallas. As of tomorrow morning, I leave at 5 a.m., so the movers are here. So I'm trying to get this all done. So you can imagine the stress of starting this process in January, and I am now moving with a 1-month-old, 2 large rescue dogs, and starting the 19-hour drive tomorrow morning.
Good Lord.
So, but I am here.
Questions?
Madam Chair, I have questions for staff.
Yes.
The applicant referred to a deck next door approved with the variance?
2.
I'm sorry?
There should be 2.
But I'm asking.
I'm not aware of them. I personally can't speak to the variances for the properties next door. I didn't do the research for this, so I'm not familiar with it.
Because the staff report says 1820 North Jackson Street has a use permit, but that's not even close to.
So you can see in the picture there, that's my neighbor, 3203 right there, and then sorry. Sorry.
It's okay. So is it material to our deliberation that we don't know whether this deck was approved with the variance or not, the original deck?
Madam Chair.
Mr. Owen?
This is Ms. Malice has posed a question which has at times perplexed me when I've read staff reports. The statute commands us to examine, I forget the exact term, consistency or compatibility of development with surrounding neighborhoods similar to the structures and properties and surrounding that's a tongue twister. Similar to the structures on the properties surrounding the subject property. Oftentimes I think the staff lapses into a mechanical review of other approvals that they have in their files and look at, distances and setbacks, which is what they measure, appropriately so. But that's the information that's easily accessible to them. But I actually think that the statute may not put that in the center. I think that the statute may actually ask us to make a more holistic evaluation. So this is a good illustration, I think, of that principle. So I don't actually, as long as these structures are not in violation, we don't believe that they're in violation, the precise mechanism by which they're approved isn't as important to me as how the neighborhood looks as a result. And so that would be the way I would personally evaluate it.
So in this case, you would posit that it's irrelevant whether this is a rebuild or not. It's simply, would we approve this deck in this location?
I'm relying a little bit on the staff analysis that, for example, this is allowed by use permit and not by variance. But I think that if we're in the use permit world and we have neighbors who are all saying this looks like the rest of our neighborhood, and we with our own eyes looking at these photos come to the same conclusion, then yes, I think that's enough. If those things weren't the case, if there was a dispute about that, or our own evaluation led to a different conclusion, there might need to be more analysis. But I do think that replacing a deck with a bigger deck, or replacing a unapproved deck with an approved deck that's bigger than the unapproved deck was, I mean, in the end, it's sort of like the previous one. You know, they definitely broke the rules, but the new one was also happened to be okay. And so I think I'm willing to apply the same general analysis here.
Any other questions or comments? Thank you. Mr. Smith.
I move that the Board of Zoning Appeals adopt the attached resolution approving the use permit in V-11261-17-UP2, subject to the conditions listed in the resolution.
Second.
Thank you. Moved by Mr. Smith, seconded by Ms. Malice. All those in favor?
Aye.
Wait.
So he say one, and I believe he said, did you say two?
I said two because I was reading UP2. No, I think it said 11261. Hopefully, that's the case that I'm.
17 UP1.
Yeah, and then.
Oh, there's a difference in the.
Oh, yep, there is. In the motion versus their staff report.
That says UP1 and UP2.
The resolution also calls it UP2, but the caption on the staff report calls it UP1. And because there was the prior approval alleged to have occurred in 2013, UP1 would duplicate that. So the normal, I'd ask unanimous consent that we refer to this as V-11261-17-UP2.
So ordered. All those in favor?
Aye.
Aye. Thank you.
You know, I'm okay?
Have a safe trip.
Drive safely.
Thank you.
Don't hold to 19 hours. Take as much time as you need.
I start to work on Monday. Thank you.
Next case.
Dash 11262-17-UP-1. It's a use permit request to permit a setback of 16.5 feet from the porch base instead of 21 feet as required, and 15.3 feet from the porch eave instead of 19.5 feet as required, to the north Bryan South right-of-way, and to permit a setback of 15.1 feet from the wall instead of 25 feet as required, and 14.4 feet from the eave and 12.9 feet from the planter box instead of 21 feet to the 18th Street North right-of-way. Permit a setback of 2.5 feet from the wall and 1.3 feet from the eave to the rear property line instead of 10 feet as required, for a new 2.5-story dwelling with a detached garage. And the staff recommendation is to adopt the attached resolution granting the subject use permit with conditions.
Questions for staff? Applicant, please.
Good evening. Thank you for your time tonight. My name is Dave Springberg. I'm the owner of 1801 North Bryan Street. Staff, Amanda Clement, was very, very helpful with this process, as well as DES. You have the report, and I'm not one to argue with Amanda's recommendations, but I just wanted to bring a couple things to your attention. The property was platted in 1919. It's 50 feet wide. It is 5,500 square feet. It's a corner lot. All the lots in the same section are the same interior and corners. So if I were one lot over, I wouldn't be here because everything that's proposed would fit in an interior situation. The fact of being on the corner and having to be 25 feet from 18th Street is what brings me here primarily today. We started by surveying the street and doing a survey of all the homes on the block to get a setback of the house and the porch to put it in line. We tried to be thoughtful about the massing of the house and the compatibility both in style and sizing with the rest of the neighborhood. There were two other items I wanted to mention. I did reach out to all the neighbors on the block on Bryan Street, all four corners of the intersection, the entire block of Bryan Street, and the neighbors to the rear. The major concern was a tree. That's not the house.
No, we're trying to fix that.
But there's a tree on the front left-hand corner of the
Thank you.
property. I think you can see it in the back there that the neighbors wanted preserved. I worked with Vincent, the county arborist, and we documented that it's one of the items that we're going to try to preserve as part of the construction. And there will also be new curb and sidewalk along that 18th Street side right there. And I can address any questions you have about architecture, stormwater, siting, the whole thought process, anything you'd like.
Any questions for the applicant?
Yes, I'm just looking through your letters of support here, and I'm not seeing nearby neighbors. Is that correct?
I contacted all of the neighbors on Bryan Street, both sides of Bryan Street, and the neighbor to the rear. So I think one of them that has a 27th Street address is actually, it's an owner and non-occupant. The neighbor to the right, Tom and Irene, came in and saw Ms. Clement at one point, but they didn't sign a letter. They weren't opposed. They said, whatever you get approved is your business, but,
1807?
1807 would be, that would be adjacent, I believe.
Yeah, we have a speaker.
Double lot next door. They were one that was concerned about the tree.
Okay.
1807 is one of the speakers.
And 2503, the one directly behind you?
I contacted them. I sent everybody the entire use packet by, you can see the letter, that they were all signed by the cover letter. They were all sent by certified mail, the entire application process. And I had everything sent back directly to Amanda so that they didn't feel that I was pressuring anybody to approve something.
So you didn't talk to neighbors, you just sent letters?
Several. I provided my email, my phone number. I did have several conversations with different neighbors. Tom and Irene next door, Michael diagonally across, Bill directly diagonally across the street, who's been there since the 50s, and several emails back and forth about the tree with Michael across the street.
Because I think that okay. All right, thank you. The other question I had was about the garage placement. Could you just review for us why you can't put the garage further from the side?
The original plan was to put a one-car garage with in that corner sideways with a driveway coming off of 18th Street. This is where DES got involved and said there's an alleyway that runs off, and that a driveway needs to be 25 feet from the entrance of that alleyway. It has to be from any right, and they consider that a road. So it wasn't possible to get a driveway in, so we enlarged the garage to allow for the parking.
Enlarged the garage? You couldn't just move it over?
I couldn't move it back because we're wiggled between the house and the garage. I wanted to move it sideways and put a one-car garage in the driveway, but we couldn't make that work because of the distance it had to be from the alleyway. So we're using the alleyway as our entrance into a two-car garage.
Other questions? Mr. Owen.
I'm just curious about your the financial disclosure statement that was in your application. There's a question number 3. It says list the names, addresses, and nature of interest of all persons having equitable ownership interest in the real estate to be affected, including, in the case of corporate ownership, the names of stockholders, officers, and directors, and of all parties in interest. And you list one person, David Springs, nature of interest contract owner, and no other information. Are there any other persons having an equitable interest in this property?
No, I own, my company is Sunnyside Development LLC. And I am the primary.
Sole proprietor?
Sole proprietor. No, I clarify that. My wife and I are 50-50.
Okay, so your wife has an equity interest in the company?
She does have an equity interest, yes.
All right, and does the company...
When this was applied, I had not taken title to the property yet, so that's an oversight on my part.
Okay, so at this time, the company has fee simple interest in the property?
Excuse me?
Is it true that at this time the company has total ownership interest of the property?
Correct.
Fee simple interest?
Yes.
And is there a mortgage?
No.
And the company is owned exclusively by you and your wife?
That's correct.
And there's no other, you're the officers and the owners and the whole shebang?
Yes.
Okay. And what's your wife's name?
Justine.
Okay, thank you.
Okay, I have two speakers. Thomas Hunter.
Hiya. My name's Tom Hunter. I live in Lion Village at 1807 North Bryan Street, right next door to the house that you see up there on the picture. Mine is the cream-colored one to the left. I've lived there for 32 years. Lion Village is a neighborhood which is in an incredible transition right now. It's being gentrified left and right, up and down. Over the 32 years I've lived there, I've got a stack of inquiries, probably that high, wanting to buy my two lots. My experience with developers is simply that they wish to buy cheap, sell dear, overbill the lot, and tell you what a wonderful guy they are, how much they've paid you for the price they sold it to you, they bought it from you for, and how good a guy they are. I'm opposed to this lot being overbuilt. Ask me a question.
Any questions?
Bravo.
Okay, thank you.
Are you on the side with the tree?
I am looking at this from Bryan Street here. This is south, this is north, west, east. I'm the next lot over on the north side of this house.
Okay, thank you. Susan Charlton.
Good evening, and thanks for your time. I'm Susan Charlton, and I live across the alley behind the house. Also, Jason Harrier is here. He lives in 2503 18th Street.
Address?
I'm sorry?
What is your address?
My address is 1804 North Barton Street. On this picture, I'm glad you put this up, the Harrier's house is the white one on the corner to the right on the picture. My house is that square roof next to the Harrier's house. What you can see in this picture is the tree that I care about, which is not the tree that I think has been the subject of this discussion. The flowering white tree there along the alley is 4 or 5 stories tall. It shades my yard from the western hot sun. The garage that is proposed under this variance requires that tree to come down. It requires the variances and the use permit that are requested in this proposal require almost every tree on the lot to come down. And as Tom said, it requires the overdevelopment of this property. Now, the developer bought the property knowing it is a narrow lot and knowing that it is on a corner that is subject to variances. Variances exist for a reason. Now, we're actually delighted that this property is going to be redeveloped, but we think that what has been requested is excessive. I think the coverage of the home is going to be too large, and I'm very concerned about the location of that garage because it's going to take down, actually I've got a letter with a picture that shows you this tree that provides shade and oxygen and something nice to look at that's not going to be the same when it comes down and a garage goes up in place. If I can just sum up. We oppose the variance, in particular the setbacks proposed and the construction of the garage, and I think the Harriers, my neighbors, also agree.
Thank you.
Jason didn't sign up to speak.
Thank you.
Madam Chair.
Mr. Owen.
Ms. Charlton, when did you learn about this item being on our agenda?
When I received a letter from the zoning board about a week or two ago.
Thank you.
Any other questions? Thank you.
Thank you. Discussion?
Madam Chair.
Mr. Smith.
Mr. Springberg, I'm wondering if you'd be interested in
Working on this.
yeah, sitting down with Ms. Charlton and Mr. Padova Italia. I forgot his name, the 1807 right next door. I just focused on the hat. And talking to them about different ideas.
I just want to make comments. I'm not looking to start a fight with anybody. When I did, I try to be as very open about this, and I did send out certified letters. I just yesterday got 3 returned from the post office. They attempted.
I'm not making any comments about the past. I'm talking about the future.
No, I understand, but I did. It was first, hey, I welcome the discussion. We started early.
Against developers, by the way.
What's that?
I don't hold animus against developers.
At thick skin, that's okay. I understand that, and I understand their concerns about the trees, and I understand their concerns about the garage. But I would have wished to have this conversation, and I tried to have this conversation.
But you do have carrying costs.
Yes, I do, exactly, and I understand their concern about the garage, and I I agree it's not an ideal situation. It would be a by right situation if it were one lot over, but it is what it is, and I'd be happy to discuss the garage. I think the house itself is in keeping, and Tom and Irene, they own 2 lots. The third one that was to their left, they sold to a developer a couple of years ago and built a large home on it. So.
Madam Chair?
It's all,
Ms. Malice.
I know that one of the speakers spoke about there being too much house here. I just want to review sort of what the status is in that regard. This house conforms to coverage requirements?
Yes.
Just a sec. This is R6. I believe it does. I believe it does.
Okay, we need to be sure about that.
There's a plat. There's a attached plat.
We've figured out that so from the standpoint, it's not an issue that this is too big for the lot?
No, we're below, and even we're below maximum building footprint, lot coverage, height. The setback on the left side closest to Tom and Irene, we're actually a foot further than we need to be, 9 feet instead of 8 feet.
We're way under.
Yeah, we're under, even though it's an undersized lot. All of that, it's a setback. It's primarily a setback to the 18th Street side and the position of the garage.
Okay.
And I understand the position of the garage, and because it's a corner lot, and you have to be 10 feet from the alleyway, but there is an alleyway.
Right.
Madam Chair, might I ask him how much time he
Mr.
thinks?
Smith.
2 months or 3?
Whatever is necessary. Ideally, I would like to be able to resolve it as quickly as possible. And I'm honestly disappointed that nobody contacted me. I did make the gesture, and that I'd like to make.
Looking forward. We're not talking about the past.
No, I understand. And I would very much like to neighbor, but to get the information now, I'm just kind of a little put off or just thrown off balance, so to speak.
Think about the future, then.
Yep, absolutely.
So the question,
Can I ask a question of the board then? If we were to approve the house without the garage, would that be acceptable? Is that a possibility?
you have the wherewithal to do that without drawings in front of?
Assuming that's acceptable.
You can approve less, can't you?
You have the drawings for the house, correct?
Right.
So if it's nothing's changing.
It's just omitting the garage.
So the condition would delete that from the plan submitted. Less is more.
Is that a proposal that you're making?
Wait, excuse me?
Are you making that proposal?
I am with just, I'm trying to, again, thinking it in my head about, because I'm very considerate of neighbors and the trees and such, and my question would be, I would have to provide parking. I'm sorry, I would have to provide parking. So if it were not a garage, the question would be, where would that parking be provided? If I have 15 feet on 18th Street, is that acceptable, to put 2 parking pads off of 18th Street? Or if I had to come off the alleyway, even if I didn't build the structure, it still might result in the losing of the trees.
Right.
And so,
You're thinking out loud right now.
yeah.
Still need time to work it out. What's feasible, and work with your neighbors as well.
I'd be happy to do that.
Yeah, I think that's the better course. Now, your neighbors have to understand that, you have rights as well as they have rights, and so, we're not saying that we disagree or agree with one side or the other at this point.
Mm-hmm.
We're just trying to take the easy way out and see if you guys can agree.
I always try to agree, and sometimes you have to agree to disagree, but we always try. Yes, absolutely.
Okay, do I hear a motion?
Are we talking July or August?
Just saying.
Would you be willing to take a deferral to August?
August is late. I think that, the issue is one, there's one issue, and it's the garage, and I think that's something we could we're either going to agree or disagree very quickly about.
So the other option, of course, is June, if this happens very quickly and you are not adding to your proposal but subtracting from your proposal, or making adjustments sufficient, then you can have drawings back to staff.
I guess my question is, it goes back to the driveway, because I understand the neighbors' concerns about the garage, and I can totally understand that, but I have to be able to provide parking, and so.
You need to investigate that.
And so, exactly, but I think that's.
And you may have to talk to DES as well, just to get.
It's really more of a DES issue, I believe.
Okay, July.
Well, all right, the chair relented. I am willing to make a motion to defer this to July.
Second.
No.
Just read it out.
I was just preparing to make a motion. I move in the matter of use permit V 11262-17-UP-1. I move that the Board of Zoning Appeals defer this matter to our July hearing, July 2017 hearing.
Second.
Moved by Ms. Malice, seconded by Mr.
Sorry?
Owen.
Know what day of the
It's the 19th, my birthday.
Madam Chair.
Hold on, we're in the middle of something here. Right? Are you?
I seconded the motion, then I have a question for staff.
Okay, go ahead.
So there's just a discussion about parking. This is R6, is that right?
Correct.
And is there a parking provision requirement in R6 for a single-family home?
One space.
One space per unit. And that's not waivable by variance, right? Thank you.
Okay, we're good? All those in favor of deferring to July?
Aye.
Thank you.
Thank you.
Okay. Next case, please.
Make good use of your time.
B-11263-17-VA-4 is a variance request to permit a maximum fence height of 5 feet when in the front yard instead of 4 feet as required, and to eliminate the requirement for a 6-foot fence around a pool. The staff recommendation is to adopt the attached resolution denying a variance for the 5-foot tall fence within the front yard, but approving the variance to eliminate the requirement for a 6-foot fence around a pool.
Madam Chair,
Mr. Owen.
I have a couple of questions for staff. First of all, does staff have any kind of statement you want to make on this before we get underway?
Only that my understanding is that there was a time when the building code and zoning ordinance requirements were in sync on this matter. Building code is updated more regularly than zoning code, and right now there's an exemption from the 6-foot fence requirement, such that the safety measures that we believe it was intended to address are done so in a different manner. So that relates to partially our recommendation for the fencing around pools. The standards also that are referenced in the zoning ordinance are now no longer applicable to private swimming pools. So I think it's another instance where clearly an update is in order.
Go ahead.
Part of the situation here, which I think the applicant can probably speak better to, is the difficulty in having one fence serve multiple purposes and being subject to 2 different heights for one fence.
My reading of the ordinance, of the zoning ordinance, is that for a single-family home that has a pool, a fence around the pool is required, and that requirement references the pool ordinance. Is that right? And the pool ordinance speaks exclusively to commercial pools.
Exactly.
It makes no reference to residential pools.
That was not always the case.
But reading the two jointly, one could come to the conclusion that under the zoning ordinance, that reference creates a 6-foot fence requirement around the pool. Is that right? Although staff presented some supplemental materials today by email, I still could not find the building code requirements for private swimming pools. Could somebody read out or specify what are the building code, the applicable safety requirements in the building code that are being applied in this case?
I spoke with one of the reviewers. I don't have anything to read from. This is just in a conversation with people that enforce it. Is that there is a 6-foot barrier requirement as well, but there is an exemption, and I can't remember the letters and numbers, per certain standards that allow you to not have to do the 6-foot fence.
If you have a pool cover of a certain kind.
Right.
Which the staff is asserting that the applicant in fact has.
Right.
So then finally, do I correctly understand the staff recommendation that you are recommending that we approve a variance that completely forgives any fencing requirement at all? Is that your recommendation?
Around the pool.
Around the pool. That what amounts to a safety requirement in the zoning ordinance, that you're recommending a variance that vitiates any fencing requirement around this pool?
Sort of.
Okay.
Because there's a condition, so there's 2 things happening. There is a condition of the recommendation for approval of the fence around the pool is that the fence in the front yard is maintained, because part of the rationale is that there be one fence that's of the same height that encloses the front yard and is the barrier around the pool. If for some reason the front yard fence goes away, then we feel like then you have to go back and conform with the 6-foot standard.
Okay. So the totality of the staff's expectation is if we followed your recommendation, that there would not be a total forgiveness of any fence ultimately around the pool.
Be 4 feet.
Condition
4 foot.
3.
Right.
Condition 3. Okay. Resolution.
And then just related to our immediate previous item where I asked about can a variance cure a parking requirement, and you said no, at least cannot cure the 1 space per unit in an R6 lot. How come we can reduce a safety fencing requirement, but we can't use a variance for parking? Like, what's the limits on what we can use variances for?
My understanding is that we no longer permit parking specifically to be handled by the BZA through a variance process. We did in the past, so we have some older cases with parking variances. I'm not sure when that change occurred, but for parking in particular, it's my understanding that those are handled by the board solely.
We're sure that we have the legal authority
for height?
For the fencing?
Yes.
What if instead of taking the staff recommendation, we said, look, like the building code, you just don't need any fence at all? Do we have the power to do that?
Sure.
Okay, thank you.
Other questions of staff? Mr. Melnick.
So one of the it looks like one of the hardships that you're saying here is the division of the front yard and the rear yard, but it seems to me there could be gates. So it's not an absolute division, but I know there's a lot of backyards and front yards where there's gates, and isn't it true there's nothing against having a gate in the fence? Because I can see if
it's in the regulations.
Okay.
The gates.
Okay. Yeah, because the way that's set forth, it just looked like, this barrier that was insurmountable. So, okay, thanks.
Other questions? Hear from the applicant, please.
Hi. So I'm Dan Abstry, and this is my wife, Melissa. And we appreciate all of the staff's work, in particular on this issue. There was obviously some confusion that came out of this in our kind of good faith attempts to figure out whether zoning applied, building applied, or both applied, kind of in going through this process. And clearly safety was obviously our biggest concern. I have a 2-year-old and a 4-year-old, and I work in the field of taking care of people who've drowned. So this is incredibly important to me on a very personal level. If it wasn't for the fact that these safety covers that meet the building requirement, and I apologize, we don't know the numbers off the top of our head either, though they are referenced in emails that we've discussed before, they're superior to a fence. My 4-year-old has walked out onto this cover. They can hold about 600 pounds. And so they're better, which is more important to myself and my wife, as well as obviously to our neighborhood. The question of the fence out front is purely aesthetic. This was the idea that we live on a significant slant, as is everyone on 17th Street, and my goal was to have a completely horizontal fence in line with the house. My understanding of the regulation is that if a single panel is going to be over 4 feet, and that would therefore be in violation, I can't claim any hardship other than aesthetic hardship on that. That was purely an aesthetic choice, and if that's the rules, we're comfortable with that recommendation, obviously. With regards to the division point that you brought up, we have a unique property in the sense that our side yard, which would be visible if you're facing the house to the right, essentially functions as a backyard, partly because we're one up from the corner house. And so our goal in not dividing, obviously we could put a gate in between, but our goal was to have a large kind of field space for our two boys to grow and play in. And that's why having a 4-foot fence and then a 6-foot fence would essentially divide the field. And as we all know, in Lion Village, having property outside of a house is something that's rare, and that we value greatly in designing this project.
Questions for the applicant?
Madam Chair, did you consider the possibility of placing a fence at the edge of the patio around the pool so that the grassy area is separated from the pool area and thereby keep the entire yard contiguous?
That, I suppose, would be an option if one was forced to do that. It would still not create the flow that we wish. I also don't think it would add anything to the safety requirement. And looking at where we're coming from with this, with the code pointing towards no clear private requirements, and us having a product which is generally accepted both by your building specifically and in the country in general as a superior safety product, we were hoping that the variance would be an acceptable solution to this, also understanding that the entire yard will still be enclosed by a 4-foot fence.
If there was no fence, if you learned tomorrow that the zoning ordinance was changed by the county board and so there's no more reference in the zoning ordinance, and so that no longer required any fence at all, would you still want to build a fence?
Yes, for the opposite reason, though, because if you go up Kirkwood, you can't get onto Key, and so 17th Street is essentially an industrial cut-through. So I would want to protect my children from going out into the street. So a fence is there regardless. We have a temporary fence erected currently to keep our kids kind of corralled.
So
there would be a fence no matter what.
So no matter what, you want a fence in the back of the sidewalk to keep your kids in the yard?
Yes, I also think it would be aesthetically, if you look at again, because of our property, the house that's on, it's technically addressed on Jackson because it's on the corner. Their side yard is contiguous with our front yard, so the flow actually from us having a fence flows perfectly into their fence. You can see a letter of support for them, but if you also look at the pictures that I provided, again, aesthetically, this works very well for the neighborhood, where if we were in the middle of the street, this would jut out and then potentially jut back in.
So for the fence in the front, what's the relief you're asking from us? You want the fence to be taller than 4 feet? You want the fence to be...
One part.
You want a piece of it to be taller than 4 feet?
Yeah, let's say there's 3 panels that would comprise the entire fence. One would be 2 feet, one would be 3 feet, one would be 4 feet, and one would be 5 feet, and so they would all be at the same level, the way it slopes.
There's a 2-foot grade between the side of the driveway and the edge of the property. So in my desire for a single line aesthetic, either I would start at 2 feet and end at 4, or I was looking for a compromise in between. I must admit I'm naive to these things. I work in a very different field, as does my wife. So if any inch over 5 is, or any inch over 4 is not going to be acceptable, then it's not acceptable. Again, that's aesthetics.
Thank you.
Madam Chair?
Ms. Malice.
I'm not familiar with the building codes on pools or pool covers, but pool covers, I assume, work only if they're used. And so I'm sort of surprised that that's an adequate measure, because that relies on you to always have the pool covered if you're not in the backyard. Is that right?
That would be correct. With all due respect, there's probably no greater incentive than your own 2 children to keep the pool covered. And again, I have told parents that their children have died personally. I understand this world. Our keys, we have 2 keys.
You literally flick a switch to cover it. You don't have to
Yeah,
oh,
it's automatic.
You just flick a switch.
The keys are kept at a height that we can barely reach them. I am exquisitely careful about this. It would be much easier for someone to unintentionally or perhaps in an inebriated state climb a fence and fall into an uncovered pool than it would be to get through this.
So that's helpful, because I'm not familiar with
And
that.
I apologize, we don't obviously know the building code, but this has been building approved. Again, we came to
It
this.
literally said in our permit, like, you do not need a fence, this type of pool, and it cited the number is in place of the fence. So like, when we looked up our permits online, it literally told us we didn't need to put in a fence. And so we just assumed this was safer.
It is safer.
More expensive than a fence.
Oh, much more expensive than a fence, but this is our children.
Madam Chair, may I ask staff a question?
Ms. Malice.
Staff's objection to a taller fence in the front is strictly a by-the-book objection, or is there more to it?
Yes.
A by-the-book objection. So we have the latitude to approve a taller fence in this case. And roughly, what's the distance of the fence?
It's 25 feet from the corner. So again, if you were looking at the picture, we're starting from the left of our driveway. It's 25 feet to the neighbor's property. It's also, I think it's 31 feet to the house, or roughly those dimensions.
So it's from 4 feet to 5 feet over 25 feet?
Well, because it's a 2-foot grade, we were looking for a compromise in between, feeling that a 2-foot fence would look strange and also be an inadequate barrier. So that's why I started at 3 and went to 5.
3 to 5.
That was just the average would be 4.
But if you went 4 to 5, the average would be higher.
So there's a 2-foot change in grade, and we can do anything with it that would meet the board's approval.
It wouldn't, if you went from 4 to 5, the average would be greater than.
I think that what he's trying to say is he wanted the fence to be a uniform height across.
Yeah.
But he can start higher.
I could, but then we started higher, we still have to drop, we have to drop 2 feet if it was going to be completely horizontal.
We could have a 6-foot fence and solve both of the problems at the same
Yeah,
time.
we could go 6 to 8, but I'm not sure that was the look.
Okay.
Yeah.
But if you went 4, you're starting at what number? 2?
I was starting at 3 and going to 5 as a compromise because the average would be 4, as would be the middle point, but 50% would be higher than what meets.
Just a 4-foot fence is a little more secure if that's my only.
We could also do a 6-foot maximum and step off, which would be what we'd be stuck doing as a 4-foot option.
I appreciate the aesthetic that you're
but
talking about.
that's aesthetics. That's only one part of this discussion.
But I appreciate your wanting to maintain
The house is horizontal. It does in some ways make sense to match the house to the fence. But if we step it, we step it.
Why you have to start low.
Okay.
Just have it more gradual.
Mr. Owen.
I'll just state my opinion, because I think this is one where we need to add up to 3 or 5 or whatever to get a motion. So my view is that I'm willing to completely waive any safety fencing requirement here. But I hope that it gets really high on the list of things that we change in the zoning ordinance, because I think we're not super well qualified to judge safety, pool safety here on the BZA. Doesn't go usually with our training. But on this particular parcel, I'm willing to do it. I see no cause for a variance personally for the front fence, for the aesthetic, whatever. I mean, we have lots and lots and lots of hills in Arlington, and a lot of people step their fences, and I'm just not super thrilled about having to level out everyone's fence. So basically, I'm willing to forgive the apparently outdated pool fencing requirement for a covered pool, but I don't see any reason to ask these applicants not to obey the normal rules for front yard fencing.
Other comments, questions?
May I speak one more thing with regards to that? Obviously, I'm grateful for your insight into that, and hopefully, again, safety is the biggest concern in this discussion, so anything that can be done to make pools safer is a good thing. These covers are vastly superior. With regards to the question of height, obviously we're not asking for everyone, we're asking for us, which is why we're here. The unique situation of being the next to corner lot is the only reason this works in the aesthetic. If you look at the trees that go along it, there are these gorgeous 10-foot tall trees lining the property next to us. So again, the jut out fence is not there. Nevertheless, a step fence is not a hardship. I could never claim that it was.
Okay, thank you. Motion?
Madam Chair, just make sure I understand.
Ms. Malice.
Basically, in approving the variance to eliminate the 6-foot fence, we are eliminating the requirement for any fencing on this property. But we are saying if we deny the variance for the 5-foot fence, we are saying if the applicant chooses to fence, he must do the fence according to existing ordinance.
So my position is not the same as staff's. So my position would be to approve the resolution without condition number 3.
Right. That he be required to build the fence according to zoning.
I would not require them to build any fence whatsoever.
If he chooses to build a fence,
Chooses to build a fence,
it would be according to normal zoning.
correct. That's my personal view.
Well, then you don't know. Oh.
So I would delete
What about condition
number
4?
3.
The condition 3 goes away.
Yeah, I would delete conditions 3 and 4. That's right. Oh, 1, 2, well, let's see.
And?
I would delete all the conditions.
So, yeah, he
I
needs.
mean, he can do a 4-foot fence by right.
Period.
And essentially, that's what Mr. Owens is saying, that the pool is off the table. We don't have anything to say about that. I don't like the language either, saying we're going to grant a variance eliminating a 6-foot pool fence requirement. So I don't. It's not needed. It's not needed. You don't have to say anything about it. I think it's.
No, we have to say it.
Well, I mean, I don't. We don't have to grant or. But essentially, we're just saying build a fence by right on the front or any place.
Build the fences by right.
So how do you, what sort of motion do you have to address the application, which requested a variance?
I'm ready to make a motion.
Step out and we'll see what you.
No, he's coming up with. Peter's coming up with.
I'm ready to make a motion.
Mr. Owen.
I move the text of the resolution provided by staff through the end of the whereases clause with the following additional. Now, therefore, be it resolved that the BZA hereby approves variance case number V-11263-17-VA-1, comma, to eliminate the requirement for a 6-foot fence around a pool, period.
I'll second that.
Okay. Mr. Owen.
Not that I'd like to, but.
Motion made by Mr. Owen, seconded by Mr. Smith, as amended, as rewritten.
So I would ask staff if they think there's any questions of interpretation or enforcement that would be caused by that language.
No.
Okay, thank you.
Because essentially, we could do nothing. I mean, we're essentially doing nothing, right? But we have to do something because it's an application.
It's as if they had no pool. We're making it as if there was no pool. And then they can build what they would otherwise build.
Okay. Is it clear?
It's, Madam Chair, it's clear, but I think you sense the trepidation among all of us in terms of publicly eliminating what we have commonly understood to be a really important safety feature in a pool.
You might not have had a pool cover at your home when you grew up.
Other There was no pool cover on Lake Michigan.
Other powers have already made that decision, so.
Froze periodically, but
Their lives in Lake Michigan, too.
I've encountered
Okay.
a pool cover in my time.
Moved and seconded as rewritten. All those in favor? Aye. Thank you.
thank you.
Next case.
I have to go to the back.
Okay. Okay.
Okay. B-1114-17-UP-2. It's a use permit request for a setback of 9.8 feet from the right side property line instead of 13 feet as required, and an aggregate side yard of 13.8 feet instead of 21 feet as required for a new two-story right side addition and a rear addition. And the staff recommendation is to adopt the resolution granting the use permit with conditions.
Questions from staff? Other than, are these any changes from 2016?
I'll verify this at the moment.
It appears that they didn't bill within 1 year, so I'm assuming.
Expired, I believe.
Okay, okay. Can we hear from the applicant, please? Could you verify why you're here?
Yeah, hi, Ronald Rubio, applicant and owner. The prior use permit that this board granted expired before we could begin. It's the exact same proposal, exact same proposed resolution by the staff. It was very helpful, so I'm happy to answer any questions, but otherwise.
Okey doke.
Madam Chair,
Mr. Melnick,
I'd like to make a motion.
please.
Okay, so I'd like to adopt the resolution granting the use permit with conditions in case V1111417UP2.
Second.
Moved and seconded. Moved by Mr. Melnick, seconded by Mr. Owen to approve. All those in favor?
Aye.
I abstain.
Ms. Melnick abstains. Next case.
B-11264-17-UP-2. It's a use permit request to permit a setback of 10.7 feet to the rear property line for a second floor addition. The staff recommendation is to adopt the attached resolution granting the subject use permit with conditions.
Are there any questions of staff?
I have a question.
Ms. Malice?
In the table of the staff analysis of the various setbacks, am I correct that this would be the lowest setback that you've identified
Yes.
by 16 feet, approximately?
Looks like the lowest one is 16 feet.
And this one would go down to 10, so.
Any other questions of staff? Okay, is the applicant present? Good evening.
Good evening. I'm Steve Colby here on behalf of Kelly Johnson. She's unable to make it this evening. The project consists of a less than 300 square foot addition on top of the existing building footprint. The existing building footprint was expanded, I believe, in 2003 under a previously approved rear yard setback. No foundations will be added during the project. It's merely a continuation of the existing building walls straight up. I'll be happy to take any questions.
What is that noise?
So, Madam Chair?
Mr. Owen.
Do you have any information about, I think this is not in the staff report, do you have any information about the rear neighbors at 5310 and 5314 North 27th Street and their views on this?
Ms. Johnson did try to contact them, but because of her schedule, she was unable to. She did, however, receive all the approvals from her neighbors on 26th Road.
Do you know how she reached out to the neighbors behind?
I believe she just knocked on the doors when she travels quite a bit. She knocked on their door when she was home. I believe she left them a note, and that was never responded to.
Other questions?
When did the, can I ask staff a question, Madam Chair?
Please.
Can staff tell us when the letters were mailed to the abutting neighbors?
I don't know the exact date of when those go out.
Okay.
At least over a week ago, but I don't know the exact date.
More than a week ago?
Mhm.
Okay. Thank you.
Madam Chair.
Ms. Malice?
So we have concern when there's building taking place that may directly impact a neighbor, and we don't have the neighbor's views on that, and we don't know why we don't have the neighbor's views. If it's because they don't care and are all right with it, or they somehow missed the notice. And so that gives us some pause, and I think we're trying to process that right now.
Madam Chair?
Mr. Smith?
Just to kind of follow up on the question of staff with respect to the mailing. The house directly behind the directly behind the applicant, which is 5310 27th Street North, would have received a notice.
All the adjacent properties received notice.
One follow-up real quickly. Do you, I imagine it's too quick, but do you receive in your office any return non-deliverable or any indication that any were received from 5310 as not being deliverable or?
I do not know that.
Okay.
What is, are you the agent for this property, the builder, neighbor, friend?
Construction manager.
Construction manager, thank you.
Madam Chair?
Mr. Smith?
If the matter is with the board, well, I'll just say, I'm not entirely happy with the way that notices are done to adjacent landowners and the posting, but be that as it may, I'd still move that the Board of Zoning Appeals adopt the attached resolution, in this case approving the use permit in V-11264-UP-17-UP2, subject to the conditions that are listed in the resolution, as this is a straight-up build, and it's a small lot, and there's really no room in the back to do anything else.
Is there a second?
I'll second.
Moved by Mr. Smith, seconded by Mr. Melnick. Discussion?
I just note that this is a good example of our very much ongoing discussion about getting better comfort with how notices are done for everyone.
Hence my reluctance to defer to July.
Right.
Thank you very much. Okay, all those in favor?
Aye.
Aye. Thank you.
Thank you very much.
Welcome. Next case, please.
B-11265-17-UP-1. It's a use permit request for a setback of 2.8 feet from the wall to left side property line instead of 10 feet as required. for an alterations to an existing enclosed porch. And the staff recommendation is to adopt the attached resolution granting the use permit request with conditions.
Thank you. Questions for staff? Applicant, please.
Hello. I'm Susan Kelly. Tonight I'm here along with my husband Richard Kelly, and we are the new owners of 2674 North Upshur Street. We are here tonight to request a use permit to keep an existing portion of the house, which is within the setback requirement. The room has been there for over 50 years. The home was built in 1950, and as the years went by, the home became in significant disrepair. Interior and exterior conditions require extensive renovations or a complete rebuild. We opted for a renovation design in keeping with the neighborhood and the natural beauty of the surrounding Zachary Taylor Park. The room in question is a fully enclosed conditioned space that used to be used as a sunroom, so I don't think I would accurately call it a porch. It really is part of the home. It has always been our intention to repurpose this room for use as a home office. An office is a real necessity for myself and my business. The room is within the setback requirement and therefore non-conforming. Since it is adjoined to the house, it of course then makes the whole house non-conforming, which prevents any exterior renovations without the permit. As you can imagine, this greatly impacts our entire proposed construction according to zoning rules and regulations. Our use permit request is to renovate the exterior of this room in question and thus the larger house as well. What that's going to include that you see there is changing the existing first floor elevation, raising the ceiling height and constructing a new roof, although the current roof is a pitched roof like this, and the new roof will be a flat roof and will not be higher than the existing pitched roof, and replacing the siding and the trim on the exterior. We can't relocate this room to another area of the property. The lot itself is very challenging, as was evidenced in the previous picture. And so there are a lot of limits on the ability to add to the existing structure. Challenges of the lot include that it's located on a very tight cul-de-sac and is a pie-shaped lot. Therefore, the physical buildable area is extremely limited. The home is also surrounded by a resource protection area on 3 sides, which further limits the development. And just behind the proposed renovation, the lot drops off over 50 feet. Therefore, you can't build on that slope, and even if you did, it's also in the RPA. So lots of challenges there. As you can see in our packet, we collected 13 testimonials of support from our neighbors, including that of John and Linda Beth Doby, who you will hear from tonight. They own the property adjacent to the room in question and are here to speak in support of this. That is it.
Questions? Okay, thank you.
Thank you.
The aforementioned John and Linda Beth.
Good evening. I'm Linda Beth Doby. My husband couldn't be here this evening. He's home with our children. So we heard from the Kellys, like February or March, when they first ran into problems with this. We have a email distribution for our street that we maintain. We have a yearly picnic where we get together and we all maintain it. And so immediately they let us know that they had a problem. Everybody basically emailed me because we do live on the side where the sunroom is actually adjacent to our property. And when we moved in 1995, and it's been there the whole time. We've not had a problem with it. So we told our neighbors we were fine with it, and so you have 13 total neighbors who have said that they're fine with that construction. We're happy that, unhappy that our former neighbor moved, but happy to have a new family in and to be able to use the lot to, with their growing family. So,
thank you. Questions? Thank you.
Madam Chair?
Ms. Malice.
Question for staff. The proposed change says that the proposal is to convert the existing enclosed porch, but then there's discussion later about enclosing the porch in the discussion. This, if I understood the applicant correctly, this is an enclosed porch that is conditioned. So when did it stop being a porch and become just a room? And is it material that the use of the room is going from some porch to office? If it's a conditioned space already.
It's never been a porch, and we've never called it a porch. We had called it an existing conditioned sunroom. Yeah.
Questions for staff to understand the law.
Okay.
So
I haven't read it.
Right. So, I believe this was then mistakenly added or misinterpreted when we received the application, or that we probably never had a chance to change to the correct language of the request.
So we're in agreement that this isn't an existing part of the house.
Correct.
So the 1976 porch zoning actions by the county board are not, in fact, relevant to this project. Are we all in agreement about that?
I'm not familiar. I wish I could be. I didn't work on this report.
Madam Chair?
Mr. Owen?
I believe that the porch regulations in the zoning ordinance have nothing to do with this application. And it's because I believe that I'm now going to make a motion to approve the use permit.
Please.
I move that the Board of Zoning Appeals adopt the attached resolution approving use permit V-11265-17-UP-1.
Second.
Moved by Mr. Owen, seconded by Ms. Malice to approve. All those in favor? Aye. Thank you. Next case, please.
Why that was even before us.
B-11266-17 UP-1 is a use permit request to permit a setback of 18 feet from the wall to the rear property line instead of 25 feet as required, and 17 feet from the eave instead of 21 feet as required, and 24 feet from the wall to the front property line instead of 25 feet as required, in the R10 zoning district, in the premises known as 4405 Detmar Road. And the staff recommendation is to adopt the attached resolution granting the use permit request with conditions.
Questions for staff?
Madam Chair?
Mr. Owen?
Is there a speaker on this item other than the applicant? Are there any speakers?
Have one.
Okay, thank you.
Thank you. Applicant, please.
Good evening. My name is Jeff Kelly, and my wife Lily and I own the property at 4405 Ditmar Road. We bought it in 2003 and have been through various stages of remodeling. And it is our request at this time to put an addition on the left side of the house. We will not be encroaching on the setbacks on the left side, but being that our house was built in 1933, it's it is closer to the property line than what the current rear setbacks allow. So our request is just to be allowed to build that side setback to the current rear of our home, just so that everything's in a line on the back side there. So, thank you.
Questions?
Chair, according to the staff report, there are no letters of support from your neighbors on this.
The property behind us is a park owned by Arlington County. The property on the right side of us is the White House that you see down there at the bottom is currently owned by a developer. And the people on the right side, the left side, which are closest to our addition, are the Jenkins. I spoke to Ray Jenkins about this. He had no problem with it. But as I went back over the last 2 weeks several times to get a signature from him, he's working, he's gone, he wasn't available. So they're very private people, and we talk a couple times a year. So that's about it.
Madam Chair.
Mr. Smith.
Briefly to follow up, thank you very much, because your knowledge of their name
Helps a lot.
was a pure indicator that, yes, you had done that outreach. And sometimes people don't sign things, but
Correct,
that
yeah.
statement was an indication that you had done the best you could.
Thank you.
Just a question for staff.
Ms. Malice.
In the discussion of the proposed changes, it talks about the long-term plan for the space as a main-level bedroom. Is that material to what we're talking about today? Is that something that we should question?
Aging in place, but it has nothing to do with it.
Okay, can you rephrase that again? Can you?
On page 2 in the section called Proposed Changes, in the middle of that paragraph, it says the purpose of the addition at this time is to be a sunroom. The long-term plan for the space is a main-level bedroom. Does that have any relevance in terms of the ordinance that we're looking at?
Not necessarily.
Okay. Is that a true fact?
That is a true fact, yes. At this time, it's going to be a sunroom, but it will be probably a bedroom in the future, yes. An aging in place opportunity.
It's interesting, but not germane.
It's not relevant. We're just checking to see if it's relevant to the law here.
Yeah.
When we're finished with the applicant, I have a comment to make.
Any other comments? Okay.
Thank you.
Mr. Owen.
So I have no doubt of the good faith of the applicant on this particular parcel, and I'm not. Apparently, even the AV equipment doesn't agree with me, but the park behind this set of properties is really lovely, and the neighbors I observed when I visited at 4415 have a deck outside the back of their property that's right next to where the proposed addition would be, and I can't tell if the use of their outdoor space in that location would have its view shed of the park blocked. But I think that I'm just super concerned, even though I don't doubt the good faith of the applicant and their outreach, about not having heard from the neighbor, because I think that a reasonable person living at that property might well think that this is a serious detriment to their ability to take advantage of the park behind. So I'm not going to be inclined to vote in favor of this use permit because unless there's a neighbor contradicting me, I actually think that it's not a reasonable encroachment on the neighbor's land or the neighbor's enjoyment of their property on their part of the land. I think that there's a lot of place where the applicant's parcel is large, and there's a lot of different configurations, and I'm just not I'm not comfortable. That's why I asked if there was a speaker. I'm a little surprised that we don't have opposition on this. And I guess they could be neutral, they could be supportive, they could not care, they could be getting ready to move and not want to cause a fuss, who knows? But just objectively speaking, it seems like it's a worse deal for the next door neighbors than is typical for use permits in my view. So I'm not going to vote in favor of it.
Any other comments? Motion?
Madam Chair.
Mr. Smith.
I move that the Board of Zoning Appeals adopt the attached resolution approving the use permit in V-11266-17-UP1, subject to the conditions that are listed in the staff resolution.
Motion moved by Mr. Smith, seconded by Mr. Melnick. Any other further comments?
Madam Chair, I think, again, we're put into this bind of not having neighbor input. And Mr. Owen certainly makes a compelling case that this neighbor is particularly would be severely impacted, and I'm just distressed to be in this position again that, we don't have firsthand knowledge of his intent, and I'm becoming reluctant to support this.
Okay. Other comments? We have a motion to approve. All those in favor?
Aye.
Opposed?
No.
No.
3-2, approve. Thank you. Next case, please.
B-11267-17-UP-1. It's a use permit request to permit a setback of 2.4 feet from the wall to the rear property line instead of 25 as required, and 1.2 feet from the wall to the right side property line of 10 feet as required for a two new two-story accessory building. And the staff recommendation is to adopt the attached resolution granting the use permit with condition.
Questions for the staff? Applicant, please.
Good evening. My name is Mitchell Moss. This is my wife, Celine Caro. I'll be brief. We're here because I made a mistake. It was an honest mistake. But let me backtrack a bit. I moved to Arlington from New Orleans in 1999 when I joined the Foreign Service. I immediately went overseas and stayed out for 16 years straight. I purchased this house in 2002 when I was back on language training, and came back to live in it for the first time in the summer of 2015. I was assigned to go to National Defense University for a year. It's a great house. It's a small house. It's 912 square feet. It's a classic Arlington two-story brick neo-federal structure. It's a 7,200 square foot lot. What is great about the neighborhood, what I've always liked about the neighborhood and that lot is it's got beautiful trees. The trees are from the era in which the houses were built, the early 40s. So when we came back, we looked at what the options were. We didn't want to participate in the McMansioning of Bluemont. We wanted to keep the trees, and so we decided to keep the house as it was, but we needed an accessory structure in the backyard. We thought a lot about what we could do. During the course of that year, our neighbors, our rear-facing neighbors, the Butlers, built a structure roughly 2.5 feet from the property line, 16 by 10 or 12, I'm not sure. And that helped us decide, well, let's build a small structure. We decided on 12 by 16. In between finishing NDU and starting my current job at the State Department, I had 2 weeks of leave. I poured a slab, and I built this structure. Before building the structure, I took the drawings to the zoning office and the permitting office. I wanted to be straight and right with Arlington County. I was told I didn't need a permit. I told them I wanted to build it to code. They said, fine. They said the only restriction was you cannot exceed 25 feet in height. I said that wasn't the plan. So I built the structure. By late June, at the end of the 2 weeks, the structure was intact. It was in place with the dormers and the basic form of the structure as you see it today. The first complaint, and I talked to my neighbors about it, the county came out in late June saying there was a complaint, and I was at work. I said, please visit the building. I've been completely transparent and cooperative with the county at every step in this process. I was told there is no problem. The setbacks are fine. The height is fine. You're good to go. I said, please take a look at, I want this to be built to code. Do you see any issues? No, it's fine. In July, working weekends, I finished the roof. The structure of the roof was there, but I put a sheathing on the roof and put the windows in upstairs and two of the windows that are on the two side walls. There was another complaint in late July. I said, please come out. They looked at it again. They said, they measured, they looked, they took pictures. They said, you're fine. I said, okay. I was still at work, doing what I could on weekends. In mid-September, I guess early September, I got another call saying that someone had called to claim that I was building an unpermitted 3-story structure. I said, please go look at it. Take pictures, tell me, if I'm off base here, I want to know. I was told 1 foot setback on each side, stay below 25 feet, you're good to go. He said, they looked at it again, they said, you're fine. I know many of the zoning and permitting inspectors by name. I asked for something in writing, and they said, well, we don't do that. I said, fine. In early December, I got a call. I was on TDY out of state. There was another complaint. And I said, please go look at the structure. But I said, does Arlington County do any kind of mediation? Because I clearly have an unhappy neighbor. I don't know who it is. I don't know what I can do more. I played by the rules when I built this thing. I'm not sure what I can do to placate this person. And he said, no, we really don't have a program like that. So it was only in mid-December that I got a phone call. The reason we are here is I was not informed of and did not know about the change in the zoning ordinance in 2014 that defined story-and-a-half structure requiring a 6-inch setback for a dormer and that the dormer would be less than 50% of the roof width. I didn't know about that. It's my mistake. I'm a Foreign Service officer. I'm not a contractor, and I'm not an architect. I'm from New Orleans. In New Orleans, the worst thing you can do is build something ugly. That offends your neighbors. So I don't think I did that here. I did the best I could. I'm not sure what else I can do about this. I have drawings here that show if the board were to deny the waiver of the use permit, I'd have to spend about $20,000. I'd rip the top of the building off. I would raise the ridge line. I'd lower the knee walls. I'd reduce the size of the shed dormer, but it would essentially be a more imposing, taller structure.
Thank you. Questions for the applicant? Okay, thanks. We have several.
One question, Madam Chair. Have you had an opportunity to see the comments that were from the butlers, Patty and Ken Butler?
I did not, no. I did not. I submitted all of this by the March deadline. I've heard nothing from the butlers since then. Yes, that would be great. Thanks.
While we deliberate, if you'd like to take a look at what we have in front of us.
We have speakers. John Bauman.
Good evening. My name is John Bauman. I've known Mr. Moss for 18 years. We were Foreign Service colleagues and served together in Nigeria and in Germany. But we're friends. I'm retired from the Foreign Service now, and I provided some advice and guidance to Mr. Moss. We have a home that we've owned for 25 years in Ashton Heights, not the same neighborhood. But I've been through the Board of Zoning Appeals process twice, And in 1992 and in August 2015, most recently, when we converted the house for senior living. And so I knew what was involved. I respect the process, and I provided him with guidance from the get-go. Even though it's an accessory building, our application was actually for changes to our residence. I just wanted to say in Mr. Moss's behalf that I've been extremely impressed with his diligence in trying to comply with all of the ordinances that are relevant to this case. His outreach to neighbors, there's a long list of neighbors who have signed a petition in support of the structure. His respect for the canopy, which is something that I think is important in Arlington. And I'm not from New Orleans, but the aesthetics of the building I think are very nice. The windows are actually architectural salvage, and I'm into historic preservation, so I think it's nice to see that they're used that way. It explains, in part, the height of the building, which was intended to be a 1.5-story structure under 25 feet and in compliance with the definition of an accessory building. So it was when he realized the knee wall in the upper level was too high that he found himself out of compliance and went through this process. I hope you'll support his application. Thank you.
Thank you. Ken and Patty Butler.
So hi, I'm Ken Butler. This is my wife, Patty. We're the property immediately behind this structure. Respect the service of the previous two speakers, but I have a very different understanding of the events that occurred over the last year. You've seen my package. I'd like to highlight there are 25 neighbors, including the 3 neighbors immediately adjacent behind this, that have signed our petition in opposition to any variance for this property. I've learned a lot about the scope of the BZA tonight, but our biggest issue with this property is it does not have a building permit to build it. And the definition of a shed is 1 story, 256 square feet to be used for tool storage or similar use. This is a 2-story building. If you count the second floor, it's over 256 square feet, and he intends it to be additional living space. I apologize that I'm nervous. This is a big issue for my family. We are having a big problem getting the building department and the inspection services division to address the lack of a permit problem, because they defer everything to zoning and the BZA, and they're waiting on the results of this. Second main point. We disagree with a lot of things that are not only in Mr. Moss's package, but also the staff recommendation. We think they're incomplete, and they misrepresent what our views as neighbors would be. If he wants to go through the permitting process and make a major addition or build an accessory building, we're fine with that. We don't want a 2-story building without a permit. And my last point is, and I've hit on this before, he intends for that second story that looks into our master bedroom to be habitable by people. So it's not a shed as it's characterized, it's a person living in the second story 2 feet from the property that's going to be looking into where my wife gets dressed in the morning. And I'm surprised we've gotten this far. Object to any variance, but I thank you for your consideration.
Thank you very much. Louis Finkel.
Good evening, and thank you for your time. As you noted, my name is Louis Finkel. I live on 7th Street, 1 block over. And from my front porch, I can see this structure, which indicates that, I guess by measurement, I don't know if this is the county's measurement or the homeowners, as being just over 22 feet. I would argue to you that it's probably closer to 26, 27 feet. I can see it from my front porch as I look across, and there's elevation changes that probably provide for that. make no mistake, this is really not an accessory building, and the staff report compares this to several other accessory buildings in the neighborhood. Those are garages. Those are garages where people are storing tools, where they're putting cars. This is a townhouse being put in the backyard of an R6 neighborhood. This is a 2-story facility with those doors being someplace between 10 and 12 feet tall, with a second story where this homeowner intends to put plumbing and electricity upstairs. You don't put plumbing and electricity upstairs unless you're going to have out-of-town guests or possibly try to treat it as an Airbnb. And once you approve this, once you allow them to go forward with this project, or this project that they went forward with in advance of your approval, then they are in a place where they can do whatever they want with it. There's nothing that stops them from renting a room. As we know, you can rent rooms in your home up to 3 or 4 to anyone, and there's nothing that would stop them from using it as an Airbnb. I would urge you to reject it. This is not really a storage building. This is a whole new structure being built on a single plot.
Thank you. That's the last speaker.
Madam Chair,
Ms. Malice.
I have a couple questions for staff. Definitions seem to be an issue here. Is the county define a shed?
No.
That's a colloquial term.
Yes.
So the county does define accessory building.
Yes.
Could you just review what the definition of an accessory building is?
Do we define that, or we just have parameters for it? Sorry.
It's on the front page.
So the definition for accessory building is a detached subordinate building, the use of which is clearly incidental to that of the main building or to the use of the land.
Okay, so accessory buildings are more than just garages. They can be any structure with uses inside.
Yes.
Can they have electricity?
Yes.
And plumbing?
Yes.
Okay. All right. So by your definitions, what's been built here is an accessory building?
Yes.
Madam Chair, can they have a kitchen?
No.
So they can't just have anything.
No.
Right.
No kitchen.
Right.
And that's the thinking behind that, is that with a kitchen it would be
Dwelling. Right.
As opposed to accessory.
Where in a garage you may need to wash your hands, or if it's a workshop,
Exactly.
you may need a some way to wash your eyes if you're contaminated, et cetera, et cetera, et cetera, and a bathroom. So plumbing and electricity are not don't make it a dwelling.
Exactly.
Thank you.
One more question. So the applicant recounted some interactions with staff over the course of the last year or so. Are those consistent with your understanding of events?
Yes. I learned of this when our inspectors went out.
First time?
It was the first time, but and initially they thought it was okay because they were only concerned with the 25-foot maximum. I didn't realize it took a couple of times to get to the section that related to the dormer width and the knee wall height, and that was when we learned of that problem.
And prior to 2014, has those been an issue?
I didn't realize that change was that recent, but yes.
That was the date that was... What? It said in 2014, a zoning ordinance amendment clarified the definition of a half-story and codified the specific requirements regarding placement and size of dormers.
Right. So then just the absolute 25-foot would have been what we went by.
And dormers would not have been relevant. This isn't the first time we've had a situation like this where an applicant appears to have acted in good faith, and yet the result has put him crosswise with his neighbors.
Oh, the zoning ordinance.
And the zoning ordinance.
Madam Chair.
Mr. Owen.
And the further complication is that now the frustration level has built up so much between the neighbors, and indeed the structure has built up so much, that compromise is far more difficult than it would have been if everybody had understood how it was going to play out. And that's very frustrating, I'm sure, to everybody who's here tonight on this item, as well as to us. You know, I live in a townhouse development, so there's 20 feet behind every window in my back of my house to every window in the back of my neighbor's house. And it definitely affects my lifestyle and theirs. And that's what I bought into. We have a lovely house, but it's not the same lifestyle I think that people in other parts of the county want to have. And so I think there's a tension, there is some tension in my mind between what the applicant has pointed out they could do by right, and the ordinance does allow some similarly functionally obnoxious, from the neighbor's perspective, functionally obnoxious structures, but it does appear that the ordinance requires this particular, from the neighbor's perspective, functionally obnoxious structure to get a use permit. And so my job as a member of the BZA is to evaluate, is this compatible? Is this consistent with the way the neighborhood normally operates? Is this, tree preservation is one of our criteria, but so is the habitability of the neighbor. So of the neighbors. So, if I wonder if everyone were starting from scratch and pieces of paper as opposed to a built structure, how much could have been dealt with by the next door neighbors having a chance to carefully evaluate the by right options and what this applicant might otherwise do, and maybe this applicant would not build the windows facing in the back. And so I have the impression, I'm not really good on aesthetics, but I have the impression that the general view is that this is aesthetically pleasing, sort of in the abstract. If it were floating in space, we would say it's a beautiful object. But I think the neighbors are quite reasonable to be concerned about those windows. And now we seem to be past the point where, already the applicant is committed to the energy efficiency of those windows, and that's as asserted in the written materials that's sort of essential to the whole siting of the dwelling. And then there's this ambiguity about how often and what the neighbors care about isn't really plumbing or electricity or a kitchen. What they care about is how often is there going to be some person up there, that we're able to read the T-shirts of, and vice versa. So, we had a similar situation earlier tonight where we were able to send the neighbors back and see if they could agree on a compromise, and that seemed feasible. Here, it seems really hard, and so no matter what we do, we look like the whole system, the county system looks like very oppressive government. Either we're telling someone that they have to make enormous changes to a structure that they asked for a year over and over again. Is this okay? Is this okay? Is this okay? And kept being told yes. On the other hand, if we allow it, then, I think the other neighbor can say the BZA doesn't apply its standards to an obnoxious window. So it's really tough.
Madam Chair?
Ms. Malice.
Just walk through for a moment what the by right option would look like?
I thought I don't know if it's in your packet, but
Can you point it?
there's certainly discussion of the fact that if the pitch of the roof was changed, or if adjustments were made to remove the dormers, per the applicant's testimony, that the overall height of the structure would actually increase.
By right, it would be taller, but it wouldn't have dormers.
Yes, or they would be
Smaller.
narrow.
Yes, the dormer would be 50%.
Not occupying as much area.
Right.
Right. And the structure will actually be around 3 feet taller than what it is.
How many feet?
3 feet taller than the actual structure.
All right, so those are the 2 points that we have. We have what could be built by right and what is existing today. You know, if we asked him to tear it down, he could build something else by right that
is taller.
Taller. Would it have as many windows looking out? Wouldn't have the dormers.
They would be narrower.
I wonder, is the dormers the main concern here? The dormer
I think it's
windows?
also the knee wall height.
Yes, I believe.
Side.
I think the concern is the dormer, that they're over the 50 feet, the 50%. I'm sorry, the 50% what's allowable in a dormer. That is the concern. That it's the only. That would be the only objection, I believe, or the only thing that it's preventing it from being a 1.5 story.
Madam Chair, I think that's not a technicality. I think the reason for this provision in the ordinance is that at a certain point, dormers take up so much that they just become an extra story. And so the county has to draw a line somewhere, and they've drawn a line at 50%.
We've gone through dormers in the county and other zoning codes. So one solution would be to remove the dormers.
George, just make them smaller.
Right.
Make them fit. I mean, if that would be one, and that would be a question to the neighbors whether that.
They could do it by right.
So if they take the dormers out, how close are they to by right?
I don't know what the percentage is. They've just got to get the percentage of the width to 50%.
And the applicant has said that they've planned that out, and that the applicant has said they're prepared to make the dormers narrower, not get rid of them, but make them narrower. But to do that, the other engineering that they would do would be to make the structure slightly taller as well. So what the applicant is saying to us is there's no version of event. The applicant is asserting that there's no version of events in which the dormers facing the neighbors go away completely. But there might be less square footage of dormer facing them, but the whole building would be taller. And the neighbor has read that and has said, "Come at me, bro." Right.
Well, we can play that out. We could ask the applicant to come back with those drawings.
They don't need to.
They don't need to. They don't need our permission.
Do I get a chance to say something after other speakers, or am I done?
Madam Chair, if it would be clarifying, then I think it would be permissible, but not
Is there
additional.
a point you want to clarify in terms of your position?
I think.
You have
Come up to the
mic.
microphone, please.
I understand my neighbors aren't happy with the structure. I didn't know they weren't happy until I went to speak to them in February. this building represents a great deal of effort and work. Changing it is going to represent a great deal of cost. I can't rebuild it. I can't move it. It's built on a slab. And I built it every step of the way by the rules of Arlington County. That's why I did a FOIA to get the history of the complaints and the response of the zoning and the permitting offices. In terms of use, I had a disabled adult son. He has passed away. He qualified for a Virginia disability waiver, and occasionally he needed a place to stay. He died in January. I went to the zoning office in November to talk to them about what are the possible uses. Could my son stay here occasionally? And there was a big discussion, and they came back and said, yes, that is a permissible use of this space. If the concern is use, my neighbors can complain to the zoning office about misuse of the space. There are 30 days per year in which a guest can stay there. Otherwise, a family member can stay there. My son is now deceased, so that's out of the question. I regret that my neighbors are displeased by the structure. They at no point approached me about this. I filed my paperwork on this in March with 17 signatures from neighbors, 13 of them with adjacent backyards to the structure. 14 of them. Only 3 are from across the street with direct line of sight of the structure. So my neighbors had 2 full months to get something in that would be in the record that I could have looked at when this was published last Friday. One option that the sheds, I built that shed and poured the pad to exactly match the shed that my neighbors built. The ridge line of my shed exceeds the ridge line of theirs by 7 feet and a couple of inches. I don't know what more I could have done to abide by Arlington County's rules. And, Mr. Butler helped me raise the first wall on this shed and loaned me a tool. So at some point, things stopped going so well. I'm not sure what I could have done better or what else I could have done to try to play by the rules of Arlington County and the neighborhood.
Thank you.
Mr. Owen, no, sir.
I actually remembered that I had a clarifying question for the neighbor. Mr. Butler, can I ask you a question?
Yes.
In the written materials you submitted at the beginning of the meeting, you say, we as affected neighbors get hours to respond with this letter, and you compare it to a longer period of time that the applicant had to prepare. Why did you say you had hours to respond?
It'd be 30 hours, but we were notified about 2 weeks ago that this issue was headed to the BZA. On Monday night, I went to the website to research this process to see how it was, and I found the agenda and the write-up from the staff and the owner saying his side of the story. That was the first time I saw it. Then we immediately started writing our rebuttal, which you have in front of you right now. So that was about 30 hours ago.
So how did you first get notice about the hearing happening at all?
Informal conversations with Mr. Robert Love that it would be coming up, that it would be referred to the BZA, asked about the process, and the next answer was, you will be notified by mail 2 weeks ahead of time. And in the piece of mail that we get, there is no indication of, it says you can show up and get a speaker notice. It does not say submit your rebuttal to these bodies before.
And but you did get the letter about 2 weeks ago.
We did.
Okay. All right. Thank you. That's helpful. I appreciate that explanation.
Can I just a clarification? Somebody asked if shed was defined. A shed is clearly defined on the county website as 1 story, less than 256 feet, to be used for tool storage or playhouse or other similar use.
Thank
you
you.
can go to the website and see that definition.
Thank you.
It's not defined in the zoning ordinance. It's not defined in the zoning ordinance. I believe he's talking about maybe information about residential additions or projects for building. But shed is not a term that's defined in the zoning ordinance.
Maybe a different part of the county regulations that have that definition, but not the part that we're being asked to interpret.
Right. Okay.
time to think about it.
Madam Chair,
Mr. Owen.
we were not provided with an alternate resolution for denial, right?
Yeah, but it's expensive.
Madam Chair, I move that the Board of Zoning Appeals, with regard to use permit V-11267-17-UP1, deny the application.
Is there a second? It fails for lack of a second.
Madam Chair, let me try the.
Mr. Smith.
I move that the Board of Zoning Appeals adopt the attached resolution approving use permit V-11267-17-UP1, subject to the conditions that are listed in the staff report.
Is there a second? I'll second.
Madam Chair,
Mr. Owen.
I'd like to offer an amendment to add an additional condition. Number 3, that the structure not be occupied overnight.
Mr. Smith, do you accept that?
I'm offering it generally. It would need a second.
That's what I'm saying.
Anyone could second.
So you're offering.
Not
an
offering it
amendment?
for unanimous consent.
You're offering an amendment
I'm
to the
offering an
motion.
amendment to the main motion to add a condition number 3,
Second.
that it not be occupied overnight.
Is there a second? Hearing none. Thank you. With the main motion for approval. Further discussion?
Yeah, I'm unhappy that we're in this position.
I think we all are.
You know, we really do try, and if you were here earlier in the evening, try to work towards a compromise where we can come up with a solution that is more palatable to more people. In this case, the county had a large role in making this happen, and at this point, we're faced with making the applicant pay for a mistake that was not his, versus making the neighbors sort of pay for a mistake that wasn't theirs. That's not a great place to be. If somebody else would like to speak for a few minutes, I'll figure out how I would vote on this.
My sense is that part of what makes the situation so challenging is the possibility of human occupation during certain hours of the day. I think daytime use of this structure is not as objectively unreasonable as overnight use. And so that's why I made my motion.
Madam Chair, I appreciate that, but here's the thing. Typically, we might defer the matter and have the parties discuss this to find out if that in fact is true. We're sort of guessing now on what might or might not be less objectionable. So if we were trying to figure out what conditions might make this existing building less objectionable, then we would go the deferral route and actually get evidence as to what those things might be. So we might put the challenge out that the parties get together and basically walk through some options. Given that we're inclined possibly to accept the building as it is, are there conditions of use that would mitigate things? And if there's not, then we're back to where we are today. So I guess a conditions of use something that could be discussed if the board was willing to go in that direction of a deferral, and if the parties involved thought that that would be possibly be beneficial. But we have a motion on the table right now for
We do.
acceptance.
We do. I think that if we were inclined to condition it, I didn't agree with an overnight. I could see possibly where you conditioned it that it couldn't be commercially rented in any way or something like that, but I don't.
Legal.
I support the motion, so it's hard for me to see, and I do think, unfortunately, for all the reasons that you stated, Ms. Malice, that we're here because of honest disagreements, and particularly it's egregious to have had county staff involved, inspectors involved, who led the applicant to believe that he was doing something that was permissible. So that makes it very difficult, in my view, and very different from negotiating how to move a shed from one side of the yard to the other, as we did earlier.
Madam Chair, I might propose a substitute motion to defer if I knew how the parties felt, especially the neighbors. If either side felt that there was merit in further discussing it.
Mr. Melnick?
Oh, I was just curious, as to, for instance, you, Madam Chair, about not supporting the amendment, and I didn't second it. So, but is it enforceability that you're thinking about, this whole overnight condition, or what is the?
No,
or is it
I just
speculation?
it didn't strike me as being reasonable, given this is an accessory dwelling for a very small home, the purpose of which, as he said, initially might be for the use of a family member.
Okay.
So to me, it didn't make any sense.
Okay, thanks.
And Madam Chair, if I might, I made a motion, and of course, obviously, I support. It's not ideal. What could be done by reducing the size could result in a taller structure, but I'm not for attempting to limit its use other than what the law already limits for accessory structures, because it could be used as a ham radio shack, for example, and ham radio operators are known to operate late into the evening and overnight. Or it could be a reading room, and a person could read overnight, or for any number of reasons, meditate. But those are all lawful uses. It's not going to have a kitchen, so it's not going to be a dwelling unit. Now, can someone fall asleep in their shop, in their garage, in their accessory structure? Yes. Could they use it as a Airbnb? I don't know, but I would think that could result in a complaint by a neighbor and a possible zoning violation with respect to an occupancy issue. So, but I know what the alternative is something with a slightly smaller dormer and 3 feet taller.
Ms. Vaughn.
It's not a Creole cottage. It's not the most attractive thing I've seen. I know New Orleans architecture. I mean, it's okay. It's not bad. It's well done for a layman. But I'm not displeased by it. It's not so objectionable, obviously, as I made the motion. So.
Ms. Vaughn.
I just wanted to, I think it's been clarified, but I don't know if you intended to say accessory dwelling. I think you meant to say accessory building.
Accessory
So
building.
I just wanted to say that. And then second, actually, the chair said it.
Sorry.
And Airbnb or accessory homestay is not permitted in detached accessory structures.
Okay, thank you for that. Okay. I will call the question. We have a motion on the floor to approve. All those in favor? Aye.
Aye.
No.
4-1. Thank you. Next case, please.
B-11268-17-VA-1 is a variance request to permit the development of a lot that does not meet the width and area requirements of the R27 zoning district. And the staff recommendation is to adopt the attached resolution granting the variance.
Okay, so just to clarify, we're granting a variance that a dwelling can be built there. We're subsequently addressing the dwelling.
Yes.
And currently, there's no dwelling there, despite the picture.
There was a fire, I believe, so I don't.
Right.
Yeah.
Okay. Thank you.
Trail.
Thank you.
It's from
Any
Epic Tom.
other questions for staff? Hear from the applicant, please.
Good evening. And I promise to be brief because I know everybody's pretty tired. My name is Dario Davies, and I represent the applicant, Mount Zion Baptist Church. The church bought a dwelling that burned down that was next to their sanctuary that was on two non-conforming lots. The burnt structure after they bought it became a hazard, and the county asked that they remove it, which they did, not realizing that they would lose their rights related to the original structure that would be grandfathered in. So tonight what we'd like you to do is to approve a variance that allows them to basically rebuild the dwelling on the two non-conforming lots.
Okay. Questions?
Is the dwelling that you're proposing to build have the same footprint as what burned down?
I think it's a little bit larger.
Okay, so it's not, you're not rebuilding what burned down, you're building a new home there.
Yeah, I think they're going to by current regulations, and then they're also going to do an accessory building in the back. I don't think there was originally an accessory building in the back.
Madam Chair.
Yes, Mr. Malnick.
Just for consistency, have you all explored just using the exact same footprint? Just so you could say, all we're doing is maintaining effectively what was there. Has that been explored?
That was explored, but I think there were some issues in terms of how they want to lay out the lot. There's ordinances now, for instance, stormwater management, some elements of what we had to do to the site where we couldn't match the exact footprint of the other dwelling.
Thank you.
Okay, thank you. Other questions? Okay, I have two speaker slips. Harry Thompson.
Yes, my name is Harry Thompson. I'm the project manager for the church, and I just wanted to speak in behalf of the church. They did purchase a lot after the building burnt, and it was required to be torn down. It was unfortunate, but some of the additional regulations that are requiring the rebuild has caused us to possibly exceed what the square footage of the original house with stormwater management and various things to fit on a lot. So that had actually made the building smaller in the same footprint, and that's some of the things that we went through as a church to make the final decision on what to build.
Okay, thank you. Any questions?
No, I'll wait for staff.
Okay, thanks. Carolyn Navarre?
My name is Carolyn Revere, and I live at, I'm a horse from being here from 7 o'clock.
Sorry.
But I live at 1920 South Laurel Street, and if you go back to the original picture, you will see that that's my house in the absolute front of the house that burned down. And as you can see, my house, the back of my house will certainly abut the back of the proposed house that they want to build, which is fine. No problem with that. And I don't have any problem with the setback. The only thing that I'm concerned about is, now I just learned tonight that they plan on building a youth center. And as I say, the two properties abut just like that. Now, I am totally engulfed almost by that church. And so noise is an issue. And I want to bring up noise, for this variance. And what I'm trying to find out is, from the church, is what is it they propose to do to eliminate the noise? Because I understand it's supposed to be a youth center. And also, too, about a year ago, I went without electricity for 4 days. And this was because the church didn't check with Mrs. Levere, we're going to do this, we're going to do that. They installed a fence and crushed the conduit box that controls the electricity to my house. So that conduit box is right on that red property line to the left. And my sewer runs through that property. Now, I don't know, I'm not a builder, so I don't know how this variance is going to affect those two problems that I just mentioned. And I'm at a point in my life where I'm looking for peace. Do forgive my voice. I mean, I have trouble with allergies and everything, but peace is something that I don't get. So anyway, the church can accommodate me by keeping the noise down. And maybe I'll ask that question. What do you propose to do to eliminate some of the noise? Because I get it tenfold from that parking lot.
Ms. Levere, your time is up. We will ask questions, and you will have an opportunity to ask questions as well for the use permit portion.
Okay, very good.
Thank you. Questions, comments?
I was kind of startled to hear something about a youth center. Can someone from the church address that comment?
It's a home and it's being built, and there will be opportunities for the children to use spaces in the house for educational programs, ministry programs.
Private residence.
Not a youth center, no.
Is it a private residence?
It's not a private residence. It's going to be a youth.
It's
private residence.
It's a home that's owned by the church that will be used from time to time by the youth from the church. It's not a commercial building, no.
It's not a private building.
Is a family going to live in it?
But if are there going to be permanent residents?
No.
Okay, that's what we're trying to think. Thank you.
But it's being built as a home.
Correct.
Kitchen, bathrooms,
correct.
Bedrooms.
Correct.
But you're going to use it, but you're not going to, no one's going to occupy it permanently as you foresee right now.
Correct.
Mr. Molney.
So it'll be temporary occupancy, like if it's set out like a house, or will it or will there be nobody ever actually occupying as you would a house? In other words, it's not permanent occupants, but how about temporary?
It might, but right now there are no plans for that.
Okay, thank you.
Madam Chair.
Mr. Owen.
Question for staff. Is this lot unbuildable without a variance?
It looks like if it was the half of a semi-detached dwelling, that seems to be the only, or townhouse, that require 3,500 square feet. Those would be options. But because of what's next to it, that seems unlikely.
They could only build if the lot next to them also built at the same time.
Right.
Because if they just built
It would be one.
up to the property line, they wouldn't qualify. So with the land they control, this is an unbuildable lot without a variance.
Yes.
Okay. So under those conditions, my understanding is that Virginia law almost compels us to grant some kind of variance because we can't leave a parcel like this unbuildable.
Can I ask a follow-up on that? It's unbuildable according to current zoning.
Yes.
It could be rezoned.
Oh.
Oh.
Is it glupped to allow it to be rezoned?
Not one parcel in a just.
Low-density residential, I can't imagine. I don't know the districts off the top of my head, but
What, call it yellow? Light yellow?
Could be R5 or something like that.
it's going to be the same problem
You could build
for 4,600 square feet.
4,600, it'd be undersized.
Yeah.
It's too small.
Okay. So my next question, it relates to the draft resolution. The draft resolution refers to submitted plans, and I'm only keying into this because of another item later in our agenda. But we also have a use permit application right after this. And so I'm a little confused about what happens if we approve the variance as proposed with this resolution, and then at the use permit stage, we tinker around with what's going on. Indeed, condition number 4 on the variance is proposed to say the applicants shall obtain a building permit to construct the structures permitted herein by May 17th, 2018, or the use permit shall be null and void.
No, I think that's an error.
That's an error?
Yeah.
So, in 2015, before I joined the BZA, but on an item where I recently listened to a BZA hearing, what the BZA did in this situation was simply to approve a variance declaring this a buildable lot, declaring the lot to be a buildable lot, and then didn't specify any of the stuff. In doing so, they vitiated even the condition of requiring a building permit, which I think was a mistake on the part of the BZA when they did that the last time. Sorry, guys. But so they just said an unconditional permanent declaration that it's a buildable lot, and then left it up to the, I think there was a small by right option, which is not present here. But I wonder whether or not a much more abbreviated resolution is appropriate for this variance than locking it into the plats. So if you have any thoughts about that, I'd be interested in hearing them.
I think that gives you the most flexibility. Otherwise, you kind of have to join them together.
I mean, I still would probably be inclined to have a time limit on it. Because if it goes, because that's the problem we're going to have later tonight, is that there's an unquashable variance that maybe we wish we could have still had before us. So anyway, that was my question.
So, Madam Chair?
Yes, go ahead.
So we approved this as a single-family home.
Yes.
If there's another use, that requires another use permit.
That would pose a problem for the use permit request
Yeah.
because a non-residential use has a different yard requirement, setback requirement. So our understanding of this project is that this is a single-family home.
And not, no longer. You have new information.
Yes.
As do we.
Well, and I think to Mr. Owen's point, when you're talking about the variance conditions and the use permit conditions are pretty much the same.
In this case.
So in the variance, if it wasn't changed, we would be acknowledging drawings and submissions and height and everything else, as opposed to it's a buildable lot and we'll get to what you build next.
So, given a different use, having different setbacks, and so it does not affect the variance request.
Mm-mm.
Though the drawings definitely don't belong in the variance, because it could be a completely different structure.
Could be.
If there's different setbacks.
Right.
And I think if the intention, if the assumption was it's a single-family dwelling, a residence, and inadvertently perhaps we now learn of a different use, then you can have a variance that says it's a buildable lot and stop there until you have a different explanation. Either a commitment that a building, if approved under a use permit, is going to be a residence, or you've got a whole different set of issues. I can understand building it as if it's a residence but not using it I can understand the practicality of that, market value and all that, but that's not what we're dealing with.
Well, Madam Chair.
It's sort of bait and switch kind of thing.
Condition number 1 says, of the variance application says that the applicants agree that the project shall be constructed in accordance with the footprint shown on the survey and the architectural drawings attached to the staff report dated May 12, 2017. And this shows a house, bedrooms, kitchen, etc. I heard a representation they want to use the house, a home, as a youth center, which I don't know whether that's inconsistent with a house or not. I don't know that a house has to be occupied overnight, 24/7, or have anyone living in it, or have furniture or anything. You can own a house and you can pay the taxes, and so on and so forth. But I see the application saying they want to build a house there, and they may want to use it to entertain, to have youth come in and spend the afternoon or evening or whatever. But I see an application for a home. And until, and I heard that the neighbor who lives just below them, with her concerns about the representations that are made about what its use is going to be, and her concerns with respect to noise as a result of a use different than a home. There are noise ordinances. There are ways to deal with that, and there are ways to deal with a home being used as a commercial structure. But I see before me an application for a variance to allow the building of a home on a small lot, and then subsequently I see a use permit application that's going to deal with the placement of that home. So that's what I see.
Madam Chair? So the plans that we have are for a 3-story building, but the condition says no greater than 2.5. So don't we need different plans to grant this variance?
I guess if you follow the course of action suggested by Member Owen and strike the requirement to have the plans, you could eliminate that potential conflict.
But if we get to the variance, or to the use permit,
So we were always going to have this problem for the use permit because our recommendation is not to approve the three-story building.
but don't you, okay, so if you don't approve the three-story building, we can't approve anything if we don't have plans for a two-and-a-half-story building.
And the third condition limits you, so it's like 1 and 3 are contradictory. The plans are for a 3-story, but you're saying it can only be 2.5. That doesn't work. This is not ready.
I mean, it seems like we could work our way around granting of, or acting on a variance, but it doesn't sound like we could get much further than that, because we don't have plans for a
Two-story structure.
And so that, it just stops. It stops after the variance anyway. Maybe it would be better if we just deferred both items
Yes.
until some of these drawing issues are worked out, and also some of the new use questions are worked out.
If we are inclined to do that, my recommendation would be to hold off on acting on this item until we've heard the speakers on the use permit. And furthermore, that we should give as much guidance as we feel comfortable with to help everyone involved who has waited 5 hours to this point tonight have some sense of where we are on all this.
I have the same people.
Same people.
They have a right to speak again to the other items.
You actually didn't sign up for both, but that's all right. We can do it. Come on up.
Drawings basically reflect a 2.5-story structure. The problem is that it's, and this was going to be addressed in the special use permit. It basically, the 2.5-story structure does not meet the setback requirement. So what we're trying to do with the special use permit is waive part of that setback requirement. So it's not a 3-story structure like you're saying.
So, I'm sorry, go ahead.
Sorry.
Please finish your remarks. I didn't mean to interrupt you.
I was going by staff's assertion that the plans are for a 3-story building.
Well, and the third floor shows a bedroom with a bathroom.
Right.
Right.
There's a difference in the yard allowances for 2.5 versus 3. So because it exceeds the 2.5, it has to be farther from the right-of-way. The use permit is to allow the 3-story building within 25 feet of the street right-of-way. So if it was 2.5, that part of the request wouldn't be necessary.
So and just reviewing further, it does seem to me that there probably is a by right option once the variance is granted. The lot is 46 feet wide, but you could fit a skinny house in the middle of it if we waive the width requirements, because the depth is there.
Mm-hmm.
So this is just a lot bigger than they could do by right once they get a variance. And so my main view is that staff thinks it's too big just sort of as a structure and too close to the street. And we have a neighbor who maybe merits some further consultation on use issues for such a large structure. I mean, I'm basically inclined to, let you guys do what you want to do, but it's not nailed down. From my perspective, the variance is obvious. A variance needs to be granted. I don't think you guys I'm sorry, I shouldn't address this to you. Addressing my colleagues, I don't think that I don't think that what they're planning to do is just totally outrageous, but I think that at a minimum, I personally speak, I don't always, as they can see, I don't always win these votes, but I would want some condition language that better accommodates the neighbors' concerns. And I would want to have more time for that and possibly address the various issues that staff has raised. That's just where I am.
Other comments?
I would be inclined to defer this matter
July.
to July. Yes. Because as Mr. Owen said, I think that a variance request is in order, but until the use permit is worked out, the applicant can't act either in any case. So we might as well take them both together rather than try to cobble out a variance. I do think, I'm concerned about the neighbor's testimony about conduits and sewers running under her property, and I think she has complete right to be clarified if that's the case. I mean, you need to clarify with her, not with us, at this point. And staff may also know the answer to these things, but I think a deferral is in order to get the use permit pieces together.
And just to be abundantly clear, again, speaking for myself alone, the basic scale of the project doesn't really bother me. So I still would want to entertain staff's concerns about how massive the front is and how tall the front is. And I would definitely want to entertain the concerns of the rear neighbor to make sure that there's totally, I would love to see written support from the neighbors saying, I'm A-okay with this, and they've agreed to what, would be a neighborly concern. And if those things were addressed, I think I would be inclined to support the use permit. So if that's helpful to you in your discussions with staff and with the neighbors. And I wouldn't even rule out myself approving the height you've asked for along the street, but I would want to hear a very strong justification for it.
Madam Chair, just to add to that, clarification, because am I reading that this is a 3-story accessory building in the back? Or it's so small, I'm not sure, but it looks like it says a 3-story accessory.
I thought it was 2.
Does that say 2? I mean, I honestly can't read that.
I see
That's
2
really close,
levels.
because her house is set back, so that's going to be very close for her.
And so that will also be very close to the property.
Neighbor.
To the neighbor in the rear. And it's 2 stories. It's large. It's got steps going up it, and so the height of it.
Here's a side elevation.
So they could also clarify that the details of the accessory and the use for that, since that is going to be very close to the neighbor behind. Her house is set back. Okay. Can I have a motion, please?
Madam Chair, I move that.
We haven't gotten to that
We're
yet.
going to act on the variance, and then we'll do the use permit.
Then I put the wrong number down. I wanted to. I mean, the notice I got had the number that I placed on that form.
It's the same number. There's just 2 parts.
It's just as one says VA, one says UP. That's a slight difference.
I'll be still continuing.
Okay, come on. We don't have a motion yet. We interrupted you.
You want me to?
No.
We're going to go ahead.
Go ahead. Please, come up. Jacqueline.
My name is Jacqueline Coachman. I reside at 1921 South Langley Street, which is the property that borders the parcel in question. Just let me say my family, the family of Ms. Levere, and I have lived in this block for over 100 years. From the beginning, NARC has always been a community that welcomed newcomers and that welcomed new development. I respect that tradition, but I have concerns, and those concerns are best illustrated by comments that were made in the staff report. The first is the staff report says the church complied and had the debris removed. That is not entirely accurate. The church put up a fence dividing that parcel from my land. When they put up the fence, a lot of that debris was in my yard. The project manager assured me that day that they would remove the debris. I called 2, if not 3 times over a period of 6 weeks. My calls were never returned. I was blown off. I paid to have the remainder of that debris removed. The second point is the correspondence of March 8th from the church says, meetings with the neighborhood community will be conducted in an effort to show neighborhood support for the variances requested. Those meetings never happened. There was only one meeting, which was a week ago today. A presentation was made to the executive board of the Knox Civic Association. What is interesting to me is just the week before there was a general meeting of the Civic Association when all of us were there. And this meeting was 2 months after this memo was written. What is even more significant to me is that the first time I learned about this project was when I was presented with a petition. Can I make this very quick?
Sure.
Okay. The petition, 9 folks signed it, almost as many did not, because we felt the petition did not provide us with enough information to make an informed decision. There was more I could say about that, but I'll leave that alone. The last point I'll make is that as it stands now, there is a natural buffer between the church and the surrounding residential properties. There's 19th Street, there's Langley Street, and there's Kenmore Street. There is a parking lot as a buffer between Mr. Veer's property and mine. What is being proposed is putting this, what's called a residence, but it's also been called a youth church, putting it on the parcel closest to the 2 nearest residential properties. So, closing this quickly, if you do feel inclined to approve a variance, I hope you will do it with conditions. One condition being that there is a fence constructed analogous to the fence she constructed at her own expense to protect herself from all that goes on in the parking lot. And secondly, that there be mature landscaping on the side and behind the property. Thank you very much.
Thank you very much. Okay.
Madam Chair, I appreciate the speaker bringing up that proposal to have a community meeting. I meant to ask about it myself, and I forgot. Is there a reason can that meeting take place in the future so that we can get the neighbors on board here? Okay.
When is the next Civic Association meeting? Does anybody know? Okay.
Sounds like that.
So if we have a July deferral, that's enough time for community outreach as well as working on the details that we feel have to be addressed. Good.
Madam Chair.
Mr. Smith.
Very briefly, having experienced a lot of controversial cases over the years, and those that deal with issues about the construction process, it's really incumbent on the the project manager, developer, to clearly lay out exactly how that's going to flow, the construction process, and to lay that out to the neighbors directly affected by that, and to be extremely sensitive to their concerns with respect to construction debris, noise, the dirt left in the street, et cetera, et cetera. Those are primary concerns for construction management in a neighborhood with residences immediately contiguous. I don't see how you can skirt that in the least bit. That should be a primary concern for construction management.
Madam Chair.
Aside from the issues about what the structure is going to be, it's how you go about doing that. That's critical.
Madam Chair.
Mr. Owen.
As long as we're throwing that advice. On noise issues, the Arlington County noise ordinance is virtually unenforceable. And so, in my opinion, it creates more conflict than it solves. So one thing that we've done on some other use permits where there have been noise concerns is to have in the use permit specific hours of activity for certain kinds of activities. So we had a hockey facility, and they said they wouldn't play hockey after a certain time of night, right? So just be aware that that's a tool in the toolbox to try and make sure that everyone's feeling happy.
Okay. Can we have a motion now?
Madam Chair, in the matter of variance V-11268-17-VA-1, I move that the Board of Zoning Appeals defer the matter to our July 2017 hearing.
Moved by Ms. Malice, seconded by Mr. Melnick. For a July deferral. All those in favor?
Aye.
Thank you. Next one.
B-11268-17-UP1. It's a use permit request for a setback of 18.9 feet from the wall to the front property line instead of 25 feet as required. 12.4 feet from the porch to the front property line, up 21 feet as required, and to permit the placement of a 3-story building within the 25 feet of a street right-of-way for a new 3-story dwelling. And the staff recommendation is to adopt the attached resolution granting the use permit request to permit a setback of 18.9 feet from the wall and 12.4 feet from the porch, but denying the request to permit a 3-story building within the 25 feet of a street right-of-way, with alternative resolution that has been provided to the board as advertised.
Thank you. Can I have a motion, please?
Madam Chair, I think we discussed this item quite a bit concurrent with the variance, and so I will move that in the matter use permit.
Stop you a minute. You two did sign up for speak, but you understand what the process is going on now, right? Okay, thank you. I just didn't want anybody standing up going.
So in the
Sorry.
In the matter use permit V-111-268-17-UP-1, I move that the Board of Zoning Appeals defer this matter to our July 2017 hearing.
Second.
Moved by Ms. Malice, seconded by Mr. Smith to defer this use permit application to the July meeting. All those in favor?
Aye.
Aye. Thank you. Next case, please.
Thank you for your patience waiting so long, everyone who came.
And the rest of you.
And you should probably be earlier in the agenda next time.
Yeah, you'll be one of the first up next time.
Yeah, you'll be a good. But it'll be a long list of carryovers.
The applicants, okay. The architect.
-11269-17UP-1 is a use permit request for a setback at 10 feet from the bay instead of 25 feet as required, and 9 feet to the eave of the bay instead of 21 feet as required, and to permit a setback of 10.9 feet from the porch base instead of 21 feet as required, and 9.9 feet from the porch eave instead of 19.5 feet as required, and 8 feet from the base of the screen porch and 7 feet from the eave of the screen porch and all from the North Nottingham Street right away for a new right side addition and a wrap-around porch. The staff recommendation is to adopt the attached resolution granting the use permit request with conditions.
Questions for staff?
Madam Chair.
Mr. Owen.
If I have correctly recalled, this is the one next to the Phantom Street. Is that right?
Yes.
Does the county own the land where the street could be?
Yes.
Has the county abandoned the street at that location? That's a term of art, abandoned.
So we reached out to our colleagues in real estate. There's no, I don't know if I go so far as say abandoned. This is not shown as a street on the MTP. It appears as though it was intended to allow for an extension of North Nottingham. It's not clear why that was never pursued. So no one, rightfully so, is willing to say we will absolutely never pursue this, but there clearly don't appear to be any plans for it. And in the most recent neighborhood conservation plan, it actually it doesn't even call for adding a sidewalk. So even the community effort is not, they're not even asking for this to be improved as a street.
It's not in the MTP right now.
It's not.
It's not.
That's my home turf policy-wise, so thank you.
Other questions? Applicant?
Hi, good evening. My name is Alicia Knight. My husband and I own the subject property. I think, as you can see, it's a split-level home that was built. At the time it was built, I believe the county still had plans to build the road. The house is oriented toward the Phantom Road, as you called it. We are seeking to do a few things through this use permit application. The first of which is to move the front door of our home to the front of our home along 26th Street, to build a wraparound porch and a screened porch to be able to use the property. I improve the aesthetics. It is a little bit funky looking if you get a little farther off from the street, honestly. Build some outdoor space consistent with others in the neighborhood. I have a number of neighbors with screened porches. When we began this process, we honestly did not know we were a corner lot. I'm not claiming ignorance is a reason for your approval. But if you stand on the street and you look at our home, it's not a corner lot. I mean, it is, but it's not. And we, in fact, designed the improvements when we sat down with our architect to comply with all of the setback requirements for an interior lot, which we wouldn't be here if we were an interior lot. So we're happy to answer any questions that you have. I think this is definitely a unique site placement in a unique condition, and we're requesting your consideration and approval.
Question?
Do you have a copy of the staff report?
I do, yes.
Could you just, I was trying to figure out which neighbors gave support.
So,
Find two, in our packet, only find two letters. There's a map here that has different houses. Maybe you could just tell me.
I'm trying to figure, okay, so on your page, unnumbered page, this one that shows all of the addresses, we received letters from 5832, which is immediately to the...
I didn't see that one in the packet. That was one of the ones.
No, it's assigned, I think it was the first one in there. Doyle is the name on it.
Caroline Doyle.
Caroline Doyle, 5832, 5833 on 25th Road, 6001 on 25th Road. We did not receive a letter from 5846, who is immediately across the Phantom Road. I did speak to Nick, the husband. He said, I don't see any issues. He was surprised to learn that he was also a corner lot, but never responded to us. His home, however, is brand new, and I don't think they're going to be, I don't know that you'll be seeing them. And then we also received a letter from 6001, 5835, the immediate across the street neighbors of 26th Street.
Thank you.
Thanks. Any other questions?
Not for the applicants. I have another question for staff.
Okay, thank you. Lee Knight? No? Yo, okay. What about Carter Jones? What?
The next case.
Oh, sorry. Thank you. Okay.
Madam Chair.
Mr. Owen.
So I'm now curious, what makes this a corner lot?
Because there's a street.
But the street's not on a plan.
But it could be. It's a right-of-way greater than 30 feet wide.
What makes it a right-of-way if it's not in the MTP and it's not built?
It doesn't have to be built to be considered right-of-way.
What does make it considered right? Not every county land is a right-of-way, right? There's parks and schools and whatever. What makes this?
I believe it's, and I don't have the language, but I believe it's whatever is in the easement.
Oh, because it's an
If it's dedicated
easement.
Right.
So it was platted and the nature of the grant to the county. Well, but does the county own it in fee simple?
Yes.
So what? So then why do they have an easement over their own property?
Oh. It says we got it in 1959.
What did we get? Fee simple or an easement?
It says in fee for the purpose of providing the necessary right-of-way to extend North Nottingham to 26th Street North.
I have to admit, especially after recently recalling the situation we had with that place where they were going to build the boathouse in Roslyn. Remember that one? I'm a little nervous that we're moving forward treating this as a corner lot when maybe that's not the right thing. Can you review with us the zoning ordinance's definition of corner lot and how it relates to whatever the triggering status here is? So what I'm trying to avoid is that we actually say yes, right? But then, as you've heard earlier in the evening, sometimes everyone says yes, and then a year later you find out the answer should have been no, and then you're stuck. So I don't want to accidentally put you in that position.
Or your neighbor.
Corner lot is a lot or portion thereof not greater than 100 feet in width and situated at the intersection of two or more streets, having an angle of intersection of not more than 135 degrees.
I don't see two streets here. They don't physically exist. It's not in the master transportation plan. The county owns the land in fee simple. I don't see that this qualifies.
So a street is defined as a public thoroughfare 30 feet or more wide, including any public interest in land, fee or easement for street purposes.
Mr. Melnick.
Yeah, I was just going to ask about the definition of street. So that's what you just gave.
So that's where it gets a little hair.
Say that again.
A public thoroughfare 30 feet or more wide, including any public interest in land for street purposes.
Doesn't have to be a street, so long as they have an interest in it for that purpose.
The fact that it was deeded for street purposes.
It can remain a field.
That's nice for you.
I'm still.
It's not nice for you. It's a 25-foot setback.
Well, I'm still, frankly, a little bit nervous. I mean, now I feel like if you're sure that there's been no abandonment, are you sure there's been no abandonment? Abandonment is a special ceremony the county performs when it decides it doesn't want to build the street where it used to think it wanted to build the street.
No, that hasn't.
Requires a county board action. And it's an amendment to the general land use plan. So that, to me, that's the conundrum, right? Huh?
The deed?
To act on third parties, it would have to be recorded, right? I would think so.
Well, I'll tell you what I do know. I don't know that I can answer the question as you phrased it. But abandonment is an amendment to the master plan that the county board must do if there is a street that is no longer going to be a street, right? And so the master transportation plan.
Well, that wouldn't apply here because it wasn't ever a street.
I don't know that that's true.
Well, except by that definition where it says a street is anything where the county says we own this property for the purpose of it being a street, whether it's a street or not.
I don't think I'm not sure those two things can be legally separated. That's my point. My point is that I think the master transportation plan is supposed to include all places that are legally able to be a street and no places that aren't legally able to be a street. And so this status of land being for the purpose of a street, if the county's not going to build a street there, they need to take a specific county board action to unmake it a street. And until they do, it should appear on the master transportation plan.
As a street.
And so the fact that it isn't on the master transportation plan, but we are still treating it as a deeded for the purpose of a street, those two should never be happening at the same time. And so something's wrong. And
they should do that abandonment.
Well, you're assuming that, we might be assuming that the MTP is wrong, but maybe the MTP is right. because sometime in 1964 or 1974 or whatever, there was an abandonment. And that's why it's not in the MTP.
And it's not recorded and not written anywhere.
Right, but if there was an abandonment, then they're not in a corner lot anymore.
Right. But there would have had to have been county board minutes to say that. It's,
Yes.
but my point, Madam Chair, is that to give others notice that this happened, there has to be a recordation.
I don't know that there needs to be a land record or not. I don't. Maybe there does. Maybe there doesn't. But yes, the land. But it just would have been a county board action, right? So it would not necessarily have been recorded on their deed, and I don't know whether it would have been recorded on the deed for this property, for the county's property.
Are they recorded?
Yes. Well, they're recorded as county board statute. They're legislative actions, so they would be. It should be searchable. But to me, I'm concerned about the fact that there's incompatible, what seemed to me as a layman, to be some incompatible designations for this parcel. And maybe it's all fine.
Madam Chair, has the zoning administrator made a determination
that this is a street? Yes.
That solves it for me.
Moving on.
If I were you, I would look.
It is midnight. It's midnight.
I would do that later, too.
I think the applicant has a stake in our being correct.
Yep.
So
what is the implication if it's not?
Right.
Have a setback that's allowed for an interior lot.
Right.
So I don't see the harm, I guess.
Right. That's what I looked at earlier. Other than putting them through this process of making them pay for the application and when they may have had the right to it. That could be their harm.
They could sue.
What's the harm in granting, really?
Exactly.
It really isn't, I don't think, down the...
Well, I guess we could ask the applicant if they want to proceed, or would you like additional clarification on this obscure matter?
I think from our perspective, when we went to process our permit, we are a corner lot for the purposes of getting our permit, and that's why we're here. If we were an interior lot, we wouldn't be here. So I think from our perspective, having the approval as a corner lot would be helpful. If we're in fact an interior lot next week, we can move on along our way just as well.
Okay. I think I'm fine with this as long as there's total clarity that this action should not be construed as a BZA endorsement of the determination that this is a corner lot. If that's in question, that's an issue for another day. Yeah. But I'm willing to approve this with that understanding.
Madam Chair? I move that the Board of Zoning Appeals adopt the attached resolution approving use permit V11269-17-UP-1, subject to the conditions listed in the resolution.
Second.
Thank you. Moved by Ms. Malice, seconded by Mr. Owen. All those in favor?
Aye.
Aye. Thank you. Next case.
B-11270-17-UP-1. It's a use permit request to permit a setback of 17.3 feet from the eave to the North Pershing Drive right-of-way instead of 21 feet as required, and of 3.3 feet from the eave to the right side property line instead of 5 feet as required, for a new second-floor addition in the R6 zoning district, premises known as 431 North Fillmore Street. The staff recommendation is to adopt the attached resolution granting the use permit request with conditions.
Thank you. Questions? Applicant, please.
Good morning, Madam Chairman, Mr. Vice Chairman, members of the board.
Thanks for rubbing it in.
Good job.
We are here for 18 inches of eaves on either side of our house. We have a by right project where we're going straight up, and so these eaves would overhang the sides. Right now, the roof is off our house, so we're very excited to have, because we have a building permit already, I should say, so after what we heard earlier. The roof is off our house, we're building up. We're looking to have the eaves come out so we don't have essentially both water problems coming on the side of the house as well as aesthetics, not having a shoebox on top of a very square little Cape Cod. We have spoken to as many neighbors as we could, especially the one most affected is the one immediately to the south. It's probably obvious because it's the only neighbor that's actually directly next to us in the plot, since we are both a corner lot and across from the park. It is the Powell's residence. Sorry, I'm having trouble finding the page there. That's 427. Mrs. Powell owns the house. She's 96 now and a widower. Her son kind of manages the place for her, and I've spoken to him 3 times now. My wife spoke to her. She also takes care of their other schizophrenic son who's at home. So my wife talking to Mrs. Powell, she said, I have to wait until my other son David is home. I've talked to David 3 times. He has no problems, but he says, it's my mom's house. It's her decision. She doesn't want to sign anything. She wants David to sign it. He can't sign it, but
That's 427, right?
That's 427. We've gotten a letter from the neighbor directly behind, which is 2800 Pershing. We've spoken to a lot of across the street are multifamily tenant buildings, and we've spoken to the occupants there and then sent letters both to them and to the other neighbors in the immediate vicinity that we couldn't reach when we went by twice on a Friday and Saturday in April. So that my architect, who has volunteered his time for this part of the project, and I am very grateful for, and he is probably resenting at the moment, is also here, Carter Jones. And we're thankful for his help and also for staff support, and I'm happy to answer any questions you may have.
Any questions for the applicant? Mr. Jones, anything you want to add?
No.
Okay.
Very well.
Good.
Looking at me.
What's your pleasure?
Chair,
Ms. Malice.
I move the Board of Zoning Appeals adopt the attached resolution approving use permit V11270-17-UP-1, subject to the conditions listed in the resolution.
Second.
Moved by Ms. Malice, seconded by Mr. Smith. All those in favor?
Aye.
Aye. Thank you. Thank you for your patience. Next case.
B-11271-17-BA-4. It's a variance request to permit the construction of a new home on a lot that does not meet the width and area requirements. And the staff recommendation is to adopt the attached resolution approving the variance.
Okay, and to clarify, this is expired, so there's no changes. It's just it's a renewal, essentially.
Right, and we noticed that the only addition was the proposed driveway.
Madam Chair,
Mr. Owen.
do you have speakers on either this item or the next item?
Speakers? No.
What about the next one, the use permit?
No.
Speakers on the use permit? Okay. Why did the variance expire here? I'm sorry, Madam Chair, I don't know if I was recognized for staff questions.
Go ahead.
Why did the variance expire here?
I believe they initiated the building permit review, but it wasn't complete before the expiration. And so we continued to have some back and forth allowing revisions before we realized that it had already expired.
What were the conditions on the previously approved variance?
Do you have the old file?
Oh, yes,
be the same.
Let's see. So the draft.
Yeah. Right. See?
Yeah.
Yeah.
Appears to. You don't have the minutes? So it looks like the alternative resolution to approve was granted. And in the documents we have here, it appears to have eliminated the conditions.
So has it expired?
I will say I didn't print it. I wish I had. I got your email from earlier today asking about this, and I went to look at the minutes in our records, and they did have that. So I don't know if there was an error in the minutes, or I don't know which is correct. The minutes that I found did include the condition with the date.
So because I'm new here.
Got it. You listened.
I listened to the tape.
Got it.
And the tape is consistent with your other document.
With Drew's notes.
But I don't know if the tape supersedes the minutes. I think the minutes might be controlling. I don't know the law on that.
I think the minutes would be controlling.
Yeah.
Okay, so it did expire. Unbeknownst to all of you who voted not to let it expire, it expired anyway because you approved the minutes the next month. So here we are.
Yes.
Did we intentionally want it not to expire?
It was the same issue.
The language is it's kind of routine. It says that it has to be have a year essentially. They almost all say they have that.
It was the same problem that we just faced on Zion, which is that the variance language, the language in the draft resolution for the variance talked about the use permit. I mean, actually, that's the thing, is that the draft language doesn't refer to the variance. So what is the final condition in the version you remember being in the minutes?
Gosh.
If you read it out, it won't make sense. So that very last condition there, by your thumb.
So condition number 4, the applicant shall obtain a building permit to construct the structures permitted herein by February 12, 2016, or the variance shall be null and void.
It says variance. It didn't say use permit. Interesting. That's weird. Okay, but anyway.
Well, this one says variance too. When you look at the language in the number 4 condition, it's identical. It says variance with next year's date.
Okay. For some reason, what I was pulling up online said use permit. But in any event, and that's why I asked the question about it in the difference between use permit and variance, because what I was reading off the website that shows the draft staff report, that shows it as use permit like the Zion one did for us, right? So in any event, the reason why you struck all the conditions was because it talked about plats and whatever, and you weren't sure you were going to stick with the same plats by the time you got done with the use permit. So you ruled that it was a buildable lot, struck all the conditions about all the conditions, which...
Because they would have to have submitted something subsequently anyway.
And it was specifically discussed that there was a tiny house by right option that they could do at any time. So so the variance was not supposed to expire.
Pull up the minutes.
Okay, but what...
Computer.
But what we are dealing with, I guess, is that that was all obviated unbeknownst to the applicant, I guess, by the next month's minutes. So,
Mr. Owen, would the use permit have correctly expired?
yes, there's no question that the use permit expired, but it's not clear to me whether or not they have a permanent variance.
Because the variance is, I mean, it should run with the land for posterity.
And so my concern now is that if we do another variance tonight, that has a different configuration, now, and then it turns out the old variance that was permanent still exists, now there's conflicting variances.
But if it runs with the land, then why do we have conditions and expiration dates on any variance?
It's allowed. Variances, the statute specifically permits us to do variances. Sometimes it makes sense to do it and sometimes it doesn't. So sometimes if you're saying it's a buildable lot, it might make sense, although not. I mean, actually I
think that the Zion and this both, it's, if you're conditioning a variance to specific plans that you haven't even considered and may not want to approve.
Well, Madam Chair, can you envision a developer saying, I don't know what I'm going to do with this, but I want to get it deemed buildable.
Yes.
And then I'll figure out.
Yes. But that's why I'm saying, why would you add conditions to it that are specific to plans that you haven't considered yet, unless you consider the use permit first and said, okay, we like this house, now this is the one we'll condition to the variance.
And I think that
otherwise you're doing it backwards.
Right. And the condition for expiration, I think, is in its own category. That depending on the exact situation, you may want to say this expires in 1 year or 10 years or never, and that just depends on the situation.
And now we've got two situations in one agenda where you've got use permit conditions that are put into the variance.
And what I fear is
may not. It may work in this case because maybe that
a prior variance. Can we say this supersedes?
Without advertising it?
Oh, that it's going to do that. That's a good point.
So even if we approve this variance, if the other one is still on the books, I don't know what effect that has.
That requires research? County attorney research or what? Whose research? Who's going to decide, or is it you, who decides whether the minutes or the tape, the issue that Mr. Owen has raised is very interesting because this may be a moot point.
Madam Chair?
Yes.
In the meantime, Mr. Holmes, who is seeking 1 foot on each side, is listening to us on this variance.
Okay.
I think we should hear the item.
So let me ask you this. Is the use permit that's being presented tonight consistent with the previous variance? In other words, it works with either variance?
I think it's presented as being identical and only because of the expiration.
We think we can maybe pull up the minutes that are saved on our drive. I may have misspoke. And show them to you.
Well, that doesn't answer the question, though, of what.
No, if it shows the strikeouts, which I thought were not there, then that would clarify.
So you're saying the minutes might be consistent with what I heard?
Yes.
That there might be strikeouts?
Yeah.
In which case it hasn't expired?
Right.
That would appear to be the case.
We can just, what do we do with this then?
The use permit you
But in
could act
this
on,
case,
but
we
the
would
variance
take
you
no
wouldn't
action,
need to.
or what do we do to do this?
No need to
Wouldn't need to take
on
action on the variance, but you could on the use permit.
Okay.
Can you display it?
Oh, goody.
Okay. Scroll down a little bit.
More. There you go.
There we go. It didn't expire.
I stand corrected. I'm
Can you
sorry.
scroll up to see who made these motions, this motion on this?
It was Terry,
Was Terry?
I think.
Okay, I guess you got to go down. It's going to be the next.
Uh-oh. Into.
Oh, you guys are on the hook. Terry was the one who goaded you into it. He's like, this is what should be done, and you guys jumped at it.
He always did that.
Okay, so
Okay.
so we have a permanent variance. I would suggest, Madam Chair, that this is advertised and we should hear anyone who wants to speak, but then the action we might take is
No
to take
action. No action.
Okay. I'll entertain a motion. I don't have any speakers. You want to speak? Applicant?
The applicant should have a chance to say we're totally
Okay,
wrong.
applicant.
So as I'm listening to the conversations going back and forth, very interesting. Matter of fact, good morning.
Good morning.
Morning to you.
I'm trying to understand the position that you're taking on a variance that was already issued, whether or not you can extend the variance. The reason that we're in a scenario is because we had to sit around and wait for engineers, architects. The county had part to play with it. The county actually waived the rights to the fees and actually moved this whole hearing up by 1 month, understanding that they had some responsibility with the whole thing. So at this stage of the time, as I listen to the conversation going on, I still don't understand the position where we're
The
at.
gist of it is that the variance that you got last time is permanent.
Right.
It's not expired. So therefore, we don't have to take any action on this part. Use permit, different. Use permit expired, got to do that piece.
Okay.
So we'll do that, and we'll do that as soon as we dispose of this variance.
There's no reason, if the only reason why the variance for tonight, if the only reason for that is to make this a buildable lot,
right,
then you're already good to go.
Okay.
If there's other things in this variance that you're proposing that weren't in the previous variance, then we might need to act on it.
No, it's identical to the same.
Okay. So what would probably be most useful on the record is for you to withdraw your application for the variance and stand on the previous. So the zoning administrator, just into the record, do you believe that there is already a variance equivalent to what was advertised that
Yes.
is in force now?
Yes.
Okay, so the zoning administrator has just announced this. And so I think what would be helpful, perhaps, although I'm not forcing you to do this, this is just a suggestion to move the night along, you may want to consider withdrawing your variance request for tonight because you already have the variance you
Just
need.
for the variance.
Just for the record.
Use permits.
Then we would move on to discuss it.
We're going to do that next.
Okay.
But you won't be,
So since we already have a variance, and a variance is a lifetime for the, we would go ahead and withdraw the variance.
great. So we don't need to take an action because he's withdrawn.
Well, I
Or
think.
accept the withdrawal.
Yeah, I think accept the withdrawal.
Okay. Can I have a motion to accept the withdrawal?
Madam Chair, I move we accept the applicant's withdrawal of the variance request.
Variance number.
Read the number.
It's number
please.
V-11271-17-VA-4.
Second, given that there's a variance that's identical that's already in place.
Thank you. Moved by Mr. Owen, seconded by Mr. Smith. All those in favor?
Aye.
Thank you. Now, next. Don't go anywhere.
I'm not moving. I've been sitting here for 6 hours. I'm not moving.
B-11271-17-UP2 is a use permit request to permit a setback of 5.6 feet to the wall of the home from the left side property line instead of 8 feet as required, and a 7 feet to the home from the right side property line instead of 10 feet as required, and an aggregate side yard of 12.6 feet instead of 18 feet as required for a new two-story home. The staff recommendation is to adopt the attached resolution approving the use permit with conditions.
Thank you. Questions for staff? Questions for the applicant? There are no changes?
Not at all. This
Okay.
is,
I have two speakers.
Oh, I'm sorry. Speakers.
Sean Martin. Come on up.
Hello, I'm Sean Martin. I live at 2107 North Emerson Street, which is on the right, our left-hand side. I've lived there 15 years. And I've got some points of clarification. In the notes, it says that there are no trees that are in danger here, and that's not the case. There's 3 trees along the property line between my house and this property, and there's one in their backyard that would be impacted by this, especially with the addition of the parking pad on the left side of the property. And ideally, I'd like the setback to be larger on my side. I realize that was already passed at 5.6 feet. Ideally, I'd like to see that larger. Additional things that I would like to see is proper rodent abatement. There's been none since the property's been rotting like that, and it's not been secured. I'm shocked that the county's let that go on for years. There's a lot of young children in the neighborhood, including in my house, and it's awful. The past success came from when we met with the previous owner. We finally met on the curb one time, and that's how we came up with the parking pad on the left instead of the right, because the house on the right is very close to the property line. So another misleading statement, I believe, in the text that's provided is that the neighborhood supports it. There's 22 in support and 2 in non-support. The 22 came from the previous owner's realtor, who canvassed the whole, maybe recall the last time, like she sent hundreds of email or letters out, and people, there was no drawings in that, and people just wrote because we're sick of seeing the rotting. So I'll leave it at that. You're familiar with that. So I reached out twice to the current owner. I got his name from the tax records, wrote 2 letters over the past year, no response. So I'd like to see a little more respect for the community there of having to see this. I do appreciate he has cut the grass. The previous owner did not do that, so we had 4-foot high grass. You maybe recall me complaining about that. So to recap, my requests are secure the property properly, proper rodent abatement, have an arborist come look at the trees. That was in the discussion last time that I came, and I didn't see that in the text here. Thank you.
I'm sorry, could you state your address again?
2107 North Emerson Street, the one on the left.
Thank you.
Just above the red box.
Sorry, Madam Chair. The speaker was listing the things he was hoping for, and I couldn't get them all down fast enough. Would you mind just repeating your final list?
Sure. So secure the property as soon as possible for safety reasons. Proper rodent abatement now, and hopefully when construction starts. Have an arborist come inspect the trees on the north side of the property, and there is a walnut tree in the back that's not along the property line. And work with the neighborhood better, or try it at least some, and then ideally move the setback further from my property on the north side. I realize that last one's a stretch since it was already approved, but that's on my wish list.
Thank you.
Thank you. Sawyer Blazek.
Oh, you threw away all.
Also, good morning.
Morning.
I actually have not been too frustrated by how long this has taken. I've actually learned an incredible amount, and I have really appreciated the amount of advice and guidance that you've given to the audience. It's helped me to better understand. I was actually here just about a year ago for V-11149-16-UP-1 for 2101 North Emerson, which is immediately to the left here on the corner with 2 corner setbacks. I was experiencing a similar issue, so I requested a use permit. It was successful. We're actually still doing construction. We're very excited to be about to move in. And what I wanted to point out really was that was not the start of the process. It was actually reaching out to the community. We went to the Citizens Association. We went to our neighbors. We requested their support. We got their signatures, and we really made ourselves a part of the neighborhood prior to going into this process. And I'm saddened that this is the first time that I really was able to express my opinions and my concerns. I really haven't had an opportunity to really understand what this is. I received this letter a week ago, similar instances of having just received this when the owner did not reach out. I would note that there was a change of ownership prior to or following the actual approval last time. This is a new person that's actually coming and requesting the same approval. But really, similar with what Sean mentioned, and John Saunders, who was the other person that actually opposed it last time this came here, who is the another immediate neighbor to the west, since the stop order occurred, there's been no safety at the lot. There has been no security, no safeguarding to improve the lot. There's been rusty bowling balls, rusty fences, 4-foot high grass. It's been a great concern of us as we get ready to move in. I have a 21-month-old. We're about to have another child in August. And there's been trash and debris everywhere. And that concerns me for moving forward. I know this isn't a history board. This is my concerns that really just is focusing on what's coming up. I'm hoping that improves over time. What I also wanted to note is in the staff analysis, under staff analysis 1, that there's no adjustment to the landform, and I apologize for going over time. The fence is actually serving, as you can see right here, this rusty fence, which we would anticipate to be removed because it's actually on their property based on the rezoning. Likely going to be removed, but it's actually serving as a retaining wall. Right now on our property, there's at least 2 feet of dirt that is sitting on that fence, and it's actually resting well above the shed that's on the pass of that fence. So I'm not sure that I agree that there is actually going to be no adjustment to the landform, and it may result in further erosion onto our property, which we found that there has been significant water underground moving from the northern area down into our area as we've been doing our own construction. Again, there's been no contact. John Saunders, Sean, and I have all tried to reach out. I tried to contact his real estate agent when he originally purchased. I've tried multiple times to contact, and I really wished I could address some of these issues prior to this. Moreover, the concerns are in the shorter term, in the near future, during construction. My wife, as I mentioned, is going to be due in August. We're going to be at home taking care of that child. I'm hoping that the safety during construction is not going to be an issue or a concern to us. Or the safeguarding and the security of that facility going forward. So my request would be similar to Sean and perhaps other considerations that the board may have more knowledge of, to pursue additional support from the neighbors, of which they really did not reach out at all this time, and I was really hoping for that. Consider landscaping as a condition, perhaps, because we do have a concern about the retaining wall that's on the fence that will likely be removed. It's very old and it's on their property. Ensure proper safeguarding during construction. And I think similarly that was mentioned before, hours of operation during construction. We will be having a newborn at the time. And I don't know if this is even something that can be considered, but it would be quite disturbing, or not disturbing, but quite distracting and challenging for us to take care of our child if they're working well into the night. Aside from the excellent construction, we look forward to improving this lot. It's been a blighted lot for a long time, and we really appreciated them bringing something forward. But I was hoping to talk with them beforehand.
Thank you.
Thank you.
Could you state your address again?
2101 North Emerson.
Sorry?
2101 North Emerson.
Okay.
Thank you.
Thank you.
Comments, questions?
I'm just kind of working randomly over some of the concerns. Hours of construction are established by the county?
Mm-hmm.
What are they?
No, the noise ordinance regulates when certain activity is permitted.
Okay,
The noise ordinance is a minimum floor.
right,
Other conditions can be added on.
sure. What's the minimum floor?
I'm not familiar with the regulations.
Of course, not before 7 a.m. I think it's 7 a.m. to 7 p.m. or 7 a.m. to 9 p.m. are the hours of construction of the zoning ordinance.
I think it's 8.
I'll bet you $1.
Doesn't it differ on Sunday?
Yeah, weekends it's different.
Yeah, weekends is different than weekdays, right? So, actually, I have a question for the applicant if Ms. Malice is thinking of others. On your disclosure statement, so on the application says, we, Saran Keskin of MAS Homes, Inc. And then on the financial disclosure statement, where it says, list the names, addresses, and nature of interest of all persons having equitable ownership of real estate to be affected, including in the case of corporate ownership, the names of stockholders, officers, and directors, and all parties in interest. There's only one item listed, name, Saran Keskin, owner. Can you offer any clarification about the relationship of MAS Homes, Inc. to this property?
Yes, actually, MAS Homes was owned by me, so just I purchased based on that company.
Do you own the property, or does MAS Homes, Inc. own the property?
MAS Homes Inc. own the property.
Who owns MAS Homes, Inc.?
I am 100% owner on that entity.
Okay. Is there a mortgage?
No.
Okay. Thank you.
Other questions, comments, motions?
I'll just offer a brief introductory comment. And I've had the view that the BZA should have a practice of the law of the case, so that if I disagree, if I would have ruled differently from how the BZA previously ruled, but the only thing that's happened in the meantime is an expiration, then I feel as a new BZA member, I should approve the old thing, because that's required for people's economic stability. The exception to me is if conditions have changed in the meantime. If there's new conditions, then new physical conditions or legal conditions, then I don't feel bound to the previous ruling. And what in this situation, we have new ownership. The continued rotting of the property apparently has come to further exacerbate the neighbor concerns. And so I feel like in this case, it's not, actually the ownership isn't such a big deal, but the continued deterioration is a factor that neighbors have brought to my attention. So I don't necessarily feel like this is an automatic, they got the thing before, it's just a technicality that they didn't get the approval. It may be worthwhile to consider new conditions. So that's just an opening gambit. But you guys went through this before, and you may have better insights about what additional conditions to impose.
Madam Chair?
Ms. Malice.
The couple of items that sort of jump up in my priorities here is, one is the arborist review of the trees and the possibility that tree protection may be able to save them if they're worth saving. And the other one is, I am a little concerned about the assertion that this fence is in fact a retaining wall. I don't, can you speak to the retaining wall, this fence issue?
At this stage of the time, with the land where it is, you don't want to disturb anything. So as we go back in there, we actually start to renovate and take everything down and pull it down and start looking at the grades, we're going to find that these retaining walls are either outdated, they're not put in right. So we'll have to address the issue of the soil and how it grades into the neighbor's lots. That's all controlled by building. So when your site inspector comes out and he talks about your silt fence, your controls and everything else, and how the end product, you've already got in place a program that makes sure that your neighbors on both sides are well thought of.
Yes and no. Yes, I think that's true. I think the neighbors sure would like to know what's going to happen. Would there be a circumstance under which you would rebuild a retaining wall?
Build on the same wall?
Rebuild.
Oh, rebuild the same wall? Not unless it's on the site plan, no.
Yeah.
I haven't physically seen that, so I can't tell you what the retaining wall is actually holding anything up.
I have not either.
But I don't believe the retaining wall is on the site plan though. And the site plan's already been reviewed. Site plan's almost just about ready to go. Yeah.
So I guess the question in this regard is what if the plan review is already done and they haven't seen a retaining wall issue here, how does the neighbor's issue get addressed? Is it just by grading?
If I may, retaining wall. How big is the retaining wall? 2 feet. And is that because of the differences between your lot and that lot? Okay. So in most cases, when you come into a scenario like this, is that you have to be concerned about the water draining off of that one particular property. So if the grade can't be graded out, then some type of retaining wall would have to be put in. But I in most cases, I don't see, looking at a 2-foot grade, I don't see that would be a case where you couldn't actually adjust the grades to make the grades work.
But can you adjust the grade simply on your property without impacting their property? Yes. You would build up to the grade?
Up to or down, right.
Yeah, we're getting into an area that is beyond our level of expertise, my level of expertise in terms of grading and, what the solution is. But I want to make sure that the applicant or the neighbor has a solution, and I'm not sure, since I don't have a solution, I want to make sure there is a solution, but I can't prescribe what it is. So looking for some language that is it possible for the neighbor to go to plan review and find out what's going on and what the solution will be?
There's no go to. You can certainly request document. You can talk to people and you can request the materials, but there's not a formal place or process.
But if the applicant wished to see what plan review says about this grade difference and what they're advising the builder to do, is that something that...
So the comments associated with the plan review are posted on our website. But the problem is if there's no issues, there's no comment. So if things are being addressed, they're not going to be commented on.
But so
Madam Chair, if I might.
Sure.
The neighbor could say, I'm going to go hire an engineer to look at the sediment and erosion control, the issues with the grading and make a report. And that report could say that there's a problem with the construction that's going on next door. And then take that to the neighbor next door. It could also take that report to the county and the inspectors who do the sign off on the on the plans and say this is the problem, to get their reaction to whether it is or not. Don't neighbors do that? Don't they go to, when they see construction, and they have their own expert challenge?
I'm not familiar with that process, personally.
I was just trying to think of a way that...
To the neighbor.
It's not fair. I don't see it.
Well, but if there isn't any, if plan review has said there's not a problem with the way they're proceeding, but the neighbor thinks there is, the burden is then on the neighbor.
Well, the question is, the neighbor doesn't know how they're proceeding. Plan review may have a solution. Do you know have you seen what the solution is?
Approved plans are public documents, aren't they?
Right, but if they're under review, there's, exactly. It's an iterative process.
We've gone through 2 submittals already, so they're on the final stage. So here's the, we do a lot of work in D.C. where you have parking malls. Our neighbors are next door. One of the best approaches in a case like this is, does the retaining wall at this stage of the game, the way it is, does it work for you? Or are you looking to get the retaining wall removed and something put in better? Well, it's not only a marketing. So as you guys are looking at the rules and regulations, it's a marketing. Now, I understand that there's a lot of builders out there that really don't care about it. They think if they put 80% into it, and they can capture 80% and still sell the house for 100%. Well, in a marketing side, if there's a retaining wall that doesn't look good, we have to turn around and try to sell the product. So what we're looking for is we're looking for the best interest of both parties. So we would be glad to go out and actually walk the property with him, talk about the concerns, look at the retaining wall, and come up with a solution to it. The retaining wall, being a 2-foot retaining wall, isn't a major deal. So we don't want to blow it out of proportion, so let's look at it in a very simple fashion, a neighborly fashion, and try to solve the problem.
What is your, would you mind coming up? How's that sound to you?
I'm sorry, I didn't hear entirely.
Well, what we're trying to do is there's two different ways of doing it.
Yeah.
One is a very simple way, and I'm a simple guy, and the other is to try to go around and try to figure out how to make it all work.
Mm-hmm.
If we set up a meeting, we go out and we take a look at it, and let's look at the retaining wall, and we can come up with a solution that works for it, because we're only talking about 2 foot.
Mhm.
And then how long?
I wouldn't be able to.
Yeah, 20 feet,
Yeah, I
30
guess
feet
it.
between me and them?
Yeah,
or-
probably something like
Yeah,
that.
so between me and you. So we're not talking about a very big thing. And then from there, and once we walk it, while I'm working with the, with plan review, we can address the issues of any type of grade elevation differences and why is the retaining wall there. It may be a landscape retaining wall. It may be that years and years of people building up dirt on it, and that's what's got to come out.
My impression is it's a fence there, that there's a fence there?
Yes, it's actually the rusted fence that you can see in these photos. Right there.
And it's just debris has built up against it
Exactly, yep.
on your side?
Exactly, yeah. So elevation is relatively flat on this property of 2105, and on our property it drops 2 feet because of the fence. And it goes
Now-
past the shed.
Oh, I'm sorry.
Yeah, no, sorry.
So evidently, the natural grade itself had a 2-foot drop. Okay, so I'm sure that the neighbor, and we've seen it before, people take brick and block and everything and put it in there and put dirt over the top of it. Okay. So what will end up probably happening is, if I look at the site plan, is that we will probably have to pull out that retaining wall and get the natural grade of the dirt, which was there before the house, or while the house is being built. So what you're looking for is a nice, clean blend between the two properties. Is that?
Yeah.
And that's what everybody is in search for.
And whose fence is that?
It's 2105.
So it's not
The applicants, yeah.
applicants'
Yeah,
fence?
and that's always because
Because
the
of the survey.
fence is actually open with the fencing on the neighbor's side.
Yeah.
You think that that's always the way it is, but it doesn't always work that way.
Yeah.
So was it your intention to take the fence down?
Well, you're going to take the fence down, right? Yes. Yeah.
Come on up. You have 30 seconds. I'm not moving in here.
Here to Mr. Smith, I am looking forward, but I have concerns if he cares about what the neighbors think, and he's in the best interest of everyone, because it wouldn't sit like that for a year and a half if he cared about the neighbors and the kids and the rats and the mice that are in my crawl space. So if I ask that it's written in that he has to do these things, I don't trust him.
Thank you.
30 seconds?
Okay, we're not going to have more of an argument.
So we are our new group. It's one of the reasons why we're taking the house over. So what we're looking to do is to start off. I mean, as we're looking at this is not just recent. This is a decapitated house. It's been sitting there for years and years and years. So we've got a lot of investment. No, I know.
Hold it.
I know. So what we're looking to do is we're looking to start off on the right foot. We are concerned about our neighbors. We want to make sure, and just like the yard in the elevations, we want to work with both sides. So now I think that I don't know if the county actually issues an arbiter to come out from the county and check the trees for the final survey. But we can check that.
Yeah.
We can see the county has an arborist that actually looks at these things. So we just get the have them come out, and I'm sure that if there's a tree there, they're going to have silt fence and tree protection on it.
Okay. Everybody sit down. Thank you. Okay. It appears we have some interest in outreach and negotiations, which is all a good thing. Can we have a motion and move this along, please?
Madam Chair,
Mr. Owen.
I have a question for the applicant. When are you hoping to receive a building permit?
Close. I'm both of the site and the building have gone in for their second review.
When do you expect to receive your building permit?
I'm hoping within the next month,
When do you expect to begin construction?
as soon as I get a building permit.
Within a month of getting the building permit?
Within a month of getting a building permit.
And how long do you think demolition will take you?
You're probably 2 weeks. Probably not even that. Yeah, about maybe 2 weeks. Give yourself, by the time you do the sill fence and everything else and get ready to go, 2 weeks.
And that includes like excavating the previous foundation and all that stuff, right? So by the end of summer, you're expecting to have, assuming that you get the building permit you're hoping for, you expect to have completely removed everything from the current site.
Yes. We're running 5 months on build.
Okay.
Start to finish.
Thank you.
Anyone else?
Madam Chair.
So,
the two additional conditions that I'm contemplating, or the two adjusted conditions that I'm planning, is one, it's common on larger site plans these days for there to be a standard condition that contact information for the construction manager must be provided to the neighbors. So in this case, I think the condition I would want to run by the zoning administrator for enforceability is applicants agree prior to issuance of the building permit to provide to the zoning administrator a name, email address, and telephone number of a construction manager to receive inquiries from neighbors affected by construction. Presumably, the neighbors could then contact the zoning administrator to receive that information, but you would know that you had it. You would know it was complied with because it has to be provided to you. I'm not putting in the condition what you have to do with it. I'm just trusting as a good public servant, you would in fact re-provide that information to the neighbors. Does that sound reasonable to the zoning administrator?
Sure. I'm trying to think of how it's normally phrased. I think we also require sending it to the Civic Association, but
right.
It's,
but the Civic Association isn't participating.
Sounds like it's a limited, yeah.
So we could just leave it to your discretion how to, maybe you could give it to the Civic Association, but you could also give it to other people depending. All right, the other thing is I'm not sure I'm comfortable with the 1 year expiration. I think I would be inclined to have a shorter expiration because the sort of principle of let's move this along under the previous thing, if this gets sold again and the neighbors are coming back 18 months from now and it's been resold and nothing has happened again, you know, I feel like we're not really addressing the neighbors' concerns with the vacancy. And so I would want to put a tighter timetable than usual, given the history of this property, so that if as the applicant hopes, you know, by fall, there's no action, you know, regardless of why there's no action, that there would be a joint understanding that by that point, if it comes back to us again, there might be further conditions for rat abatement, for soil erosion, for whatever, that are beyond the scope of what we might be willing to approve tonight. So, so that would be my other thought. I haven't made a motion yet, but that's my other thought, is that I would want a shorter, maybe a 6 month as opposed to 1 year turnaround time for the building permit to be issued.
any other comments?
Madam Chair, I would agree to those conditions.
Madam Chair, the conditions I was going to propose also were to retain an arborist to review the conditions of the trees and make recommendations for preservation if appropriate, and that the applicant would meet with the adjoining neighbor to adjust the grade, to discuss adjusting the grade along the fence line at 2105 North Emerson.
Okay.
I didn't catch the last one.
Okay, that the applicant would meet with the adjoining neighbor to adjust to
A particular adjoining neighbor, or?
105 North Emerson Street.
That's the site. That's the site.
That's the site. Oh my God, I'm losing my mind.
2101.
2101.
2107.
2101. I think it's 2101 site.
Yeah, the 101 is the one with the
Retaining wall.
retaining wall.
Retaining
Okay.
wall. 2101 North Emerson to discuss solutions and to address the grade along the fence line.
Ms. Malice, I wonder about the enforceability of those two conditions.
Sure. Well, not the arborist has to be tied into.
That's enforceable.
To something. We have a condition for arborists.
No building condition until an arborist's report is received by the zoning administrator.
Thank you.
Okay.
Building permit, you mean?
No, I said no building permit. No building permit until the zoning administrator has a copy of the arborist's report. And presumably that also would be provided to the neighbor, right? Or if upon you know that the neighbor might ask you for it. And then my question is, how do we make enforceable this conversation on the grade change?
Well, Madam Chair, I thought that your number one sort of subsumed that, where you're requiring the project manager's contact information to be provided to the zoning administrator so that neighbors can contact if they have a need.
Yeah, the problem is that my
Making them meet, I don't think is enforceable, but having the neighbor be able to contact when there are issues with respect to the construction process, I think is.
Well, yeah, I mean, with enough imagination, anything's enforceable. But the problem with my condition is that my condition doesn't take effect until the issuance of the building permit. So they could wait until 1 hour before the issuance of the building permit and provide that information to the zoning administrator, the way I drafted it, right? And so the conversation that we're hoping will take place would be earlier than that, a fair bit earlier than that. So my condition, because I want my condition to be enforceable, I tied it to the building permit. But there would need to be some way to predate any expectation of meeting with the neighbors.
Mr. Melnick.
About the arborist, you're talking about a report, but we're not talking about, like, say the report gives recommendations, but we're not saying anything about enforceability of the recommendations.
Well, Madam Chair, to follow, the county has a policy of trying to preserve the tree cover. And so if the recommendations by the arborists are that these trees can be preserved, would they run afoul of the county's tree preservation, desire to preserve trees, would be the question. I would suggest that if the report says these trees should and can be preserved, and they don't, they have run afoul of the county's policy to preserve to the extent that they're. So we're putting a condition that you have an arborist look at them. I think that if the arborist says that this tree can be maintained, then they have to maintain it. That would be my view. That would be the enforcement. Because if there wasn't a county policy that made, and I don't know right off the top, but I know that it's more than aspirational.
Okay.
That's my belief. It is more than aspirational. I mean, so.
I just wasn't aware that there was, just once you have a report and the arborist says these trees can be saved, that they actually then have to be saved.
So maybe we could ask the staff about that.
I can't speak to what the tree preservation requirements are. I don't know what they are. And I would agree with your assessment. There's no guarantee that what is in the report is going to be consistent with what our requirements are or what our standards are, and I don't know what they are.
Well, I think what the neighbor was interested is in a review of whether the trees are in good condition and whether they can be protected during construction.
Yeah, I don't think I would support and this is why I want a short turnaround, right? Because if this doesn't pan out and we're hearing this again the next time, then the next time I wouldn't be inclined to approve it until I knew for us which trees are being preserved.
Sure.
And that would be part of the use permit.
In front of us.
So don't come back without that if you have to come back for further permission. But for now, I'm following the law of the case. You guys heard these tree complaints before, and you didn't put that in last time. And so I'm not sure that anything more than take a look at it, use your best judgment in good faith. I don't think it's reasonable to impose more than that tonight. That's my own personal view. So although I think Mr. Melnick is correct that it may not result in mandatory tree saving, although maybe Mr. Smith is correct that it does, I wouldn't be inclined to impose more than you have to submit a report, and we'll hope that good faith takes you the rest of the way.
Well, Madam Chair and Mr. Owen, there are landscape standards, and one, it seems to suggest, is that the preservation of the county's trees and tree canopy coverage has been identified as a top priority by the county board and its citizens. And those documents, this tree preservation policy, establish minimum standards and requirements both for landscape plans and installations. The information in these standards is not intended to replace, but rather to supplement other applicable ordinance and regulations within the county. So it sounds like there is some, and I haven't gotten into details, but it seems like it's part of a landscape plan that the preservation of preservable trees by virtue of an arborist report could be enforced. That's just right off the top, it seems like that. No, that's not. And we have certainly put conditions for landscaping into approvals many times, routinely almost.
Mm-hmm. Well, I think it's the pleasure of the board how tight you want to be on it. I think, oddly enough, on this one, I don't want to be as tight as maybe some of the rest of you do. But
it's a small site, and it's going to be difficult to save trees. But if we put a condition in that says this is important and we want it addressed, it doesn't necessarily mean that it can be done physically, right, but it should at least be flagged as a concern.
All right, Madam Chair, I'm going to make a motion.
Please.
I move that in case I move that in the case V-11271-17-UP2, the use permit request, that the Board of Zoning Appeals adopt the resolution in the staff report, except that in condition number 4, to use the date November 17th, 2018, rather than May 17th, 2018.
I mean, 17.
To use, so I've been corrected. The date I want to use is November 17, 2018.
No, it's 2017.
17, right. You're right, thank you.
17, 11, 17, 17.
Change the month without changing the year, yes. Okay, so the date I want to use, thank you very much, colleagues. Okay, the applicant shall obtain, so the condition number 4 would read, the applicant shall obtain a building permit to construct the structures permitted herein by November 17th, 2017, or the use permit shall be null and void.
Okay.
Moreover, to add an additional condition, applicants agree prior to the issuance of the building permit to provide to the zoning administrator a name, email address, and telephone number of a construction manager to receive inquiries from neighbors affected by construction. That's my motion.
And no trees.
I'm not making additional conditions yet. That's a base motion.
Can we have a second to this motion? Okay. Moved by Mr. Owen, seconded by Ms. Malice. Further discussion?
Madam Chair,
Ms. Malice.
I request unanimous consent to add condition number 6, which is the applicant shall retain an arborist to review conditions of the trees and make recommendations for tree preservation if appropriate.
How about a date?
Before issuance of building permit.
Okay. Is it?
Reading that out again.
Retain an arborist to review conditions of the conditions of the trees and make recommendations for tree preservation if appropriate.
Prior to the issuance of the building permit.
A use permit. I mean, a building.
Building permit. Is that an acceptable addition?
No objection.
Madam Chair, before I offer consent to that, I asked the zoning administrator, do you feel that's enforceable as stated?
Sorry, it would be basically showing evidence of retaining an arborist and having those recommendations provided before the permit is issued.
Yes.
Yeah, that's totally fine.
Okay. Do we all agree?
No objection.
Good. Any others?
I don't know how to phrase it.
What is it you want?
You know, the grade thing. I don't know what to do about that. Got nothing.
He's going to talk to him. May not be happy with them to get together. To the guy.
I got nothing more.
It appears that we have a motion as amended. All those in favor?
Aye.
Aye.
Aye. Thank you. Next item. Last item.
B-11272-17-UP-1 is a use permit request to permit a setback of 24 feet from the wall to the North Richmond Street right-of-way instead of 25 feet as required, and 20 feet from the window wells to the North Richmond Street right-of-way of 21 feet as required, and 8 feet from the wall to the rear property line instead of 10 feet as required, in the R10 zoning district and the premises known as 2629 North Richmond Street. And the staff recommendation is to adopt the attached resolution granting the use permit request with conditions.
Questions? Applicant?
Hi, my name is Seth Ballard. I'm actually the architect for Mr. Holmes, who was unable to be here today. We'll keep things very brief with the hour. I would like to thank staff for their help, and next time they give a recommendation to be first the next month, I think I might listen. But otherwise, we ended up here just because we had a couple of misunderstandings with the zoning of the property, one of which I did not understand, because most easements that I deal with, we don't actually have to have a setback from. So that's how we ended up in the situation where we had filed for a permit where the bays were designed deeper, which is mostly why we're here secondarily, so that we could have a garage that's wide enough for a car and some storage. So if you have any questions, I'd be happy to answer them. Otherwise, thank you for your time.
Questions? Looks like the other house.
Madam Chair,
Mr. Rowan.
I'm ready to make a motion.
Thank you.
I move that the Board of Zoning Appeals adopt the attached resolution approving the use permit V-11272-17-UP-1, subject to the conditions listed in the resolution.
Second.
Moved by Mr. Owen, seconded by Ms. Malice. All those in favor? Aye. Thank you.
Thank you for your
Thank you for your patience. Minutes.
Madam Chair,
Mr. Owen.
I circulated an email to the board earlier, a couple days ago, seems like, suggesting two changes to the minutes. The first was a change to the second paragraph on the first page of the minutes under item V-112-19-17-VA1 to better describe the piece of evidence we rejected. So I can read the paragraph, or if everyone feels like they read it.
No,
Staff has a copy.
Yes, I will agree to the changes that you suggested.
Everyone's cool with it?
Very
Okay.
much so.
And then in the next item, V-11220-17-UP-1, in the new condition number 5, I would suggest using the word concurrent instead of commensurate.
Right.
And I note for possible discussion that Ms. Malice's resolution used the word footings when she read it out, but the minutes refer to it as footers. And I don't know if there's a difference between footings and footers. There is a difference.
I believe so. I'd rather correct it.
So I'll just note that.
what's the difference between a footing and a footer?
I don't know, but I'd rather use whatever word you used.
Use whatever word I used. As far as changing the word commensurate to concurrent, while ordinarily you'd want all parties here when you're changing a resolution, but since it was clear in the discussion that I clarified, or I was asked to clarify that word while all the parties were here, I think it's appropriate to for clarity, to change that word to concurrent. Or is that?
Yes. You basically, when it was brought to your attention that you had said commensurate, you said you had misspoke.
I said I did not.
You didn't mean to. So the meaning of the motion was concurrent.
Everybody was aware that was the.
So is the zoning administrator suggesting that it might be safer to go with footings then, if that was what the original word was? Or has staff changed it to footers to save us from ourselves? Because that's the better word to use.
I don't know why it was changed. I don't know. I'd rather be consistent with whatever was actually said.
All right. So then my motion is to approve the minutes with the substitute paragraph that I circulated by email, and to change the word commensurate in item 5 where indicated to concurrent, and in that same item to change footers to footings.
Referencing the architect forum on the issue of footer versus footings, there's a number of different opinions, but it tends to be that footings are used by contractors or by architects, while footers are used, the term is used by contractors, and also that there's a regional difference. In some regions, they're referred to as footers. So,
About footing, how about footer/footing?
or put footings, footers.
Okay, so so let me remake my motion. I move that we approve the minutes subject to the substitution of the paragraph as described in the email. And in item 11220, subsequent for condition number 5 to replace commensurate with concurrent, and to have the rest of it read, the pouring of the footings, bracket, footers, close bracket.
Okay, cool. You have a second?
A second.
All those in favor?
Aye.
Abstaining because I was absent.
Oh, you're so lucky.
You're already gone.
No,
You wanted to come back for the footers discussion.
This is the latest in a long time. I'm trying to think.
Oh, motion to adjourn.
Second.